go live right now.
Great, thank you. Good morning, everyone. The convening of the Massachusetts Gaming Commission, because we are holding this on a virtual platform, I'll start with a roll call of my fellow commissioners. Good morning, Commissioner O'Brien.
Good morning, I'm here.
Good morning, Commissioner Hill.
Good morning. I'm here.
Great. Commissioner Skinner, good morning.
Good morning, I'm here.
And Commissioner Maynard.
Good morning, Madam Chair. I am here.
Excellent. Then we'll get started. Today is December 19th, 2022. It's a Monday morning, and we are beginning with public meeting number 414. Before I get started, I have a little bit of business to attend to. Earlier this month, ahead of taking up the applications for Category 1 and tethered Category 3 sports wagering licenses, Massachusetts Gaming Commission did hold public hearings intended for the public and stakeholders to offer any thoughts they had on the applications we received. We also have held open the ability to submit written comments on an ongoing basis and are continuing to receive input from stakeholders in this manner. To that point, we have received a number of public comments from members of the Springfield community relative to MGM Springfield's compliance with its host community agreement. That agreement was executed as part of the casino licensing process, and adherence to the terms of the host community agreement are a condition of licensure under Chapter 23K. However, that matter is not directly before the Commission today as we review the application which has been submitted for a license under Chapter 23N, the sports wagering law. We may and will, however, keep this issue in mind. If it becomes relevant to any of the factors we will evaluate as part of the sports wagering licensure process. As always, we appreciate and welcome the interest and input from members of the public relative to matters before the Commission. So now, turning to our agenda for today, before I turn to our General Counsel, I would like to make a few introductory remarks, some of which are familiar to all of you and those who have listened in on our earlier discussions. Today, as we begin our evaluation of these applications, we, as commissioners, are reminded of our principal responsibility to ensure the public confidence in the integrity of the gaming industry here in Massachusetts and the strict oversight of the gaming establishments and now sports wagering operators through rigorous regulation. We are reminded that the MGC's licensees will be held to the highest standards of compliance, including an obligation to maintain their integrity. As we have said in the past, the award of a gaming license in the Commonwealth is a peerless privilege, and our law requires gaming licensees to be held to those highest standards on a continuing basis. The MGC mission commits us to creating a fair, transparent, and participatory process that engenders the confidence of the public and participants. That process is to benefit the Commonwealth while minimizing potential or realized negative or unintended consequences. With that understanding, the MGC and all of its powers are created by statute. We must follow the process required by the legislature. To shed further light on that process, I turn now to General Counsel Grossman.
Thank you, Madam Chair, and good morning, everybody. Today and tomorrow, you will return to two applications of our current gaming licensees seeking a Category 1 license, which will offer the opportunity for retail sports wagering at their gaming establishments, as well as the opportunity to partner with up to 2 MGC licensed Category 3 online sports operators. The issuance of retail sportsbook licenses at the casinos is relatively complex because it spans Chapter 23K of the general laws regulating casino operators and Chapter 23N covering sports wagering. It is this complexity we must deal with over the next few days and the statutory scheme with which we must comply. Significantly, the timing of the full suitability investigation and determination are different under the two statutes. Chapter 23K required full suitability before licensure of the casino gaming operators. Chapter 23N offers a presumption of suitability to those licensees, although it is subject to further review as described in the regulations. However, for the mobile operators who have not gone through suitability the way casinos have, Chapter 23N directs a temporary license before full suitability. Currently, we're engaged in the public meeting process, which deals with the statutory presumptive granting of casino sportsbook licenses under Chapter 23N and the temporary licensure of mobile sports wagering licenses under Chapter 23N. Our proceeding today is not an adjudicatory hearing. If questions are raised as to suitability, such review would take place at a later time after a thorough investigation that would include an informed decision and determination of any individuals or entities which bear on an applicant's suitability, and after full consideration in a properly convened adjudicatory hearing. In the interim, an applicant may be deemed eligible to operate under a temporary license. And Chair Judd Stein, I believe you wish to conclude your opening remarks.
Thank you, Attorney Grossman. And thank you to my fellow commissioners again for your commitment to the MGC mission and for your thoughtfulness and diligence today and over the next several weeks as we evaluate these applications. As I have said for the last week or so, I feel very fortunate to serve with you, particularly as we work tirelessly to implement this new law with the public's interest in the forefront. And our last several months and months ahead have been demanding and will continue to be demanding on our MGC team. And as I've said, can only be described as a team of excellence. We're very grateful for the contribution each of you make individually and as collaborating colleagues. We thank you for your dedication as public servants, the sacrifices that you make, and commitment to the MGC mission. With that, let me give a brief overview of today's agenda. First, you will hear again from Attorney Grossman, who will review the statutory and regulatory framework that will help guide us as we evaluate the applications. Then, Blue Tarp Redevelopment, LLC, doing business as MGM Springfield, will resume its presentation for a Category 1 license using 205 CMR 218.06 subsection 3 as guidance. Commissioners, upon consideration of requested supplemental information, we will then resume our assessment of the quality of the components of the supplemented application and decide whether to move forward on a determination of the matter with Attorney Grossman's guidance. Subsequently, we anticipate that MGM's presentation of its application for a Category 3 license. After BetMGM's presentation, we'll hear from GLI, the IEB, and RSM relative to the technology, suitability, and finance components of the application. And that will lead us to a section-by-section analysis of the application during which the applicant will answer our questions. Staff members in our legal team, in addition to GLI, IEB, and RSM, will also be available to answer questions. And to ensure that we have ample time to reflect, finalize any personal notes memorializing our impressions, and follow up with any unanswered questions, we may break as needed after consideration each section or number of sections. Then after any further questions for purpose of review of the Category 3 application, I will seek from the group comments and a sense as to whether we have a consensus regarding the quality of the applicant's response to that section. Did the applicant not meet expectations relevant to the standard of review outlined by General Counsel Grossman? Did the applicant meet expectations, or did the applicant exceed expectations? Anytime during this public meeting, the Commission may determine that an executive session is required for us to fully review and evaluate certain information in the application as set forth in the agenda. And should we vote to go into executive session with the guidance of our legal counsel, at this time, it is anticipated the public session of this commission meeting will reconvene today at the conclusion of any such executive session. After our review of the application, we'll decide whether we wish to proceed with our determination process fully or in part, or defer that decision entirely to another day. So with that, again, let's turn back to item number 2 on the agenda and General Counsel Grossman. Thank you, Tom.
Thank you again, Madam Chair, and good morning, commissioners and all who are joining us here today. Of course, we are here, as the chair mentioned, so that the commission may continue to evaluate the application received for Category 1 sports wagering license from Blue Tarp Redevelopment, which is the licensee that operates MGM Springfield. Prior to resuming that review, however, it may be useful to reset the stage, walking through the legal provisions and principles that will inform the commission's decision-making. And with that, I'll just highlight a few provisions of the Massachusetts Sports Wagering Act, which has, of course, been enacted as Chapter 23N of the general laws. And then we will take a look at a number of sections of the Commission's recently adopted regulations. Of course, as always, questions and comments are invited along the way. With that, I'll start with Chapter 23N, and the first place to take a look at is Section 6B1, which says that the commission shall issue a Category 1 license to any holder of a gaming license, as defined in Section 2 of Chapter 23K, that meets the requirements of this chapter and the rules and regulations of the commission, provided, however, that any holder of a Category 1 license shall not be issued a Category 2 license. In the present matter, Blue Tarp Redevelopment is a holder of a gaming license under Chapter 23K. Accordingly, if it otherwise meets the requirements of Chapter 23N and 205 CMR that I'll discuss momentarily, then it shall be issued a Category 1 sports wagering operator license. Before we look at the Commission's regulations that govern the licensing process for a Category 1 applicant, we should discuss what a Category 1 sports wagering operator license is. And that term is defined in Chapter 23N, Section 3, to mean a license issued by the Commission that permits the operation of sports wagering in person at a gaming establishment, as defined in Section 2 of Chapter 23K, and through not more than 2 individually branded mobile applications or other digital platforms approved by the Commission, provided that the mobile applications and other digital platforms shall be qualified for and issued a Category 3 license. So if this applicant were to be awarded a Category 1 license, it would be authorized to operate an in-person retail sports wagering operation at MGM Springfield and through 2 mobile operations. This Category 1 license is the tool that enables the licensee to operate through those 2 mobile platforms. But remember, of course, that the entities that will actually run those mobile or digital platforms would themselves have to first obtain a Category 3 license. So now let's have a look at the Commission's rules and regulations that have to be met by the applicant in order to be issued a license. And the best place to begin here is 205 CMR 218, which, as you know, is the section that sets out the application requirements, standards, and procedures. The process itself has, of course, already begun. Here we've commenced the review. That was after an administrative sufficiency review was performed upon the submission of the suitability portions of the application, and then the Commission convened the public meeting that was referenced in order to receive public feedback on the Category 1 applications collectively. Momentarily, we'll walk through the factors and standards the Commission has set out for the award of a license, but prior to doing so, there are a few other provisions and principles that are important to keep in mind. First, the regulations provide that the Commission shall analyze the factors and considerations set out in the regulations, but need not do so in any particular order or give any individual factor any particular weight, and in fact can assign a factor no weight at all if deemed appropriate. Next, you'll recall that the regulations provide that the Commission may require or permit an applicant to provide additional information or documents as the Commission deems appropriate in its review of the application. So in evaluating the information provided in the application, as the Commission did previously, it may direct the applicant to provide updated or supplemental information, which we have done in this particular case. Of course, similarly, during the course of the evaluation, if the applicant observes that there is additional information that it still hasn't provided that may be of use, it may request an opportunity to do so. It's, of course, again, noteworthy that this review is being conducted as part of a regular public meeting under the open meeting law and not at an adjudicatory proceeding. And that means a number of things, one of which we've already discussed, and the other is that all deliberations must take place in public. and that, if necessary, the executive session provisions of Chapter 30A may be utilized. As it pertains to this instant matter, Section 21A7 of Chapter 30A allows the Commission to move into executive session to comply with or act under the authority of any general law. In the present situation, there is a general law that gives the Commission authority to move into executive session. Specifically, Section 6I of Chapter 23N provides that applications for operator licenses shall be public records under Section 10 of Chapter 66, provided, however, that trade secrets, competitively sensitive, or other proprietary information provided in the course of an application for an operator license under this chapter, the disclosure of which would place the applicant at a competitive disadvantage, may be withheld from disclosure under the public records law. In sum, if there is any specific information that the Commission would like to discuss, but that the applicant identifies as falling within that provision, and the Commission agrees, it may move into executive session to discuss that specific information. While the statutory provision in Chapter 23N relates to the public records law and not the open meeting law, to require that the subject information be discussed publicly would nullify the whole purpose of the provision, which is designed to protect such information. Accordingly, application of the executive session provision I referenced is appropriate in this instance. Finally, before moving into the factors themselves, it's also important to recall that any finding the Commission makes must be supported by substantial evidence. This term is defined as such evidence as a reasonable mind might accept as adequate to support a conclusion. So when making a determination as to whether there is support in the application to find that a specific factor has been satisfied or has not been satisfied, the Commission will have to ensure that there is substantial evidence in the record to support the conclusion. The one exception to this rule, of course, and an area that has a heightened standard, relates to the review of an applicant's suitability. By the terms of Section 215 of the regulations, any durable finding of suitability must be supported by clear and convincing evidence, not just substantial evidence, which is a lower standard. Our jurisprudence tells us that clear and convincing proof exists when the evidence induces in the mind of the fact finder, here being the Commission, a reasonable belief that the facts asserted are highly probably true, that the probability that they are true or exist is substantially greater than the probability that they are false or do not exist. And for evidence to be clear and convincing, it must be sufficient to convey a high degree of probability that the proposition to be proved is true, and it must be strong and positive and full, clear, and decisive. We'll come back to that in a minute, but those are the two general standards of review, if you will, that will be in play during this evaluation. Now, please allow me to lay out the factors included in Section 218. The factors are specifically in 218.06 subsection 5. Each factor, you'll recall, falls under the umbrella standard that the Commission included in the regulation, which directs that in determining whether to award a sports wagering operator license, the Commission will evaluate the application to determine whether a license award would benefit the Commonwealth. So that's the main standard that will have to be met in order to award a license. In reaching that conclusion, though, the Commission provided that it will consider the following factors. And of course, you'll recall that the application itself was designed so as to elicit information in these categories. Number one, the applicant's experience and expertise related to sports wagering. Number two, the economic impact and other benefits to the Commonwealth if the applicant is awarded a license. Number three, the applicant's proposed measures related to responsible gaming. Number four, a description of the applicant's willingness to foster racial, ethnic, and gender diversity, equity, and inclusion. Number five, the technology that the applicant intends to use in its operation. Number six, the suitability of the applicant and its qualifiers, and we will come back to this one momentarily. And number seven, any other appropriate factor in the Commission's discretion. So those are the factors that will be reviewed. And again, I'd just like to circle back to that suitability factor for a moment. You'll recall that the Commission adopted Section 215 of the regulations to govern suitability determinations. And it included provisions allowing for a durable finding of suitability, meaning the so-called final determination. And it also included a provision related to a preliminary finding of suitability. In the matter before you, you may choose to award a durable finding if you conclude that the applicant and each of its qualifiers has already demonstrated their suitability by clear and convincing proof by means of the review conducted under Chapter 23K at an adjudicatory proceeding, and that the applicant has maintained such suitability on an ongoing basis up to the present time. In that event, no preliminary finding need be entered, and this applicant could move right into durable finding territory. In support of that principle, I direct you to Section 6D of Chapter 23N, which says that in investigating the suitability of an applicant, the Commission may use information obtained from the applicant pursuant to Chapter 23K, Chapter 128A, Chapter 128C, or information from other jurisdictions where the applicant is authorized to conduct sports wagering. A preliminary finding may be entered for any category of applicant, including a Category 1 applicant. Recall that a Category 1 license shall be issued to a casino licensee, but only if it meets the requirements of Chapter 23N and 205 CMR. So it is not an automatic decision. So those are the factors that the Commission must consider in making a licensing decision here. As you work your way through the evaluation, though, it may become clear that a condition of licensure will be appropriate at a particular time. For example, you may find that the information relative to a particular factor is lacking. In that event, it does not necessarily mean that the applicant cannot be awarded a license. It may simply mean that the area may require to be supplemented with an appropriate condition. License conditions are described in Section 220 of the regulations, and you'll recall that there are a number of automatic conditions, like an obligation to obtain an operation certificate prior to commencing operations, and that an operator comply with Chapter 23N and the Commission's regulations. But there's also a provision that allows the Commission to impose any other condition that it determines are appropriate to secure the objectives of Chapter 23N and 205 CMR. As a practical matter, I might suggest that the Commission begin discussing any additional conditions as part of the review of each individual factor, as you have already done here. Then, once the Commission has made its way through all of the enumerated factors, but before any final decision is made as to whether to award a license, the Commission should shore up what those final conditions will be in the event that the Commission is inclined to award the license. Once that's done, the Commission may decide whether it will award the Category 1 license, determine that the applicant is eligible to receive a temporary license while a complete suitability assessment is performed, and that would be in the circumstance where a preliminary finding of suitability has been entered, or the Commission may deny the application for failure to meet the requirements of the regs or for having violated Section 6E or 9 of Chapter 23N. At that junction, a written decision will be prepared and issued commemorating the Commission's decision. Keep in mind, the award of a license does not mean that the licensee has the green light to commence operations. It simply means that they're eligible to work towards the award of an operation certificate, which is a prerequisite to conducting sports wagering operations. That process is described in Section 251 of the regulations and requires submission and approval of such things as the internal controls, including the House rules, and compliance with any conditions that may be imposed as part of this evaluation. With that, Madam Chair, I'll pause with that and see if there are any questions or turn it right back over to you.
Thank you, Todd. Questions for Todd at this juncture, commissioners? Okay. It's bringing up the document. So before we're turning now to Section 3 of the application of the agenda, and which we will now continue with the application review conducted at the Gaming Commission's public meeting number 407 on December 7th, 2022, submitted by Blue Tart Redevelopment. doing business as MGM Springfield for Category 1 sports wagering operator license. Excuse me. Notwithstanding our preliminary findings on subsections B and through E of the application, the applicant has indicated that not only addressed our specific request to supplement sections F and G, but also supplemented other sections of its application. At this juncture, I'd like to give the applicant the opportunity to address its supplemental application, and then we'll proceed with our review. Good morning.
Good morning, Chair. Jed Nozel on behalf of Blue Tarp Redevelopment and MGM Resorts International. If I can, before jumping in, just introduce the team that we have here today and also online for the live stream. First, of course, Chris Kelly, President and COO of MGM Springfield. We also have Arlen Carballo, Executive Director of Finance for MGM Springfield. Beth Ward, Director of Community Affairs for MGM Springfield. We have Dan Miller with us, Director of Client Compliance for MGM Springfield. We also have on the live stream, Danielle White, Vice President, Community Engagement for MGM Springfield. I'm also joined in the room here today by Pat Madamba, Senior Vice President and Legal Counsel for MGM Resorts International. I also am joined by Gus Kim, Vice President and Legal Counsel for MGM Springfield. In addition, we have Garrett Farnes, Director of Responsible Gaming for MGM Resorts International. We also have today with us Joshua Smith, Vice President, International Compliance for MGM Resorts International. And we also have joining us for purposes of the presentation and certainly any additional questions, Sarah Brennan from BetMGM, as well as Robin Rubis from BetMGM. So, Chair, the company appreciates the opportunity today to be back in front of the Commission to continue review of the Category 1 sports wagering application. And before I jump into the update, I want to turn it over to President Kelly for a few introductory remarks.
Well, thank you, Jed. And just a few quick comments. First, good morning and happy holidays to everyone that joins us. Thank you to all of our commissioners. Despite the improbable outcome of yesterday's game, this is a joyful time of the year, and we deeply appreciate the gift of your time. Would also like to offer special thanks to all of the support staff at the MGC that have assisted us along the way in getting us to this point, as well as to offer congratulations to the team at Encore Boston Harbor for recently receiving approval for their Category 1 license. And with that, we very much appreciate the opportunity to reconvene today, and we look forward to the discussion. And with that, I'll hand it back over to Jed.
Thanks, Chris. So as indicated earlier, MGM Springfield's updated and supplemented its application as requested by the Commission on December 7th, 2022, and as provided through the Commission's regulations allowing for such supplements. And again, I think this was recently commented on, Chair, notwithstanding the Commission's preliminary findings on sections B through E, we have gone back for completeness of the application and the record and supplemented some of these sections as well, but also focused on sections F and G as specifically requested. More specifically, we've updated the application based on the Commission's input at the previous hearing. We've incorporated some of the public presentation into the application from that date as well, again, for completeness. And we have also incorporated, as requested, specific information regarding BetMGM's platform to the extent that it pertains to MGM Springfield's retail application. This is very prominent, of course, in Section F, but there are also sections that we've added in that additional information to have in front of you one complete document. Just a few additional highlights. The MGM Springfield's application is precise in describing the relationship between MGM Springfield and BetMGM for the retail sportsbook, including that all final decisions regarding the sportsbook lie with Category 1 applicant that's in front of you today. We've provided a copy of the race and sports pool agreement that describes the retail services provided by BetMGM to MGM Springfield. This was also provided as part of BetMGM BetMGM's application as well. So turning with a little more specificity to category F, the technology section. This subsection has been supplemented based on information from BetMGM, as well as the company, based on feedback that we got at the December 7th hearing. We've added additional information regarding know your customer safeguards, the wager application process, monitoring and security, testing of the platform and kiosks. And I want to pause there for just a moment. We did have an opportunity also to go back and provide additional information regarding the certification of BetMGM's platform to the IEB, in specific Assistant Director Band, with copies of other state independent lab reports certifying the systems proposed here meet the applicable GLI standards as recognized in those other states. So turning briefly to Section G, we've supplemented the company's answers for a series of questions pertaining to background, compliance, and suitability based on, again, feedback from the commission as well as observations from other hearings. We, of course, relied on the IEB report as well as commission's outside financial consultant to verify that verified MGM Resorts International's financial suitability. In addition, we've updated certain answers to ensure consistency throughout different sections in response, in particular to Commissioner Maynard's questions in connection with Section G, essentially to include everyone in connection with suspension, revocation, and other actions against licenses held by Blue Tarp, as well as controlled by MGM Resorts International, and including in portions of Section G, its subsidiaries. As the commission approaches the review of suitability in connection with the Category 1 sports wagering applicant, and some of this repeats and is similar to what Attorney Grossman said, it should be done through the lens of the company's current suitability, including MGM Springfield is subject to the commission's continuing duty regulations as well, found at 205 CMR 115. I believe that this is what was contemplated under 23N, essentially by incorporating the ability to draw from the 23K process in order to provide the commission with the adequate information in order to make a Category 1 sports wagering license determination. And again, the fact that the company is and continues to be subject to the continuing duty regulations, which my read is that they are more extensive than even what the sports wagering application would require, I think should give comfort to the commission that the company certainly remains, by clear and convincing evidence, suitable. The company has diligently reported those requirements throughout time. The commission has knowledge of the company's compliance history through those reportings, as well as the commission's access to MGM Resorts International's Compliance Committee materials, including compliance binders. So we feel very comfortable on the history of compliance that's in front of the commission. Before I pause, I did want to also go back and address a specific question that was asked by Commissioner O'Brien regarding a lawsuit that was filed by Shaylin Brown against the company as well as its past leadership. And again, while the company is in a little bit of a constrained position in what it can speak about, especially when it comes to matters that may involve litigation strategy or privilege, the company can provide the commission with the procedural posture of that case, as well as its unequivocal denial of the allegations made by Ms. Brown, as well as what will happen next in that lawsuit. And while the company will briefly address that matter now, no adverse action has been taken against the company's license to bring this before the commission at this time. I think that was reflected earlier in the remarks regarding the process under which that would have to go through, and certainly be done to the extent that there's anything to look at through an adjudicatory proceeding. And I want to be very clear, there's no evidence, let alone substantial evidence, that has been presented to the commission that would call into question that there's nothing less than clear and convincing evidence regarding Blue Tarp and its qualifiers and the fact that they remain suitable. We're suitable, the company is suitable to be issued Category 1 sports betting operator licenses as required under Chapter 23N. With respect to the pending matter, it's helpful, I think, to the commission, though, to have a better understanding of the procedural posture of that case. And to that end, Ms. Brown filed a complaint with the MCAD in September of 2020, alleging discrimination based on race, gender, sexual harassment, and retaliation in violation of state and federal law. The company, under the MCAD rules, filed a position statement in November of 2020, and on August 22nd, 2022, the MCAD issued an investigative disposition finding that there is insufficient evidence to support a determination of probable cause to credit the allegations of the complaint with respect to all claims in the complaint. Accordingly, a sister agency to the commission with specific jurisdiction over discrimination matters has already substantively reviewed the bulk of Ms. Brown's claims and found no probable cause. As is the case in and under state and federal law, the EEOC did issue Ms. Brown a right to sue letter. And based on information and belief, we understand that Ms. Brown has filed a lawsuit against Blue Tarp and its former president, Mr. Mathis. Again, based on our knowledge and as of certainly today's hearing, the company has yet to be served with that complaint. So with that, I'm going to turn it over briefly to Attorney Kim just to address the specific allegations that have been made as it comes to the company's reporting requirements in connection with the its reports filed with the commission.
Thank you, Jed, and thank you, Chair, thank you, Commissioners, and thank you, staff. I echo Chris's sentiment of happy holidays to all, and I'm always grateful and appreciative of the fact that I can appear before you, knowing that the commissioners and the staff work diligently and very hard to make sure that everything is we're in compliance. I want to categorically state that both of the named defendants, MGM Springfield and Mr. Mathis, unequivocally deny that MGM Springfield filed any falsified reports with MGC or engaged in any unlawful discrimination, harassment, or retaliation. I just want to make sure that I underscore that we deny all allegations in the complaint. Thank you, Jen.
Right, and that's going to be core to the company's pleadings going forward. And I think as most of you know, what you can expect once the company is served with a complaint, we expect to move to dismiss that. Certainly, if it survives that level aspect of the litigation, we likely seek summary judgment. If it in fact goes to trial, we will vigorously defend ourselves at trial. We'll obviously keep the commission up to speed and informed as that litigation winds its way through the courts. And Chair, I think as this commission has recognized on many occasions, and certainly the company takes very seriously, that suitability is not static. It travels with the licensee. If there's any concerns with the conduct of a licensee at any point, the commission, first through the IEP, has ongoing authority in any matter to take steps based on the results of that investigation, and then bring any particular matter to the commission's attention. So again, in connection with allegations in again, our understanding, yet to be served civil suit that was previously found by the MCAD as having a lack of probable cause, don't provide anything to certainly question or certainly not disrupt the Category 1 suitability of MGM Springfield, its qualifiers, as well as making it eligible for this commission to move forward with that finding of suitability in connection with the granting of its sports wagering license. And again, I want to go back, and although we've already gone over this, certainly, and the commission has given its sense of satisfaction with the company's answers, and sort of wrapping up this part of our presentation is, in connection with diversity, equity, inclusions. MGM Springfield's workforce is over 50% minority based, and with the largest single concentration of team members coming from Springfield. And over 70% of the Springfield workforce identifies itself as diverse. And so with that, in covering sort of the areas where we wanted to supplement I believe the supplemented application provides substantial evidence for the commission to move forward, but we are here to answer any additional questions that the commission has, and we're happy to do so in order to facilitate your deliberations.
Thank you, Attorney Nozzle, and thank you, President Kelly. Attorney Kim, any additional comments now at this juncture? Attorney Nozzle, you're all set?
Yeah, we are. Thank you, Chair.
Okay, commissioners.
Madam Chair, before we move on, if I could just also point out as you go forward, and I'm assuming you are doing this, but the other aspect of the complaint in terms of the numbers that were submitted to the MGC, I am assuming and trust that you're continuing to provide any information that you have on that, as well as the discrimination challenges that were raised in that complaint.
Commissioner O'Brien, that's correct. And again, we deny those allegations, and we will keep the commission and answer any further questions that the IUB has regarding that. We're happy to engage in that process.
Thank you.
Okay. And so now, commissioners, at this time, I'd like for us
Madam
to
Chair?
Excuse me, yes.
Hi, I have a question just on the subject of the lawsuit.
Okay, we can address those now. That's fine. Thank you, Commissioner Skinner.
Well, so, and I'm happy to hold the question until a later time in the meeting, but just wondering, aside from the lawsuit, wondering in terms of the allegations that Commissioner O'Brien just highlighted, my question is, what is IUB's role in investigating those? Is there an intention for IUB to review those allegations and conduct its own internal investigation?
Commissioner Skinner, I'm going to have you hold that question, please, because it's addressing our internal operations right now. And if we could just, I'm hearing you that you're presenting that question. I don't want to put Director Lilios on the spot at this juncture. Director Lilios, we can see how you'd like to proceed on that, given that they have their own procedures that they must follow. All right, so let's get started in terms of the review of the supplemental application. Commissioner Skinner will put your question into parking lot, but we will return to it, okay? This time we're going to go through each section as we've done in the past, and I'll learn whether there is a consensus as to the quality of the section and whether it meets our expectations, as I said earlier, relative to the standard review set forth earlier by General Counsel Grossman. I do ask that each of us take a breath before we follow up on our questions so that we're not speaking over each other. I know there's a little feedback from me that sometimes we do that, and that makes it hard for everyone to both hear and concentrate. So I ask for that as we proceed. So I've got section B open, commissioners. There were some additions and clarifications to that section as well. Do we have any questions for the applicant?
So, Madam Chair, it would be helpful for me, given the breadth of the application, if the applicant could simply highlight what was added in the amended application rather than us doing this section by section without the assistance of the applicant.
Attorney Oso, are you able to do that, or is that?
Yes, Chair, I can walk.
Yeah,
I can walk you through sort of the sections essentially that that we had concentrated in updating. Again, section B1A, we had added again clarification regarding the roles and responsibilities between BetMGM and MGM Springfield. With MGM Springfield, it's Category 1 applicant being ultimately the having control over the sportsbook operations for retail. We also made some updates in section C, including C1C, C1G, C2D, C2E, And really, this was taking information that we had presented partly in our presentation to provide you with the most updated information to not change, but rather supplement those answers in question C, again, in our efforts to have one complete document in front of you. That continues on in incorporating some additional information from BetMGM in C2F and C2G, as well as C3I, again, with information from BetMGM as requested to incorporate into our application, C3J, C3L. Additional information in L was added from our presentation. D1C, excuse me, it was largely the same information that was presented. D2, B, C, and D, again, just to ensure consistency from what we and have a complete record in front of the commission on those, not changing any substance of those answers. We also incorporated additional information from that MGM into E2G, E2H. And again, I mentioned then jumping into sections F, F2, and F3, significant additional information regarding the technology portions, including know your customer, wager acceptance, monitoring of suspicious activity, testing, location of servers, in addition to information security and BetMGM's policy. And then again, we updated G, 3D, E, G, and H to ensure that those answers were comprehensive based on feedback that we got from the commission, as well as I mentioned earlier, updating section G4 to respond to Commissioner Maynard's questions about including everyone when it came to suspension or revocation records as well.
Madam Chair,
Yes.
could I have the attorney reiterate the changes or the amendments made to section E for us, please?
To which one? I'm sorry.
E as in Edward?
Yeah, and also if we could, I would like to be able to go section by section to have some order. So could we hold that and be prepared to look at E more precisely? Okay.
Yes.
That would be really helpful. So be prepared for that question, Mr. Nozel. So section B, for your any outstanding issues or outstanding questions, are they resolved for you on section B? Commissioner Maynard, it looks like you have a question.
No, shaking my head, no. I would say that I would reiterate that I believe that the applicant meets section B.
Thank you. No questions. Any questions or clarifications on B? Oh, okay, hearing none. Can I take your temperature as to whether we have a consensus that it met? We know that it had met our expectations before. There have been some clarifications. Does it continue to meet your expectations?
It met expectations for me, Madam Chair.
Thank you so much.
I would say the same.
Agreed.
Commissioner Skinner, thank you so much. So we can move on. Thank you. Now moving on to section C. I'm sorry for being a little bit less nimble here. The loading is just a little different on this one. Okay, on section C, there were some clarifications. If we had found that it met expectations before, do you have any questions for the applicant now? I have a question I didn't ask before, President Kelly and team. Might be a Daniel question. Am I right that the number of kiosks will be 18 now rather than 9?
That's correct.
Okay, and in terms of the a clarification, they are anticipated to all be on gaming floor now.
That is correct.
And just in terms of thinking about a hopeful rush should this license be awarded, you're all set in terms of they're being spaced for public safety purposes. It's not only with respect to security around minors, but also just lines, that kind of thing for the public to come in and be able to place their bets.
Yes, Lady Chair, there are several different locations throughout the casino floor, so they will be pretty well spread out. A higher concentration in the sports area, because that'll be the main viewing area, but they are across the entire floor.
Thank you. And then I think I saw that the clarification on the job description was made with respect to who's setting lines. And so I appreciated that. And it was actually, for me, much of this is a learning exercise. So thank you for that. Anything else on section C?
I just had one clarification question on C1A, your current numbers. You note that your tally in this answer includes anybody at Mass Mutual. Can you just give me the actual head count of who's at Mass Mutual?
I'm sorry. Hi, good morning, happy holidays. I don't have the exact number in front of me. I can get it in a couple of minutes.
Okay.
They average about 100 FTEs, hours worked. I'll have to get the head count though.
Okay, great. And you don't anticipate any maybe potential, like, I don't know what people call them, field people, ambassadors, whatever, that might be added over in that area?
The Mass Mutual area, not
Yeah.
at this moment.
Okay, thanks.
And to just follow up on, I think what's important for you folks put on the record, and I think you enhanced the answer with respect to the your continuing and successful partnership with the lottery. Did you add in about, I have the language that, I think you might have enhanced that. Might be wrong.
We did, Madam Chair. Again, it was to state that we do have a pre-existing relationship with the lottery. We have an agreement with them that includes that we offer Keno, the lottery from a point of sale perspective, and then also kiosks throughout the gaming establishment.
Thank you for that update. All right. Anything else? Okay, without any further questions, commissioners, we found that it met expectations. We got a few clarifiers in writing, and then today, do you continue to meet expectations?
Yes.
Thank you, Commissioner Skinner.
Madam Chair, it continues to meet expectations for me.
Thank you, Commissioner Hill.
Same.
Thank you, Commissioner O'Brien, and Commissioner Maynard. I see you nodding your head. Great, then we can continue on with section D. Do you have any additional questions with respect to section D? I'm not hearing any. I thought your response, your supplemental response in D3 was really comprehensive and very helpful for me. So thank you very much. Commissioner O'Brien?
No, just that, reiterating the commitment that they stated already in this regard in terms of keeping IB and us informed of any new information.
Okay, thank you so much. Anything else?
Madam Chair, I believe they met expectation for section D.
Thank you. Commissioner Maynard, you're in agreement?
Yes.
Thank you. Commissioner Skinner?
I'm in agreement.
Excellent. Commissioner O'Brien.
Same.
Okay, then we can move on to section E, please. Any questions or comments? Commissioner O'Brien? Do you have any
I'm
questions?
just looking through it. I need a minute.
Okay, excellent.
So Madam Chair, I had asked
Oh,
earlier
yes, thank you.
if they could reiterate to us the amendments that were made to E. You gave us a nice list, but you were going a little fast for my writing.
Sure. Thanks, Commissioner. Just quickly, I think we essentially, there are three areas in the application that essentially ask for my loose term sort of compliance type information. You have E3, A through F, which pertains to the applicant. You then got G3, which pertains to the applicant plus 5% owners of the applicant. And then you've got G4, which in that case, we answered those questions in the most complete way, including the applicant's owner, and then the owner's subsidiaries to make sure that we had covered everything there. So E3 is just was updated to reflect Blue Tarp's history here, noting previous actions, obviously by the commission, and then referring for further answers to the section. Actually, it should be to G3 for further information regarding fines and penalties.
Questions on E? I have a question. You've added and underscored, I think, in section B as well, that, and I appreciate this, that MGMS is excited to have engaged that MGM as a sports wagering service provider. However, all final decisions regarding marketing efforts regarding retail sports wagering will be in MGM's sole and absolute discretion. To the extent that you are awarded the opportunity to have a tethered online sports wagering partner, would that extend out? Would that extend to online sports wagering as well?
So the category 3 tethered applicant is a separate entity. I'll probably turn to Mr. Madamba to give you a little bit of background on the ownership of that. But because it's a separate entity, the retail establishment would not have control over the category 3 applicant. And I'm turning to Mr. Madamba to maybe add a little bit more. Because it's probably good to understand sort of the ownership structure of the category.
The answer to the question first would be generally no, because BetMGM is essentially a joint venture. It's a 50-50 joint venture between MGM Resorts International and Entain PLC, a London publicly listed company, so that our decisions are joint. We each have 50% control over it, as opposed to our retail operation where we have 100% control. And there's actually already a model in place for exercising ultimate control over the retail book with our service provider. Depending upon the jurisdiction, BetMGM plays a different role. For example, in Maryland, where they have mobile betting, we, MGM, are not the license holder. BetMGM is the license holder and runs that business in Maryland on the mobile side. However, at our sports book, in the retail side, we have, the employees are all ours, but they have a manager. They're permitted to have a manager and manage that book and make decisions over the retail book. On the other hand, in Las Vegas, in our retail operation, the statutory scheme for sports betting, retail sports betting, does not permit BetMGM, even though it's our service provider, to have control over those sports books. And we actually have, after a dialogue with the Gaming Control Board, with the Nevada Gaming Control Board, we have something called a super trader there. And it is an employee on our It's on our payroll. We have our own trading team.
I'm sorry, I hate to do this, but I don't have the best hearing, and for whatever reason, I'm having just a little bit of trouble following.
Yeah.
Sorry about that. Thanks.
Commissioner O'Brien, is this better?
Yes, thank you.
Okay, super.
In Nevada, BetMGM does not qualify for what's called a sports pool license there on the retail side. So we run those books with them as a service provider. And after a dialogue with the Nevada Gaming Control Board, we have what's called a super trader to demonstrate our ultimate control in the retail book. So it really depends upon the statutory scheme in a particular state. Here you have the tethered category 3. It will operate that skin, so it will operate the skin. We will operate the retail book with BetMGM as merely a service provider, as opposed to the operator of that retail book.
Thanks,
Is
Pat.
that all
I think I
helpful?
was focusing on the marketing efforts, and who would have sole and absolute discretion over marketing efforts of your tethered partners. The tethered partners, they only have access to an online sports wagering license through you, if you're awarded this license. So I guess my question is, would you extend out your discretion and control over marketing efforts that any tethered online sports wagering partner, would you have control over that?
Lady Chairs, especially as it relates to marketing in this section being responsible gaming, marketing, advertising. I think, part of what Pat was saying and others is, although we could not, have actual control over the tethered as a separate entity, having their own license, etc., we would still collaborate with them. And, clearly from a general compliance and responsible gaming, responsible advertising perspective, it's something I'm very much in charge of at the brick and mortar and retail perspective, and then would work with those such as Sarah Brennan at BetMGM if we felt that there was any messaging that wasn't to be distributed from a responsible gaming perspective. Again, I don't think it's necessarily a matter of decision-making and control as much as collaboration that would, provide the right kind of messaging. Clearly, it's also in our best interests on both sides to have messaging that collates with each other.
We would absolutely expect them to be compliant, and through our interest in the joint venture would exercise that interest to ensure they're compliant. And I can't imagine that our partner in Tane wouldn't want them to be compliant either. So, that's, while it's 50-50, both of the owners would absolutely require them to be compliant.
Thank you for that clarification. Sorry if I wasn't clear that on the focus on marketing. It's just that that's the statement that is in section E, E2A, and it was in section B earlier. So, my concern was that it only related to the retail. Okay, any other questions for section E?
Madam Chair, I now feel that they met expectations for section E.
Okay, thank you very much.
So, Madam Chair, I'm actually curious to reserve my judgment on this until we get down to G in suitability and some of the discussion of NTANE.
Okay, Commissioner Skinner?
I feel the same, Madam Chair, and that's with respect to sections E, F, and G. And I don't want to go back into the discussion that we had when we were last, when this applicant was last before us relative to operator versus service provider. But I think, BetMGM is very significantly intertwined with the category 1 retail operations, notwithstanding the fact that they're a service provider. So I'm struggling a little bit in terms of how we can consider a category 1 license for MGM Springfield without reviewing BetMGM's application at this point, particularly given some of the recent disclosures that have been made and the recent disciplinary actions that have been taken against MGM. So I'm looking for some assistance, some guidance as to how to get my head wrapped around how we move forward with this application review, separate and apart from BetMGM.
Yeah, Commissioner Skinner, let me give that a try. First, again, BetMGM and its 50% owner Entain are not a qualifier for MGM Springfield. They are a service provider. They're a vendor. And if I reach back and think about this from the perspective of the Category 1 gaming applicants, it's not unlike having a question about who is going to run the Category 1's slot machines and who is going to, or do we have confidence in the integrity of who is going to run the MGM Springfield slot machines. It's a service provider. It's something that you will continue to retain jurisdiction and certainly have to have a level of confidence in once we get to the operation certificate process. And it's something that you'll have to be comfortable with as the vendor for MGM Springfield in connection with sports betting. So that's the way that I'm thinking about this. We can't review or certainly the ownership of or half the ownership of MGM's suitability here in connection with our application. That may be a question you have in connection with your review of BetMGM in connection with its Category 3 license, where it is coming before you as a qualifier.
Director Lilios, you want to add into Attorney Nosel's remarks?
Just that service provider or vendor model that he's described is consistent with our regulations and consistent with the 23N scheme that identifies operators with MGM Springfield being the operator of the retail establishment, and then the regulations going on to define vendors. So for purposes of the retail launch anticipated next month, we have treated BetMGM as a sports wagering vendor and are in the process of collecting the materials required by regulation for the temporary licensing of them that would permit the launch, whereas we've treated MGM Springfield obviously as the gaming licensee with the presumption of being the operator for the Category 1 sports wagering license. So I hope that helps, but happy to try to offer more if needed.
Director Lilios, for the record on IEB's report, have you any concerns with respect to the suitability of MGM Spring?
We've filed our report. We are constantly getting updates from each of the three properties, and there is no information to disturb the finding of suitability on the report that, as presented in the report now. Suitability is ongoing. We do continue to get disclosures. We investigate as appropriate, but I'm not bringing I have no information to bring forward to you that would cause any recommendation or concerns to disturb the finding of suitability.
Thank you. And General Counsel Grossman, we've heard from their attorney. I'd love to hear from ours. Thank you.
Madam Chair, I have a question for Lilios, please, if you don't mind. Before we move on to Todd.
I'm sorry.
I have a question for Director Lilios, if you don't mind, before
thank you.
Todd, please. Director Lilios, is there an investigation or would BetMGM have to be found suitable as a vendor before they can commence the retail operations at MGM Springfield?
As a vendor, the commission has promulgated regulations for temporary vendor licenses. They are reliant on attestations for the temporary piece, with full suitability investigations to occur subsequent.
And so what's the process by which the commission will review that information?
Like occupational licenses, the vendor, and like the vendor licenses on the gaming side, those licenses are issued on the IEB's findings. So the individual vendors would not come before the commission, but certainly there's a reporting component that the IEB anticipates, keeping you apprised of.
And what is the timing in that in terms, so assuming that MGM is granted a Category 1 license today, with the understanding that they are collaborating closely with BetMGM, just to provide a service so that they can operate the retail sports book. What's the timing in terms of the review of BetMGM as a vendor?
Our licensing division is working hard to get all of the required attestations from both the operator and the vendors before the retail launch. So those documents are incoming now, and the licensing division and the IEB are aware of the vendors that will be required for the retail launch. So those are pieces that we're all working hard on, and, the IEB will review the attestations. But that the commission determined to proceed on the attestations in order to enable the launch with the suitability invests to be performed post-launch.
So we'd be relying on the attestations alone. But
I'm
then,
sorry, Commissioner Skinner.
aside from information that,
I'm just going to interrupt, please, because I'd like to have, before we continue discussing BetMGM and its process, I want to get clarification from General Counsel Grossman, because right now that's not the matter before us, and so I want to be careful.
I'm discussing BetMGM as a vendor to MGM. That's what I'm doing. I have questions relative to BetMGM as a vendor to MGM Springfield, whose application we are reviewing right now.
Okay, thank you. Continue, Commissioner Skinner.
Thank you. So, Director Lilios, we will be relying on the attestations alone for the vendors, despite any information that may come to us in terms of a disclosure or in terms of the media. What are we doing with that information that we have gathered and that has been disclosed to us? Are we to ignore that information and instead rely exclusively on the attestation?
No,
I'm trying to understand how that.
No, I know there's a lot of moving parts here for sure. And certainly as we review MGM for the operator license, and you have the report on MGM in front of you, and Senior Enforcement Counsel Kathleen Kramer is going to summarize that report for you later today. The 23N contemplates that, if we identify a significant issue in conjunction, with one part of 23N, an operator license, it's not ignored on a vendor license. And 23N also contemplates the same thing with 23K, right? We can rely on 23K. We don't have to put blinders on. But generally, the process that you're utilizing for both the operator and the vendor licenses now are, significantly on self-disclosures, and some of the issues that we have seen in the self-disclosures and in other information that has come our way may require some review, some investigation, if you will. That is not something that the IEB has had the opportunity to do at this point. But you have regulations that contemplate that.
Okay, thank you. It's still not clear to me, but I guess maybe it will come clearer as we proceed in the discussion.
Perhaps now we'll turn to General Counsel Grossman, who will add further clarity for you, Commissioner Skinner.
I'll certainly try. I do think I would note that it's important, of course, to get all the commissioners the information that they'd like in order to make a reasoned, responsible decision for themselves. And so we should certainly make efforts to do so.
General Counsel, do you, in what way do we do that?
Well, I was just going to say, though, in the context of this specific question, it's important to remember, I think, that service providers can be moved in and out. Though there is one identified today as part of the initial rollout, there's no guarantee that that will be the service provider in perpetuity. It's in general a contractual relationship, if I understand this particular situation correctly. So I think it is helpful to focus on the applicant before us, but it's also important to understand what services this particular provider will be providing and what the parameters of those services are going to be. So you can offer a holistic review of the entire application. So it's not irrelevant by any stretch to the consideration as to Entain or BetMGM or any of that, though they are in this context a vendor. So some of the issues that may surround them, good or bad or otherwise, are properly considered in the context of their own application. But I also think, and I'm hedging a little bit on what I'm saying, that it is important to make sure that everyone understands the dynamics of the relationship between the parties. So to the extent there is information about the nature of the relationship that would be helpful to move forward on this particular information, then I think that would certainly be relevant here.
Chair, if I can just add one more comment.
After you, Mr. Nozzle.
Yeah, thank you. I appreciate it, Chair. MGM Springfield and MGM Resorts International and all of the qualifiers that are in front of you, their suitability stands on its own. They are suitable, and the commission can move forward with this application based on that existing suitability of the applicant and its qualifiers. And that's what's called for in connection with the review under the regulations, as well as what's called for in the application.
Thank you. Commissioner Maynard.
Madam Chair, I just wanted to answer your initial question. I believe this section has been met.
And we're still on E. Thank you.
So I think, Madam Chair, if I could just chime in, I think notwithstanding, the veracity of what Attorney Nozzle just said, we also have before us the question of whether anything has been raised substantially that would call into question that finding. And I'm not suggesting that it is, but I think part of what Commissioner Skinny may be asking and what I'm asking is because they're so integrally intertwined, the question is anything that we see in connection with BetMGM going to, raise the specter of anything with MGM? I don't see it at this point, but I think there's sufficient questions that my question on resolution would be, it would seem like some of the details of the relationship between BetMGM as a vendor and MGM as the licensee might be something we would talk about in executive session, because it might be competitive disadvantage for them to openly discuss that relationship in this forum. And would that possibly answer some of the questions that Commissioner Skinner has going forward on this application?
And in particular, just to that point, what I'm struggling with, and I understand that MGM Springfield will stand on their own as an existing Category 1 gaming operator and as a Category 1 sports wagering operator. But by granting that license to operate the sports book at the retail level, are we saying yes, okay to BetMGM when we haven't reviewed their application?
No.
Even as a vendor, right? Are we saying we are okay with MGM Springfield moving forward with BetMGM operating their sports book?
Commissioner Skinner, I'm going to present my challenge for you, and maybe you can help resolve it. A Category 3 applicant that's tethered, our word, to a Category 1 can't go forward without having a Category 1 partner. So I really do see this as a condition precedent. If we're going to assess Category 1 applicants, we sort of have to do it with the idea that if it turns out their partners have problems, then they're going to have to find a different partner or a different vendor or a different service provider. But I do think that the only way I can think about it is that this is a Category 1 application. And of course, they were very transparent, and we wanted that as to who they are proposing. We have the applicant from the tethered partners. They're explaining which is really helpful in the application, all the services that will be provided, and they are in response to our application questions and in response to our regulatory provisions. But I don't think we can, and this is where I'm asking for help, I don't think we could not make a decision on the Category 1 application and then just say, well, let's see how their partners do first, because I don't feel that any quote unquote partner has, lack of a better word, standing to come forward with us. Can you help me out, Councilor Grossman? Am I thinking about this too simplistically?
Let me pick up on that theme that you were just working off of. As I mentioned in my remarks, the award of the Category 1 sports wagering license simply opens the door to the Category 1 licensee to being able to operate online or mobile operations through Category 3 operators. And so it's a two-step process. You would want to make sure that the Category 1 applicant has satisfied all of the factors, including suitability on its own, and those who, which includes, of course, those who it associates itself with. But the Category 3 reviews should also stand on their own. And as the chair just mentioned, if one of them does not meet the standards that are set out in the statute and the regulations, then the commission could essentially say no to that particular applicant, in which case the Category 1 operator would have to find someone else. So I think they are separate evaluations, but it's also, I think, important, and I just want to make sure I'm understanding all the issues correctly. The category in this case, and it was also true of the last one we reviewed for Wynn Resorts, that it just so happens that one of the Category 3 operators will also provide certain services to the Category 1 retail operation. So it is certainly relevant to understand the services they will perform in their capacity as a vendor, which is different from the services they will perform as they stand on their own as a Category 3 licensee. So even though it's the same entity, they're really doing two separate things.
Right.
And so you want to really make sure that we're focusing on the services they will provide in the context of the Category 1 license here. And then we will review them independently on their own as a Category 3 applicant. But I do, Commissioner Skinner, to your point, there is certainly overlap there, and I think we need to recognize that. So if there are certain questions out there, they're not necessarily irrelevant here, but it's just important, I think, to bear in mind this review is of MGM Springfield and Blue Tarp redevelopment specifically.
So,
I appreciate that, and it is coming into focus a little bit. I'm just, I'll end with this. I have a hard time imagining a scenario where we have different concerns about that MGM as a vendor than we would as a Category 3 tethered applicant. I think all of the issues that we'd be concerned about in connection with their Category 3 application, they're present and very much an issue in their role as a vendor for MGM Springfield.
so I'm just going to interject now. One, I want to make sure that there's no, I'm hearing we, the word we, and I want to be very careful that there hasn't been any, there's no decision on that MGM. There's no assessment that's gone on as a commission. So to the extent that I don't want there to be a suggestion that there's an assignment or an evaluation of that MGM that's already proceeded or that there's conclusions that have been made. I think that's fair. I think we all agree with that. Commissioner Skinner, I know that you're thinking about something. I know Commissioner O'Brien's maybe thinking about something, Commissioner Hill, Commissioner Maynard, but I know that as a body, we haven't discussed these. So
correct. And thank you for that clarification.
Thank you. So with that said, what I'm not hearing is a consensus on sections E and perhaps not F and G, although there might be perhaps a majority or something close to it. But I think for taking the temperature, that's not sufficient right now for moving ahead. I am hearing Commissioner O'Brien say that there might be issues, and again, disclosures that Director Lilios said that they, our licensees do continue to make the proper disclosures as they do throughout, their ongoing obligation as a 23K licensee. Am I correct that you feel that we need to digest some matters, Commissioner O'Brien, in an executive session if they are appropriate?
Yes, that's a fair statement.
Commissioner Skinner, would that help you as well?
Yes, Madam Chair.
Thanks. So,
Madam Chair,
Commissioner Hill.
so let me be clear as we move forward. It was my understanding from an earlier comment made from Commissioner O'Brien that before we would address E, that she would like to hear from section F and G before we made a comment. And as we've been moving over the last week, we've gone through those sections. And as we have had questions about any possible executive session questions, we put them out there for Todd to take a list. And then we vote at the end to go into an executive session to address those.
Yes.
So I'm recommendation that we address F and G as we have, see if there's any questions, and then we can put a list together. Thank you, Madam Chair.
Excellent. I'm presuming that maybe the executive session will address them, but in terms of E, we'll put that to the side. Section F. There was an enhanced and fulsome response to section F. Are there individual questions for Mr. Nozel or the applicant at this time with respect to section F? I'm seeing none. Okay, do we find that section F meets expectations?
I'll speak as one commissioner. Yes, I believe it does meet expectations.
Commissioner O'Brien?
Same. I think F meets expectations for me.
Commissioner Maynard?
I appreciate the supplement, and yes, it meets expectations.
Commissioner Skinner?
I think it meets expectations. Again, just getting my head wrapped around the fact that we're only dealing with MGM as the applicant right now.
Okay, and I feel it meets expectations. I thought it was a very fulsome response. Thank you, for the clarification to the applicant. Moving then on to section G. Commissioner O'Brien, do you have questions that you'd like to raise in this forum? Oh, you're on mute, so sorry.
Sorry about that. I'm trying to go back and find it. I believe there were a couple disclosures about recent fines that probably are, and maybe not, maybe MGM's fine talking about them in this forum, but whether there might be more detail to the fixes that had to go into place or how those happened, whether that goes in any competitive disadvantage. I would ask MGM to give me their thoughts on that.
I'm sorry, Commissioner O'Brien, what question
Which matter?
are you speaking to right now?
I believe when you were going through the lists of the licensing history and any dispositions or fines, I believe, wasn't there a recent fine on MGM? Was it out of Maryland?
That is a BetMGM matter on their mobile piece, and they are the holder of that license. That license they operate.
That was not out of the land-based, out of MGM?
That's correct.
Okay.
Any other questions, commissioners, for the applicant in this forum? Okay. Given that we have at least, I know, two who suggested that for both, I think Commissioner Skinner, I know Commissioner O'Brien mentioned G before. Commissioner Skinner, do you feel it's met expectations, or are you looking for the executive session for clarity?
Again, I would be grateful for the executive session for clarity on portions of the response to E, F, and G, but again, as it relates to BetMGM and the relationship between BetMGM and MGM Springfield, particularly around the technology piece. So I don't know how we reconcile that. I'm being told that there are two different applications, and I understand that.
Sorry, Chair, if I can sort of come back to that. As the technology piece, I think for section F, are we through that piece? My understanding, the outstanding issues were on section E, 3A through F, as well as, I guess, in connection with suitability questions in section G3 and G4. And I do have to just say, in fairness to this particular proceeding, that your questions in the application ask for certain information pertaining to, in section E, 3A through F, the applicant, section G3, the applicant plus its 5% owners, and then section G4, again, the applicant and a term key persons. We have answered thoroughly on all of the information that is before you as requested in the application for anything having to do with compliance or suitability. And again, coming back to the fact that MGM Springfield and its qualifiers are currently suitable under Chapter 23K and are under heightened reporting requirements, well beyond what this application is required to provide regarding its history of compliance. There is more than substantial evidence. In fact, there's substantial evidence that we have maintained by clear and convincing evidence the suitability of the company. So we're happy to go into executive session and answer additional questions about what the commission may want to understand further. But I do think we have answered everything that the application has, and you have a complete record in front of you in order to grant the Category 1 sports wagering license as required under Chapter 23N.
And just one other comment on, I just want to make one other comment on compliance, which is the question is actually geared towards the applicant, which is MGM Springfield, and its owners, which would be MGM Resorts International. And we answered that question. But on a quarterly basis, we routinely file with the IEB our compliance committee binder. We have an independent compliance committee that has quarterly meetings. all of our subsidiaries outside of that chain, because we have, I don't know the exact number, probably 100+ subsidiaries. We report up through this compliance process, all of our subsidiaries, litigation, regulatory matters, a whole host of different things. And we actually share that particular binder, this very same binder that our MGM Resorts International Compliance Committee gets. We share that with our Massachusetts regulator, you, as well as regulators in our other jurisdictions. So we've been nothing but transparent on compliance, and it's far broader on a periodic basis every quarter, far broader than the questions in the application.
General Counsel Grossman, do you want to add to that piece?
Yeah, I guess I would just reiterate some of the thoughts I set out before, which is essentially, in this case, of course, it's helpful that the advocate is of the belief that they have satisfied all of the requirements. That's helpful. But ultimately, it's up to the commission, the decision makers, as to whether all of the elements have been satisfied by substantial evidence. And to the extent that a commissioner feels like further information would be useful on any of those points, they're certainly within their rights to request that. Ultimately, it's up to the commission as a whole to decide whether there's further information that has to be elicited, and we can do that if done precisely in executive session. So we'd need to exactly identify what pieces of information we would like to talk about in executive session, and to the extent that that information might help any commissioner or commissioners reach a decision on whether the factors have been satisfied, then it's entirely appropriate in this case. But
So
again, we do need to be
pause
very
that?
precise.
Yes, and that was, so Commissioner Skinner, you mentioned just now, there had been, I thought, a consensus on section F, but you just raised an issue, and you raised the issue of technology and why you might want to go to executive session to address issues of technology. I'd love it if you could explain that to the extent that you're comfortable in this forum, to get guidance from Councillor Grossman to see if it would be appropriate for executive session. Otherwise, the forum that we're in is the appropriate forum to discuss it.
Madam Chair, if we could take a 5 to 10 minute break so I can consult with Councillor Grossman offline, please.
Okay, and if I can turn to Commissioner O'Brien, you also had asked for an executive session. Is that still an outstanding request?
So the question that I have is, what I am struggling with is not so much the vendor licensee distinction. It is that it appears to move forward even as the Cat 1 licensee, that the Entain 50% ownership with MGM in BetMGM is integrally intertwined with the operations in this particular application. And it kind of goes into a number of different sections, responsible gaming, technology being two of the most obvious. So I would like a little more information about exactly how that works in terms of control of advertising, responsible gaming, et cetera. That's what I'm struggling with, where we've had some conversation with it publicly, and maybe we can have more in this public forum, but it would seem to me that if there was a more candid expression of exactly what the control relationship was, in particularly when it came to the advertising marketing RG space, that might be the more appropriate forum to have a fulsome discussion to answer my questions or get information. We can try it in the public forum, but I think we've exhausted that.
And so and you're referring to my earlier question.
Yes.
And the response that was given in the public forum. So perhaps there's some competitive disadvantage issue
Yeah.
there that might provide more insight. Okay. Right. Councilor Grossman, there's a request for Commissioner Skinner to speak with you. Commissioner Maynard or Commissioner Hill, do you have any thoughts on either proposal, or do you have further questions that you'd like resolved either in this forum or in an executive session?
I don't have any further questions regarding this application, Madam Chair. I am actually ready to move forward with a vote. However, out of respect to my two commissioners who have a further question, I obviously would move to go into executive session. In my mind, we have addressed what we needed to do regarding the vendor question, in my mind. I know that a couple others may not agree with that. I've always looked at this as a category 1 application. And if we didn't have any category 3s out there via legislation, we would be looking at this application as a category 1 and this other issue as a vendor. We've discussed this many, many times. I've gone back and forth, but this is how I've ended up, and this is how I would like to move forward. So at this time, no, I have no questions, but out of respect, I would move into an executive session so my fellow commissioners can hopefully get their questions answered so we can move this forward. Thank you, Madam Chair.
Thank you, Commissioner. Commissioner Maynard?
I learned a long time ago that legal fictions are a part and parcel of what we have to deal with as governing bodies and as attorneys, which I know there are 4 on this commission. And seeing this as a category 1, although there are some blurred lines, this is a category 1 application. I have no further questions. As Attorney Nozel rightfully pointed out, Section G was supplemented. It went above and beyond, and in fact, these questions on the application were very broad and very expansive. I have no further questions, but like Commissioner Hill, I hear 2 of my fellow commissioners who want additional information answered. I would vote to go into executive session, though I do not expect to have any questions during that executive session.
And I'm in agreement with both of my fellow commissioners, Commissioner Hill and Commissioner Maynard. I want to make sure that all of us are comfortable with all questions answered, provided that the executive session is a valid venue to answer those questions. I would support that as well. So we'll take it's now 11:45. To the applicant, again, first I should say happy holidays. I regret not starting the day with that. Although I know it is a very a special season for so many, and I think probably I just went to work. So thank you for that reminder, and also for the patience that you've exercised as we do our thorough vetting of all the applications. We'll return in 10 minutes, so that puts us just before the noon time, and hopefully Commissioner Skinner, you and Councilor Grossman can connect, and then Attorney Grossman, if you can think about Commissioner O'Brien's request as well. We'll return in 10 minutes. Thank you, everyone. Thank you, Dave.
All set.
Trying to make sure I don't knock out power here, Commissioner Hill.
So all I can say is, Jordan, I wish I had some of the heat that's trapped in your office today. Because it is not warm in here right now.
I mean, you want somebody to look at that for you because
We may, at the lunch break, I may have somebody, it's not horrible, but it's not warm, that's for sure.
So
Hill
work
has-
from my office. I'm serious. I mean,
No, it's not that bad, but it's enough that like gloves wouldn't be bad once in a while.
so in my home office, Commissioner O'Brien, there's my radiator. This is actually a radiator cover. My radiator is right here. So I'm very warm and toasty right now,
No matter where you go.
no matter where I go.
Yeah, I have all sorts of aids at home, you know, space heaters, electric blankets, that sort of thing, but. Sometimes you never know if those are Pavlovian, you know, they make you feel like you can control your office, but you really can't. Just see if you feel better about it.
The most entertaining thing about my office was there's 2 units in it, right? One unit was offsetting the other unit for
Yeah.
a long time. And then I think we finally got that fixed.
When I was in the AG's office, they gave us the thermostats. They didn't really work. But if you lifted the grate out by the window in the actual vent, you could turn the knob manually and adjust exactly how much was coming in your office, which through the whole reno never changed.
You know what I've noticed, Eileen, you were talking about the heat and the cold. Boy, there's been a lot of wind that we've never had in the past. As much wind as we have in the past. Again, I can only speak for the North Shore, but boy, it makes it cold when that wind's blowing.
Yeah,
And
there's
you-
actually somebody a block away, you know, people put their basketball hoops right on the edge on the street.
Yeah,
And it had been there for years. And it actually went over and crashed the glass survived, but the actual hoop in the front was destroyed.
Mm.
One of the last times everything blew through.
I guess the end of this week's gonna be windy, rainy, snowy.
Mm-hmm.
Typical New England.
Okay. All right, so we are reconvening Massachusetts Gaming Commission meeting number 14. Because we are holding this meeting virtually, I'll do a roll call. Good afternoon, Commissioner O'Brien.
Good afternoon. I am here.
Commissioner Hill, good afternoon.
Good afternoon, I'm here.
Good afternoon, Commissioner Skinner.
Afternoon, I'm here.
Commissioner Maynard, good afternoon.
Good afternoon, Madam Chair. I'm here.
Excellent. Okay. So I'll turn to Attorney Grossman.
Thank you, Madam Chair. If I may, I believe the best approach at this point would be to ask Commissioner Skinner to inquire of the applicant relative to a couple of issues. And it may be that it would be able to answer the questions in public. And if that is the case, then that may resolve the issues relative to this applicant. And we could move on from there. If the applicant is unable to answer these questions in public, it seems to me that it would meet the standard under section 6I for purposes of going into executive session to inquire further. But I think it's important that we ask these questions in public first. Certainly, and then we can move on to Commissioner O'Brien's question, which I think we've already established cannot be answered in public, but we just want to make sure we refine the exact issue and then ensure that it meets the standard.
So if I could, there was a question that the chair had asked earlier. And I went back again and I looked at the application again in terms of the advertising, marketing control. And I'm satisfied with, for this applicant, what's in there. And so I'm not going to need executive session on that particular point. So I defer to Commissioner Skinner's questions.
That's encouraging, Commissioner O'Brien, because I suspect that I will get there after I ask my question. To the MGM folks, what is the relationship between the applicant and BetMGM with respect to the provision of promotional advertising, including risk-free advertising?
Want to go and take that, Dan?
I'm gonna you
Yeah.
take up issue.
Sure. So the retail promotions are those that would be in our control, if that helps Commissioner Skinner. So the types of promotions, that type of promotion or any other type of promotion ultimately would be something that we would decide whether it was appropriate or not to offer at in this particular market.
I didn't hear that last part. I'm sorry.
Sure, I'm so sorry. And good to see you. What's offered in the retail book ultimately is MGM's decision. So whether it be those types of promotions or any others, we would have the ultimate decision as to whether or not to offer that promotion or any other type of promotion in the retail book.
Okay. That's helpful. Thank you. My second question is, what is the relationship between the applicant and BetMGM relative to the maintenance of patron data?
patron data. Okay, I couldn't quite hear you. Thank you.
There is certain data that is shared back and forth with BetMGM, just as you would share data with other service providers where you're doing account creation and what have you.
So Commissioner Skinner, anybody, for example, that is an MGM Rewards member already, we had that information at MGM Springfield and our greater parent MGM Resorts International on our servers. We're not then sharing information with BetMGM from a perspective of them going after.
Here, let me help. Okay. There is sharing in terms of, if you're asking about, for example, system security, we share information, essentially information that we share one way, they share information with us the other way, but it's contained on either their server or our server, so that we are responsible for the security on our data, on our servers, and that stays within the MGM environment, and anything that's on their servers is the responsibility of BetMGM and affiliates of BetMGM. But our environment stays secure.
As a final piece, Commissioner Skinner, what I might turn you towards is a diagram that we supplemented. It would be page 374 of the application that shows both the separation and connection of the data systems.
But again, our environment is contained within the MGM. We're in control of our environment, if that's what you're asking.
So let me ask you a different question, slightly different question. So does BetMGM have access to MGM patron data? I guess is MGM patron data, does it all sort of get funneled through, and excuse my terminology, funneled through MGM, the parent company? Does it get funneled through there, and therefore, through that process, does BetMGM have access to the MGM patron data?
Doesn't have full access to the patron data, and it doesn't go into our system to get that data. We share certain data with them to facilitate the creation of accounts.
Mm-hmm.
We share it's probably shown on that. I haven't seen the diagram,
right?
But it's probably shown on the diagram how it's populated, but it's for purposes of facilitating the opening of an account on the mobile system.
Okay.
But it's not. But they don't go into our environment to get the data.
Right.
And it's just on the mobile operations. It's not for retail purposes.
We might ask them for information that would be exclusive to them if we're populating someone on the retail side.
I'm sorry, could you
so there's a lot of crossover, I'll put it that way, between a retail customer and a mobile customer, so that we facilitate. So for example, when you sign up on the mobile, on the BetMGM mobile app, you become an MGM rewards member by signing up there. So we would get data back on that customer.
And that's how, in previous discussions, we've mentioned about the ability to get credits and tiers across both platforms.
Mhm.
It's more about our players' abilities to move through our loyalty program than a sharing of information that you could deem unsecure or inappropriate.
Okay, so I think with that, Attorney Grossman, I don't know your thought, but I do think it is appropriate to move into executive session to further discuss.
To discuss the second question you
The
asked.
second question on the patron data, yes.
Okay, if there are questions about the relationship between the parties relative to the maintenance of patron data and personal information,
Yes.
that seems to fall within the parameters of competitively sensitive information that could be detrimental or place MGM, the applicant, at a competitive disadvantage. And so would be the appropriate subject for a motion.
Can I ask, does the applicant plan on sharing anything further? in
Sure.
Executive session.
Sure.
Yeah.
We'll try to answer all your questions to the best that we can, always.
No, because, Pat, you're just uncomfortable because of the issue around there being sensitive information that could put you at a competitive disadvantage.
Correct.
Okay.
Chair, just before we close the public discussion on this, there's one additional element, I think, in response to Commissioner Skinner's question that, and at the end of the day, for purposes of responsible gaming, for purposes of data integrity, when it comes to the retail sports book, MGM Springfield is responsible for that, including any issues that would ever come up. They would be responsible, not the vendor, MGM Springfield. They would be responsible and accountable to the commission for anything that happened in connection with any issue around regulatory compliance or otherwise.
Understood.
So do we need, so does that solve your question, Commissioner Skinner, or I just want to understand what I would be voting on to go into executive.
President, well, so let me be more pointed then. I guess my questions relate more to the confidential investigations that were disclosed by BetMGM. And so, I'm interested in, and that's why I asked the question that I did relative to the relationship between the applicant and BetMGM relative to the maintenance and security of patron data.
I think we need to pause there to the extent that we're discussing things that are outside of the public domain.
Okay, all right. So, Councilor Grossman, you're comfortable that we could go forward under 6I, correct?
Chair, could we have a 5-minute break before we go into executive session? I want to make sure that I'm going to reach out to somebody else as well on the MGM side. I want to make sure that Commissioner Skinner's question gets answered fully.
Yep, and before we do that, though, I just would like to pause on her first question. Commissioner Skinner, you mentioned the free bet. Just as a reminder, that the issue of free bet, our white paper does address that Director Linden produced with his team earlier and published. It does address the issue of free bets. We have, to the extent that we decide we want to have more of a regulatory role in that world. Commissioner Skinner, I think that we are going to be looking at our advertising regulations. So that's just something to keep in mind. You raised an important question that we haven't raised, but I think it's only because the advertising regs haven't been in front of us. But again, something for us to think about for moving forward. So thank you for that question. And now we'll give the applicant, do you need 10 minutes?
10 minutes. I'm going to reach out to Las Vegas.
Okay, so 10 minutes, and that gets us to 12:30, and then we'll reconvene and decide if we're going to move into executive session. Thank you, everyone. Okay, Dave, thank you.
All set.
Thanks so much. Mr. Nosel, are you all set, or were you still waiting for some of your?
I actually just for Madama to return, so if you can just bear with us for 2 or 3 minutes, we should.
Just give me the nod and I'll know. Thank you so much.
Yep. Chair, maybe while we wait, if is there an explanation, I guess, on the mechanics of going into executive session if necessary? How will that work? Is it a separate link? What would be the next steps for that?
Yeah, so Crystal, I'm not sure if I see her. It's me on page 2. Crystal, yeah, Crystal, you'd be able to send the links to the applicants, participants. Do you have all of their names, or at least send it to?
Yeah.
One who can forward it?
Yep.
Okay, I'll set them. So would you send it to Daniel or Todd?
Yeah, Chair, on our end, if you send it just to Pat Madamba and I, and we'll figure out and forward it to anybody else that we think we need.
Crystal, are you all set with your emails? Otherwise, Karen can pass them on.
Are we unmuted?
I've got everything.
Okay, she's got everything. So she'll make sure you have those links. Are you all set now, Chad, or we're still waiting?
No, I think we're ready. We're ready.
Oh, okay. Thank you so much.
Thank you.
So again, this is a reconvening of Massachusetts Gaming Commission public meeting number 414. Because we're holding this meeting virtually, I'll do a roll call to confirm that all my fellow commissioners are attending. Commissioner O'Brien,
I am here.
Commissioner Hill,
I'm here.
Commissioner Skinner,
I'm here.
Commissioner Maynard.
I'm here.
And so we're set to proceed. Attorney Grossman and Attorney Nosel. I think we're waiting to hear from the two of you. So
We're going to go into.
I believe we're going to hear from Mr. Madamba to hear whether there's any supplemental information in response to Commissioner Skinner's.
Are we in the executive session?
no, we're not in executive session yet, no. So, but the request was to move into executive session. Councilor Grossman, can you confirm that this would be an appropriate use of that before I read into the record what's required?
It would, except I believe Mr. Madamba was going to see if there was any further information he could provide first.
That's actually not, that's not exactly accurate.
That's not.
I said that I would feel more comfortable in executive session.
Okay.
And that I would also ask for somebody else to join us. And we will have someone else join us as well in that executive session.
Okay. In that event, Madam Chair, yes, so I think if you would like to read the language you have before you, and then Commissioner Skinner, I believe, has a motion prepared.
But you are saying, based on everything that you've heard today, that it would be appropriate.
Yes.
Okay, the commission anticipates that it may meet in executive session in conjunction with its review of the BetMGM LLC or Blue Tarp redevelopment, doing business as MGM Springfield applications. Actually, that's wrong. My apologies. Commission anticipates, so strike that. The commission anticipates that it may meet in executive session in conjunction with its review of the Blue Tarp redevelopment, doing business as MGM Springfield application in accordance with GL Chapter 30A, Section 21A7, and GL Chapter 23N, Section 6I. Consider information submitted by the applicant in the course of its application for an operator license that is a trade secret, competitively sensitive, or proprietary, and which, if disclosed publicly, would place the applicant at a competitive disadvantage.
Madam Chair, I'm prepared to make a motion. I move that the commission meet in executive session in conjunction with its review of the Blue Tarp redevelopment, doing business as MGM Springfield application in accordance with General Laws, Chapter 30A, Section 21A7, and General Laws, Chapter 23N, Section 6I, to consider competitively sensitive information related to the relationship between the applicant and BetMGM with respect to the maintenance of patron data and an ongoing confidential investigation that has been disclosed by BetMGM, which, if disclosed publicly, would place the applicant at a competitive disadvantage.
Second.
Can I ask a clarifying question? You said that this is disclosed by BetMGM. I don't have that application in front of me. Is that appropriate then, Councilor Grossman? I'm asking the question.
Yeah, I mean, this is a public meeting, so there is certain information that we will make part of the record, certainly. So it's not a secret, and we can certainly provide whatever information is necessary, but it should be done in executive session.
Well, I am again asking, Commissioner Skinner's motion said that it's with respect to something that was provided by BetMGM.
But it overlaps, right?
That pertains to the relationship that the applicant has with BetMGM.
Could you say the motion again, then, please, Commissioner Skinner?
I move that the commission meet in executive session in conjunction with its review of the Blue Tarp redevelopment, doing business as MGM Springfield application in accordance with General Laws, Chapter 38, Section 21A7, and General Laws, Chapter 23N, Section 6I, to consider competitively sensitive information related to the relationship between the applicant and BetMGM with respect to the maintenance of patron data and ongoing, confidential investigation that has been disclosed by BetMGM, which, if disclosed publicly, would place the applicant at a competitive disadvantage.
Another clarifying question. Has that same information been provided by the applicant before us?
Not that I'm aware.
Director Lilios?
No, it's new information.
Was it provided only, not new information, was it provided by the applicant before us? I want to make sure I didn't miss it in the application.
It was provided by a representative of BetMGM.
We're prepared to have the discussion, Chair, in executive session about the sharing of data.
Okay, you may be, but I'm not because I don't have that application in front of me. Has that information been provided? Perhaps, but it's not the application before us. I just want to make that clear that it's procedurally, I hear the applicant wanting to be cooperative. I guess if there's a different way of framing it so that I'm not having to consider something that's not for me. I just am a little uncomfortable with that arrangement. Councilor Grossman?
I mean, the alternative is to have the discussion in public without going into executive session.
Oh,
but
no, well,
the
that's,
applicant
No,
wants to
I'm-
do.
there's another solve, I'm sure, Commissioner.
Yeah, no,
Skinner.
I'm wondering if we phrase it more from the MGM perspective, that the question is in connection with their application and their data sharing, MGM's data protections and sharing in relation to
Yes.
the matter that was disclosed by BetMGM, because then we're putting the focus on
Yes.
MGM's role in that regard.
And whatever they share with us in an executive session. If there's something that's
Right.
responsive to Commissioner Skinner's question, I would like the motion to reflect that it's coming from them as opposed to us looking at an applicant. Because I understand that that they're interwoven, Commissioner Skinner, so I understand that relationship is there, but I just don't want to reference another application, that's all. Thanks. So, Councilor Grossman, if you could, maybe Commissioner Skinner, would you be willing to revise your motion? With some help from
Asking that I revise the motion because I feel like exactly what Commissioner O'Brien just said is reflected in the motion that I put forth. So I'm going to need a little help understanding what it is you're looking for exactly, Madam Chair.
I guess I am trying to make sure that we don't reference that this information is coming from a different application. I can only make my decisions today based on the application form.
Okay, Madam Chair, I move that the commission meet an executive session in conjunction with its review of the Blue Tark redevelopment doing business as MGM Springfield application in accordance with General Laws, Chapter 30A, Section 21A7, and General Laws, Chapter 23N, Section 6I, to consider competitively sensitive information related to the relationship between the applicant and BetMGM with respect to the maintenance of patron data and an ongoing confidential investigation, which, if disclosed publicly, would place the applicant at a competitive disadvantage.
Second.
Any further discussion? Commissioner O'Brien?
Aye.
Commissioner Hill? Commissioner Hill?
Yes.
Commissioner Skinner?
Aye.
Commissioner Maynard?
Aye.
And I vote yes. Fine. Okay, now we're going to leave this this session, this public session, and then we will move into the executive virtual session, virtual room. You'll have a link to that. And we're not going to take a break beforehand. We'll just go straight into the executive session. Thank you.
Dave, I think you can take down the screen. The chair just needs to connect to audio.
Okay, that's all set. Oh, yeah, Kathy, it looks like you're muted. I don't know if unmuting will do that or if I'm.
Sorry, everybody, I'm talking away and I was not on audio. Thank you, everybody. Okay, so this is a reconvening of commission's public meeting number 414. And we're going to just again, because it's a virtual platform, I'm going to confirm attendance. Commissioner O'Brien.
I am here.
Commissioner Hill.
I am here.
Commissioner Skinner.
I'm here.
Commissioner Maynard.
I'm here.
So we're set to proceed. We just concluded our executive session, and we now are going to turn back to my searching for or assessing whether we have a consensus on the outstanding sections of the application, which has been revised at our request, particularly with respect to sections F and G, but also supplemented elsewhere. I believe we have outstanding F. I believe we've confirmed, met our expectations, but we are now looking for sections E and G. Are there any outstanding questions with respect to section E?
No questions, Madam Chair, but I would say that they met expectations.
Thank you. Are other commissioners in agreement?
Agreed.
Same.
I agree.
Okay, excellent. So thank you again for the enhanced response and for your participation in today's questioning. Then turning to section G. Do we have any additional questions on section G? And so do we feel that it meets expectations? Commissioner Skinner, I saw you take off your video, your audio.
Yes, I feel that that section has met expectations.
Excellent. Commissioner Hill.
Meets expectations.
Excellent. Commissioner Maynard.
Meets expectations.
Commissioner O'Brien.
I agree.
Okay, so I agree. We'll move on then. If the commission is prepared, we've gone through each section and we have reserved, make sure I'm in the right item. We have reserved in item number 4, the right to make a determination by the commission in accordance with our regulation. And we have asked Attorney Grossman to walk us through that process if we are prepared to move in that direction. Okay, thank you. I'm not hearing any objections, so I'm going to assume that that's moving in that direction. I turn to Todd Grossman, our general counsel.
Thank you, Madam Chair. If helpful, what I'll do is I'll just remind everyone what the standard is, and we'll go through the factors and the sub-factors just to ensure that everything is in place, and then we can talk about some of the conditions that may go along with it if the commission is inclined to award the license. First, so we begin at section 218.06 sub 5, which says that the commission's ultimate question is to, in determining whether to award a license, is whether such award would benefit the Commonwealth. And in making that decision, as you know, the commission laid out a series of factors. And now we'll just go through the factors and the sub-factors that help inform the decision. So the first is the applicant's experience and expertise related to sports wagering, including the applicant's background in sports wagering, the applicant's experience and licensure in other jurisdictions with sports wagering, and a description of the applicant's proposed sports wagering operation or description, technical features, and operations of the sports wagering platform, which is not necessarily applicable in this particular matter. The next factor is the economic impact and other benefits to the Commonwealth if the applicant is awarded a license, including employment opportunities within the Commonwealth, the projected revenue from wagering operations and tax revenue to the Commonwealth, And here the applicant's proposed plans for construction and capital investments associated with the license board, and finally, community engagement. The next factor is the applicant's proposed measures related to responsible gaming, including the applicant's responsible gaming policies, the applicant's advertising and promotional plans, and the applicant's history of demonstrated commitment to responsible gaming. Next is a description of the applicant's willingness to foster racial, ethnic, and gender diversity, equity, and inclusion, including within the applicant's workforce, through the applicant's supplier spend, and in the applicant's corporate structure. Next is the technology the applicant intends to use in its operation, including, as applicable, geofencing, know your customer measures, and technological expertise and reliability. Next is the suitability of the applicant and its qualifiers, and you'll recall here there are the two options, either the durable finding of suitability or the preliminary finding of suitability, and we can discuss these in a little greater detail if that would be helpful. But the sub-factors include whether the applicant can be or has been determined suitable in accordance with 205 CMR 215, the applicant and all parties in interest to the licensee's integrity, honesty, good character, and reputation, the applicant's financial stability, integrity, and background, the applicant's business practices and business ability to establish and maintain a successful sports wagering operation, the applicant's history of compliance with gaming or sports wagering licensing requirements in other jurisdictions, and whether the applicant is a defendant in litigation involving its business practices. And finally, any other appropriate factor that the commission deems relevant in its discretion. So those are the standards and the factors that the commission, of course, has considered during the course of this evaluation. Let me stop there. There are, of course, other provisions that may be helpful to discuss, but Madam Chair, I'll come back to you.
So I don't have notation of a condition that we discussed from last time or this time as a condition, but Commissioner O'Brien, you did ask a follow-up question, and then you had a chance to review the application during a break. Is there any further clarification we want with respect to the advertising and marketing?
Not that I can think of at the moment, Madam Chair. I don't know if you have one, but.
This is a question for the applicant. Did you clarify that you would be in control of third-party affiliates for marketing, and that would extend through your partners, the ultimate responsibility? I heard a collaboration from Daniel, but I thought later on perhaps you clarified that.
We have complete control over the retail side. On the mobile side, the tethered skins at the moment, just one. We would expect that BetMGM would follow, because it's BetMGM that would be placing the advertising, would follow all of the requirements in Massachusetts. And to the extent that they didn't, we would exercise our control, if you will, through our 50% interest in the JV. And again, I can't really speak for our partner, but I can't imagine that Entain as well wouldn't want BetMGM. It's just to satisfy all of Massachusetts requirements. But the skins do operate, I'm not going to say independently, but they do operate their business with, and look, at the end of the day, we're ultimately responsible to you because they're tethered to our license, and that would reflect badly on us if they did something that was not appropriate. And we are fully cognizant of that. We operate in other states with skins, not only BetMGM, but in some other states we host another skin as well, and we're just ultimately responsible.
I'm all set. Commissioner O'Brien, you all set?
Yeah, I mean, that's why I think a lot of the questions I have are more BetMGM, not this Cat 1 applicant.
Thank you. I don't have notes of another condition. Attorney Grossman, do you? Anybody?
Sorry, I don't have notes of any specific conditions, but just as a reminder, under section 220.01 of the commission's regulations, there are automatic conditions that will attach to the award of any license. And if it would be helpful, I can just quickly go through those so everyone is on the same page.
Please remind us of them. Yep, thank you.
They include the following. That the operator obtain an operation certificate before conducting any sports wagering in the Commonwealth, that the operator comply with all terms and conditions of its license and operation certificate, that the operator comply with Chapter 23N and all rules and regulations of the Commission, the operator make all required payments to the Commission in a timely manner. In this case, as far as the licensing fee is concerned, if it's a durable finding of suitability, the Commission issues, that would be the full $5 million fee. If it's a preliminary finding, it would be the $1 million payment towards a temporary license. The next condition is that the operator maintain its suitability to hold a sports wagering license. And lastly, that the operator conducts sports wagering in accordance with its approved system of internal controls, consistent with 205 CMR, and in accordance with its approved house rules, in accordance with Chapter 23N, Section 10A, and consistent with 205 CMR. So those are the automatic conditions that attach. And then, of course, there's a whole process to obtain an operation certificate that requires other prerequisites for that.
All set. Commissioners, I think this applicant's probably looking for a motion. Are we?
Oh, sorry,
Madam-
Commissioner Hill. I think before you do that, you should
I'm just
talk
going to
about.
bring this up.
Oh, sorry, Commissioner Hill, please go for it.
I think the last week when we were doing this, we went through the factors and we agreed, and then we made a motion. Is that what you're going to say, Todd?
Yeah, specifically as it relates to suitability, I think you need to determine which branch you're going to go.
We did them individually. Remind me,
Yes.
A different standard, as opposed to accepting out suitability for a different standard. So are you going to do it by motion, or should I make it as I think we do it by a motion, correct, Todd? As opposed.
Yeah, I have two motions to make. One of them will do with suitability. However, we did go subject by subject in the last two licenses that we approved.
And I think, Todd, you walked us through that.
Yes, I think Commissioner Hill's prepared to address these.
I was ready to address the motions to allow, but Chair, I was looking to you to go subject by subject.
We did. I thought, Councilor Grossman, you did that.
Yeah, basically, you want to just make sure there's substantial evidence for each of the factors that I just reviewed. That's really the ultimate question. And then ultimately, whether a license award would benefit the Commonwealth. That's the question to answer.
So commissioners, with respect to A through G, with the exception of F, we're going to need to find whether or not we agree that there's substantial evidence to support that, with the ultimate finding that the Commonwealth will be benefited. This will operate as a benefit of the Commonwealth. Do I have a motion with respect to that? Councilor Grossman, I think that you led us through this process last time.
Yes, I certainly can. And Commissioner Hill, maybe.
I think we do with our other
with
our horse racing license. So I don't want to lead my fellow commissioners, imprecisely.
Sure, I can certainly tee that up unless Commissioner Hill, you'd like to.
No.
Go for it. Okay. So I think you want to find that the applicant Blue Tarp redevelopment, through its application submitted and discussed as part of the review today and on December 7th has established by substantial evidence that the criteria set forth in section 218.06, sections 5A through E and then G have been met, and that the award of such a license would benefit the Commonwealth.
I'm ready to make a motion to that, Madam Chair.
Okay, thank you, Commissioner Hill.
So Madam Chair, I move that the commission find that the applicant Blue Tarp redevelopment through its application submitted and as discussed here today and on December 7th, 2022, has established by substantial evidence and met the criteria set forth in 205 CMR 218.06, 5A through E, and G, and further that any award of the Category 1 license to the applicant would be to benefit the Commonwealth.
I second.
Thank you, Commissioner. Any further discussion on this first part of the decision? Okay. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner. Aye. Commissioner Maynard.
Aye.
And I vote yes. 5-0. Thank you. And now?
I have a second motion, Madam Chair. I move that the commission find that the applicant Blue Tarp redevelopment be found to have established by its application filing, reviewed by the IEB, and the discussion here today and on December 7th, 2022, by clear and convincing evidence at an adjudicatory proceeding, its suitability consistent with 205 CMR 218.06 5F, and that any conditions subject to a finding of suitability also reference the obligations outlined in 205 CMR 220.01.
Just I have a question on that because we didn't do an adjudicatory hearing. So are you referring to the one back in say 2013 when you make that statement, or?
We need clarity on that. Yeah.
Yeah, I can jump in on that one. Yes, so of course, any durable findings of suitability have to be made by clear and convincing evidence presented at an adjudicatory proceeding. In this case, it was at the prior one you've referenced, and I don't have the date before me, but I believe it's in the IEB's report where it talks about the fact that this applicant and its qualifiers have gone through the adjudicatory proceeding process and have maintained their suitability up to the present day. And that's you can rely upon that in order to find the durable finding of suitability if you were so inclined.
Okay, I guess the only language I would suggest adding in, given the 2 days of hearing and the discussions that we've had, is to maybe amend it to say, and nothing in the submissions of the applicant or in the hearings on December 7th or today raise substantial issues such that we would disturb that suitability finding. I think it gives nod to what we've done over this month.
So I would agree to that.
And would you amend it just to put in the date of the earlier 20?
Yeah, I said December 7th and today's date.
Oh, no, the adjudicatory hearing date too.
Oh, I see what you mean. Refer back to the 2013.
Yeah, whatever that is.
I don't have that readily available. I don't know.
That was, it was amazingly, it was December 23rd of 2013.
There you go. It's like Groundhog Day.
Merry Christmas, happy Hanukkah, right? Okay, so there we go. So
I would second, given those amendments.
Yep.
And I think we have it on the record, unless you would like Commissioner Hill to reread it. Are we all set? Okay, and we have a second from Commissioner O'Brien. Any further discussion? Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner. Aye. Commissioner Maynard.
Aye.
And I vote yes. 5-0. Congratulations to MGM Springfield, and thank you for your application, your interest, and your responsiveness today and December 7th. So thank you. Commissioners, what would you like to say?
Congratulations. Happy holidays.
Commissioner Maynard?
Same. Congratulations. Good luck.
Okay, Commissioner Hill
Yep, just great, great job and congratulations to you.
and Commissioner Skinner.
Congratulations. Thanks for hanging in there with me. Happy holidays.
And the applicant.
First, Commissioner Skinner, always a pleasure. Just thank you, everyone. Really do appreciate it. And as I said in executive session, more than happy to answer any question that the commission has. I hope everybody enjoys their holidays. It's been a tough, really tough couple of years, 3 years now going on. And I just hope everyone really, really enjoys this period.
Thank you for that. President Kelly, we took your team away last week and we thank you for having been lined up. And I'm pleased that we were able to address you this morning promptly. I thought we'd let you close.
Well, thank you, Madam Chair. Thank you to the entire commission. As has been referenced on the calendar, it's aptly timed for the gift of this decision, what it means to the city, what it means to the community, and what it will ultimately mean to the state. We recognize that this is a multi-step process, but this is a very important step forward for our entire team at MGM Springfield. And so we thank you. And we appreciate the thoughtful and deliberate approach that the commission has taken. And I have to say, we are extraordinarily excited about, in the not too distant future, transitioning an extraordinary sports lounge into a sports book. So thank you again and happy holidays.
Thank you and happy holidays to all. Thank you so much. Commissioners, I think probably now we deserve some lunch. It is 1:30. Should we reconvene at 2? Does that sound right, commissioners? Okay, thank you. MGM Springfield, good luck and stay warm. All set, Dave.
All good.
That's much better when I have the audio on. It works. Thank you so much.
No problem.
Okay, commissioners. Everybody's back. Okay, this is a reconvening of Massachusetts Gaming Commission's public meeting number 414. And because we're holding this meeting on a virtual platform, we'll do a roll call. Commissioner O'Brien,
I am here.
Commissioner Hill,
I'm here.
Commissioner Skinner,
Yeah.
Commissioner Maynard.
I'm here.
Okay, so we're set to go. And we are now turning back to our, excuse me, our agenda. And we are going to begin, and I'm just looking at our attendees, now with the presentation of BetMGM for their application for Category 3 sports wagering operator license. We hope that it will include a demonstration of their application. Good afternoon. Is it Lonnie or Lonnie?
It is Lonnie.
Hope you're on mute or you're.
It is Lonnie. Can you hear me now?
Yeah, just if you can elevate it a little bit more.
There we go. Is that better?
That's better. Commissioners, we can always use louder.
All right.
It's very soft, actually.
Very
I will speak up.
Great. So it's Lonnie. Did I read your lips right?
That is correct. It's Lonnie.
Okay, excellent. Good afternoon, Ms. Lonnie.
Madam Chairwoman, good afternoon. We want to echo the sentiments of MGM and thank all the commissioners this afternoon for the diligent review of our Category 3 sports wagering application tethered to MGM. We want to thank you all for all the review of the information, along with the staff, specifically the BIE group, for the hard work. We have a group of subject matter experts here today to talk around different issues throughout this presentation. So I'd like to run through the individuals that will be presenting different items for you all this afternoon. First of all, if you'd like to move to the agenda slide. Commissioners, I'm the Chief Compliance Officer of BetMGM, Rhea Loney. Also joining me to discuss our experience and expertise is Jeremy Coleman, our Deputy General Counsel, Sarah Brennan, our Senior Director of Technical Compliance, David Main, Senior Manager of Technical Sports Operations. We'll also be addressing responsible gaming in our presentation today. We have Richard Taylor, Senior Manager of Responsible Gaming. In relation to discussing our BetMGM Rewards program, you'll have Megan Twombly, Director of Loyalty and CRM Optimization. Anna Eliezer, our Head of Diversity, Equity, and Inclusion, will be discussing our Diversity, Equity, and Inclusion program. Also, you have Roman Rubis, Director of Technical Governance, who will be discussing the technology component and doing a presentation of our platform. Commissioners, if it's your pleasure, we'll now turn it over for the presentation portion, and I'll turn it over to Jeremy Coleman, Deputy General Counsel, if there are no questions before we begin.
Thank you, Rhea, and I want to second everything that was said. We really appreciate your time and consideration of our application. Before we get started with our formal presentation, I just wanted to make a quick note regarding confidentiality. BetMGM has designated several parts of its application as commercially sensitive or proprietary, as provided in Chapter 23N, Section 6I. BetMGM asks that discussion of any material that has been designated as confidential be done through an executive session. As such, we do not plan to present any information that is confidential in our affirmative presentation, and we will alert the commission if a question asked by the commission elicits confidential information, and we will request that we move into an executive session. With that note, I'd like to kick it over to our Senior Director of Compliance, Sarah Brennan, to start our formal presentation. Thank you all.
Thank you, Rhea. Thank you, Jeremy. Good afternoon, commissioners. Nice to see you again, this time on behalf of my organization, BetMGM. And we will dive into experience and expertise. Kennedy is going to be changing slides for me, so bear with us a bit if I have to tell her to move on or go back. BetMGM was established in July of 18 to create a world-class betting and online gaming platform in the US and has quickly become an industry leader in this space. As an industry leader, we use state-of-the-art proprietary technology to offer sports wagering and online gaming via market-leading brands to our patrons. This proprietary technology allows us to control the entire player journey, creating a seamless and enjoyable experience for our patrons. In collaboration with MGM, BetMGM assists in operating the physical sportsbooks, as you know, and as we've highlighted over the last couple of days of hearings, by providing 24/7 trading and risk operations and our retail technology at MGM's properties in Vegas, Detroit, New Jersey, Mississippi, Maryland, and soon to be Massachusetts. Next slide, please. BetMGM is a joint venture between two industry leaders, MGM and Entain. This diagram demonstrates the services that either provide to us. MGM largely name recognition, brand, and market access in our MGM jurisdictions across the US, and Entain with a proprietary retail and online technology that's supported by over 2,000 developers. They are a leading global online operator with over 50 licenses in 27 jurisdictions and lead in expertise in betting and online gaming. We've got 600 traders worldwide. Next slide. As the industry continues to evolve and grow and market access across the US opens up, BetMGM is live in 25 jurisdictions presently. Online sports wagering has reached 41% of the US population in the last few years. And at present moment, we have 31 market access agreements across the US. Next slide. Now, we spoke about this briefly in MGM's hearing, and I thought it would be helpful to have a slide here that more specifically delineates the responsibility between MGM and BetMGM as it relates to both retail and mobile operations. As was stressed during MGM's hearing, both entities are singularly responsible for their regulatory compliance obligations. You can see, and as we discussed already, that BetMGM provides retail technology to MGM sportsbooks and also industry-leading trading and risk operation management, which includes the 24/7 global bookmarking operations and a dedicated US-based team. For online and mobile operations, BetMGM is responsible for all regulatory and operational functionalities, which I'll get into when I describe the compliance function and department at BetMGM. And you can see that the team that reports into me operationally is responsible for the trading and marketing compliance and responsible gaming functions. MGM at their book is responsible for all other regulatory and operational functionalities when running a BetMGM sportsbook and uses its proprietary rewards program, MGM Rewards, for integration with casino player tracking systems. At retail, every employee prior to deployment receives extensive training in operations, responsible gaming, and AML. Next slide, please, Kennedy. Now, commitment to compliance. Anecdotally, for your background, when I started working at BetMGM, I was employee number 110. I started in January of 2020, and there was 5 people in the compliance department. To date, we are nearing 75 with the recent addition of fraud analysts to the AML team. So you can see that the growth in the compliance and legal teams has been exponential in correlation with our expansion across US markets. BetMGM's dedication and commitment to compliance is deep. And as such, we have expanded the department in order to mitigate risk and ensure compliance across all business functions in all the jurisdictions within which we operate in every area of the business operations. We have a director of AML compliance who is responsible for all federal and state filings, as well as managing the senior director of suspicious activity, who's responsible for filing suspicious activity disclosures as it relates to any sort of suspicious activity or waging that occurs on our mobile platform. We also have a director of technical compliance who works in close parallel with both my operational compliance team and Roman Rubis, with whom you'll become acquainted on the tech governance team, as they evaluate the regulatory requirements as it relates to platform capabilities and requirements in each jurisdiction's regulatory framework. Licensing, I know that you all have been acquainted with Joshua Wiseman. He's a senior manager of licensing, and his team is responsible for entity, vendor, and occupational licensing across all of our jurisdictions. And the operational compliance team. Again, we went from having 2 analysts dedicated to regulatory and operational compliance to now a team of nearly 40, including trading compliance, iGaming compliance, responsible gaming, marketing compliance, patron complaint management, and regulatory administration. The regulatory administration team is responsible, and you may have already had some interaction with them, for developing all of the compliance documentation, including internal controls, terms of service, and all other required filings with respect to responsible gaming and trading compliance in each jurisdiction. I'm going to hand it over now to David Main. He's our Senior Manager of Technical Sports Operations, and he'll give you a sports betting overview and explain more in detail as to how trading works at BetMGM.
Thank you, Sarah. Good afternoon. So BetMGM's trading department handles all the odds making and risk management of all sports wagering in all of our properties. The primary functions would include the setting and modifying of wagering lines for all events, as well as resulting the events upon their completion. They'd also monitor all wagers, liabilities on events in real time in order to best determine any price changes that we need to be. There are a number of factors by which the trading team would determine the betting lines, which would include monitoring prices in comparison to the competitors in the market, as well as some customer analysis and a review of which teams are being heavily backed. The trading department would also work very closely with the compliance team to ensure that all offered events and markets comply with the official sports wagering catalogue provided by yourselves. That would include managing of any events that should be added or removed accordingly. As part of the risk management, the traders are also responsible for monitoring any potential suspicious wagering activity placed by the players on particular events or outcomes. We'll go next slide, please. So in the event that a trader does suspect any potential suspicious activity, this would be escalated to our third-party integrity monitoring provider, which is US Integrity. Now, US Integrity work with member gaming operators, as well as federal, state, and tribal regulators, as well as law enforcement, to basically make sure that the integrity of all events are complete and that there's no issues. So once an alert has been raised with US Integrity, they would review and request that all member gaming operators would also check in case they saw any suspicious activity themselves. On the flip side of that, the trading team will also monitor US Integrity themselves for any alerts that other members would raise, and review if we saw any similar suspicious activity as well in all of our jurisdictions. If we did identify any suspicious wagering, then those details would be reported back to US Integrity, as well as the state regulators themselves. Is there any questions on any of that, or can I move on to Richard Taylor, who's our senior manager for responsible gaming?
Thank you, David. We hold our questions, so if you could just stay tuned. Thank you so much.
Sounds good.
Thanks, David. Good afternoon, Madam Chair, commissioners, and staff. I would like to begin by thanking you all for allowing me the opportunity to provide an overview of our responsible gaming efforts and how we at BetMGM meet our RG commitments. At BetMGM, responsible gaming goes far beyond the RG team and the compliance department. It lives and breathes throughout the organization, from our Chief Executive Officer, Adam Greenblatt, on down. We believe we all have a role to play when it comes to responsible gaming. Now, some of the content in my presentation will probably look familiar to you, and that is intentional. When I first took this role back in the fall of 2020, it was abundantly clear to me and to BetMGM leadership that a consistent responsible gaming customer experience between the land-based operations of MGM Resorts and our digital offerings at BetMGM would be critically important. That's why we've implemented GameSense throughout our operations and continue to hone its use in a digital arena. And I'll show you some examples of how we use the program during the rest of my presentation. I'm excited and proud to share with you today how we empower and inform our employees and customers to understand and practice responsible gaming so that we can help keep gambling a fun activity and mitigate gambling harm as much as possible through education, support, and direct assistance. At BetMGM, we take a multifaceted approach to responsible gaming. As you all know, RG and PG are difficult challenges, and we take this responsibility of ensuring the most enjoyable and safe experience possible for our customers seriously. At the base of our efforts is the GameSense program. We owe a lot to the MGC for introducing us to GameSense. Having helped implement and lead the program at both MGM Resorts and now at BetMGM, I've had the privilege of seeing firsthand how the program can make an impact for employees and customers. The light bulb interactions in training rooms, gaming floors, and through digital interactions have been some of the most rewarding moments of my career. A highlight of these experiences was working there in Massachusetts with Mark Vanderlinden, the Mass Council, and so many others to develop and implement GameSense at MGM Springfield just over 4 years ago. In my opinion, there is no better example of operator, regulator, and nonprofit collaboration out there. I believe through GameSense, we are making a real difference, and a lot of credit is owed to this body for introducing us to the program. In addition to GameSense information, we also provide an array of RG limit setting tools and have trained staff who are able to provide tailored care and service to help both encourage responsible gaming, as well as assist those who are in distress. Never content to settle, we look to both real-world experiences as well as academic research to enhance the ways we engage with our customers, to reinforce positive play, and address problematic behaviors. This evidence-based approach also helps guide our employee training programs, internal controls, and responsible gaming best practices. At BetMGM, continuous improvement isn't just a talking point, it is a way of operating. As we know, we can't do this alone. And so through collaboration and partnerships with our parent companies, MGM Resorts and Entain, regulators, external organizations, advocacy groups, and researchers, we can do our part to help inform the public and mitigate harm. We believe this unified approach to responsible gaming puts the best interests of our customers, their families, and the communities where we operate at the forefront. Slide. Now, I am a firm believer that if you want to embed a culture of responsible gaming throughout your organization, you must start with your employees. All of the tools and algorithms in the world won't matter if your teammates do not understand the concepts behind them or the importance of RG from a customer experience and business sustainability standpoint. Like MGM Resorts, we use a situational relevant training model. So while all employees will receive an introduction to essential concepts of RG and PG, those who interact with customers will receive more in-depth interaction-based training. At the top of our training program is GameSense Advisor training. GameSense advisors are trained to provide enhanced customer assistance for RG and PG matters, including cases involving customers experiencing significant distress as a result of their gambling. As of now, we have 6 GameSense advisors on staff, and we have plans to expand this team over the coming year to meet our future needs. Training is provided during new hire orientation, as well as annually as a refresher. And beyond these trainings, we also provide micro-learning sessions to the entire company during Problem Gambling Awareness Month in March, as well as Responsible Gaming Education Month in September. Finally, we place a strong emphasis in learning from those who have actually experienced gambling harm and have an intimate knowledge of its devastating effects. That's why we are proud to be working with the renowned harm reduction group from the United Kingdom, Epic Risk Management, to develop enhancements to our current training to improve how we identify and handle customers who are experiencing significant gambling harm. We anticipate rolling this training out in a few months, and I'm really excited to get going in providing our employees with this content. Next slide. Moving on to our customers, we believe that informed decision-making begins with player education. We recently completed an overhaul of our responsible gaming websites to the GameSense website you see in front of you. Accessible by clicking on the RG logo in the header, our players can explore a variety of key responsible gaming topics, including our principles, how to develop a GameSense mindset and play within one's means, an explanation of our RG tools and how they can help players stay in control, a fact or myth game to help set the record straight about what gambling is and what it isn't, and of course, a full list of state and national resources to help individuals address problem gambling concerns. Something I'm particularly proud of is that we also have a section for family members and friends to learn about the gambling of a loved one, including specific information on seniors, children, and spouses. We recognize that responsible and problem gambling extend beyond the customer, and so we feel it is important to provide information not just for our customers, but for anyone interested in learning more about this topic. Having experienced firsthand how gambling addiction can affect the family, this portion of our GameSense website is particularly important to me, and I'm proud to work for an operator who prioritizes this area. Every jurisdiction does RG slightly differently, but the beauty of our GameSense website is that it can be fully tailored based on the needs of each jurisdiction. And we welcome the opportunity to work with your staff to include information and content to best serve the Commonwealth of Massachusetts. Next slide. Understanding that no two players are completely alike, it's important to offer our customers a variety of tools to help them control their activity. Whether they choose a deposit limit, time limit, loss limit, or an extended timeout, also known as a cool-off, we want to encourage our customers to view these tools in a positive light. We want them to be proud to use our tools and see their use as a sign of strength, not a sign of weakness. Through this positive promotion of the tools via customer emails and chats, we hope we can help reduce stigma and increase utilization rates. We actively promote these tools within the GameSense pages, our GameSense welcome emails to new customers, as well as throughout the year via emails and social media posts. Once entered and submitted by the customer, the limits cannot be canceled or increased until the expiration of the limit and a cooling off period has passed. However, at any time, the customer may place more restrictive limits if they desire to do so. Next slide. A key tenet of our approach to responsible gaming is meeting customers where they are at. And how we do that is through providing them with a variety of ways to get the information they need. From first-time depositors who receive a GameSense welcome email to our seasoned customers and those who are hosted, we have something for everybody. Our customer service and VIP teams are trained to both promote responsible gaming, as well as look for problematic and concerning language and either address it directly themselves or escalate it to my team for additional assistance. While the vast majority of our customers can gamble within their means, which is something we help encourage through GameSense and the promotion of RG tool usage, we understand and we recognize that some of our customers unfortunately experience issues as a result of their gambling. When these concerns are presented either through communication or observed behavior, we take quick action to provide empathetic assistance, to prevent additional wagering through our service, and encourage the customer to seek help through the state self-exclusion program, Gamblers Anonymous, treatment, etc. Above all else, our number one priority is taking care of our customers. Slide. Our customer-facing teams are trained to identify common warning signs and problematic communication, and they're empowered to act. However, sometimes it's not a cut and dry situation. In those instances, my team is available to assist and provide guidance and interaction to customers. For cases where the communication is vague and they are unsure if there is a gambling-related problem or not, our customer service agents are trained to escalate the matter to my team for additional review and action. And here's just an example of what that may look like. A player may state that they could really use a bonus or they need their luck to turn around, etc. And so through that communication, that could mean a variety of things. Maybe they're just looking for additional funds for play, or maybe there's an underlying issue that needs to be explored. And our teams are encouraged to view it from that perspective. And so that would come to my team where we would look at all of their communication as well as their player activity, and we would determine the next course of action. And depending on what we would see, if it's a milder concern, at a minimum, we're going to send an email asking how they're doing and for them to respond that they understand the risks associated with gambling and that they're comfortable with their current level of play. At a maximum, we will take measures to close their account and send them resources for problem gambling wherever they may be located. While no two situations are identical, we believe that by considering the player's activity and communication directly with them, we can reach a resolution and mitigate the potential for harm. For severe cases, we do not hesitate to close accounts and refer the individual to problem gambling resources. So we will always err on the side of taking care of our players and putting their well-being ahead of anything else. Slide. In addition to working with our customers to ensure they are having a positive gambling experience, we also make significant effort to keep those who shouldn't be gambling off of our platform. And Roman will talk a lot more about the technology behind this during his part of the presentation, but I'll just say that we work closely with regulators to ensure we are uploading the self-exclusion list into our system in a timely fashion and that our KYC process keeps them out. We also encourage those who may be considering a self-exclusion to do so and provide them links and phone numbers to these services. Much like the RG tools, we view the self-exclusion programs that these states offer as a positive, as a good thing. And if those who need self-exclusion, we're here to help them get to that application so that they can sign up. Like MGM Resorts, BetMGM abides by the American Gaming Association's Code of Sports Wagering Marketing and regulatory requirements to ensure marketing is tasteful, doesn't appeal to underage or vulnerable populations, and that we support responsible gaming messaging and problem gambling helpline information. As it pertains to cross-jurisdictional cooperation, we work with MGM Resorts on a daily basis to ensure that we're sharing our list of banned players so that we aren't cross-marketing to people who one of us know should not be receiving marketing or any type of enticements. We understand that problems with gambling don't stay within certain state lines, and so when possible, we will apply these restrictions regardless of where they were initially set. We believe that this collaboration stays true to the spirit of self-exclusion and helps support those who willfully enroll in these programs. Slide. In addition to working closely with our customer-facing teams, both my team and the marketing compliance team have a close relationship with our marketing teams. Frequently, we are reviewing content, providing training and guidance, and ensuring they have the most up-to-date requirements regarding disclaimer language. Some of the key areas we focus on are not marketing or creating content which would appeal to underage audiences, not promoting irresponsible or excessive participation in sports wagering, not misrepresenting the chances of winning or suggesting sports wagering will guarantee social, financial, or personal success, ensuring that problem gambling helpline is displayed on all ads, among other topics. And we do that through examples. So we like to pull ads that are currently out there that go over the line or near the line and talk about why it is that they're considered that way. Through this examples and through this knowledge sharing, we believe we can hone our marketing and ensure that we're meeting our commitment. Next slide. To close, I want to talk about our work with stakeholders and experts to help us improve our operations and contribute to the field of responsible gaming and problem gambling. We are proud to work with other GameSense licensees, including the Massachusetts Gaming Commission, within the GameSense community of practice. Having a forum to learn from other operators has been tremendously valuable. We are platinum members of the National Council on Problem Gambling and are active with state councils on problem gambling, attending conferences, chairing and participating in committees, but most importantly, listening to the experiences and challenges of those in the trenches. We also collaborate with providers such as the Dr. Robert Hunter International Problem Gambling Center here in Las Vegas to obtain information on problem gambling rates, comorbidity, and third-party harm to share within our trainings. We are proud to partner with the American Gaming Association's Have a Game Plan campaign, and we sit on the AGA's Responsibility Committee, which unites operators on responsibility efforts, research, and modernization. BetMGM recently joined others in the first industry-led responsible gaming standards. This 12-point pledge serves as a commitment to ensure safeguards, education, and consistent standards for online wagering. Finally, you may have seen that we recently contributed $180,000 to the Boston-based ICRG to help further the study of marketing and its impacts on gambling and problem gambling. While we understand that this is just a start, we're excited to see the results of the work, and we look forward to applying these learnings to our operations, as well as sharing them with the broader industry. We truly believe that we are better together, and through ongoing collaboration between our organizations, our peers, advocates, and the Massachusetts Gaming Commission, we will be able to offer our guests and customers a safe, informed, and responsible sports wagering experience. I want to close by thanking you all for your time. And again, I appreciate the care and concern we all share when it comes to responsible gaming. I now turn it over to our Director of Loyalty and CRM Optimization, Megan Twombly. Thank you.
Thank you, Rich. Again, echoing the sentiments previously shared, thank you for your time and your review and allowing me to present on our proprietary rewards program. And so Kennedy, to the next slide, please.
Now we can
Thank
see.
you. Apologies, trying to speak and turn the camera on at the same time. So what I'd love to talk through today is about how our partnership with MGM Rewards allows our players to participate in one of our industry's leading loyalty programs. So as such, when a player signs up for BetMGM Rewards, they're automatically enrolled into the MGM Rewards program. This enables our players to double up and stack the rewards by earning on both our BetMGM digital platform and also for anything that they have on property. So whether it's stay, casino play, or dining, they're able to earn into one consolidated loyalty account. And as players earn points and tier credits to move within the program, they're able to redeem their points for bonus credits towards sports play in Massachusetts, casino and poker in other markets, or they're able to convert them into MGM Rewards points, which are redeemable for complimentary food and beverage, entertainment, hotel stays, and more. As players earn digital rewards, they're also earning tier credits to unlock new MGM Rewards tiers for exclusive benefits, including waived resort fees, tickets to MGM Rewards concerts, room upgrades, and more at over 20 MGM resort properties in Las Vegas and nationwide. Kennedy, the next slide. So just diving into a little bit of how these two programs are really interconnected and rewarding a player with a rich offering, regardless if they're playing digitally or on property. So on property, they can earn on slots, table games, their stay or dining at the resort. Online, they're able to earn for either online sports wagers or casino and poker in available markets, or wager on sports in some of our BetMGM sports books that we spoke about earlier today in our hearings. And as such, they're going to earn both tier credits, regardless of digital and retail, and then that will help them move up through the program. So if you think about your airline loyalty program, as you fly, you start to unlock different tiers, and this program works in the exact same way. You are then able to participate from playing at home before your next trip to one of our fantastic properties. And then as you earn MGM Rewards points, you're able to redeem those for hotel accommodations, dining, entertainment, and more. And then for your digital rewards, the BetMGM Rewards points, you can redeem them online for either digital rewards or transfer them into MGM Rewards points to use on property. Kennedy, the next slide, please. And to give you a sense of what the earning looks like for a sports player, if somebody came in and wagered $100 on a straight bet, depending on the odds and somebody's tier level, they would earn at least 20 BetMGM Rewards points or more at different odds, and at least 20 tier credits for that wager. For a $100 parlay, we do incentivize that slightly more by rewarding at least 50 BetMGM Rewards points and 50 tier credits. And I'll leave poker and casino to, as we're not live in those products, excuse me. Kennedy, the next slide. And to give you a sense of what we have available in our loyalty store for players to redeem, these are examples that we have live in other markets, whether it's a $10 bonus to use on sports wagering or potentially a free bet. These are examples of what may be offered in Massachusetts. And with that, I will be turning it over to Anna Eliezer, our Head of Diversity, Equity, and Inclusion. And thank you for your time. Rhea, I'm not sure I see Anna online. Could you potentially just ping her?
Anna's on, but Anna, you're on mute. Sorry, all. This is like one of those memes about how many years we've been remote and we still struggle to.
And Sarah, we have an unusual platform, so nobody's concerned. Is it
Now?
We have you, Anna. Okay.
Okay.
There we go.
Sorry, I had to switch that over. I joined on the web, so pardon my delay there. Thank you, everybody.
If you could just get a little closer to your microphone or
Sure.
maybe increase your.
Move this even closer.
I want to hear you clearly. Thank
Yes.
you.
Can everybody hear me now?
I think much better. Yes.
Okay, great. Thank you for having me. Kennedy, if you can move to the next slide. Great, thank you. So just wanted to talk a little bit about our diversity, equity, and inclusion at BetMGM. The overall picture that I just want you to have for us is that we believe that DEI has to be embedded into everything that we do. Who we are, it's not separate, but it lives within our core values, and that is everything from internal to external processes and practices. So within those core values, we respect the game, where transparency and trust are our foundation. We show the love, which is through connection and personal moments. We know the odds, where we really heavily rely on the best data to inform us. And we play to win, where we know that our people position us for greatness. And these serve as our guiding principles, underpinning our shared commitment to continuous self-reflection, challenge, and improvement in order to uplift each other and meet each other where we're at. Next slide, please. So our DEI framework is really focused on 3 areas that are rooted in our DEI mission statement, our brand values, and our leadership principles. So the first one is include, and this is where we are committed to creating an inclusive culture for our team members, guests, and local communities. The second focus area is represent, where we are committed to representing the diverse communities in which we operate. And the third area is win, where we commit to using our diverse talents and skills to create a best-in-class experience for our guests as we lead the industry in responsible gaming. Next slide, please. So we have our strategic goals here, and I'd like to just start off our inclusive culture, which is our first strategic goal, by giving you kind of an idea of, so the results that were shared by SHRM from the upcoming National Study of Workforce Equity report have shown that nearly 2/3 of organizations say that DEI work is important, but only 62% have allocated resources toward DEI. I'd like to kind of just go into that with explaining where we were at. So in 2018, when we got started, it only took us a couple of years before I came on. That was 2020, the end of 2020. And there was a lot of grassroots employee-driven DEI work that was being done at that time. And it did not take long for the company to recognize that they needed to put something in place formally. So I came on at the end of 2020, and we formally launched the program at the beginning of 2021. And by 2022, Jaleel Morton, who is on my team, has come on this June. So we've really tried to set the foundation for a strong implementation of D&I by having dedicated resources to our program with now a little over 1,000 employees. In order to nurture this, cultivate it, we partner with our 7 ERGs. Our newest ERG is our Bet on Vets, which Rich is actually one of our chairs for. So very proud to have that newest ERG that just launched this year. And we do that by authentically trying to meet the communities where they're at. So we have, different partnerships that have come from that. So for instance, the Latinx Alliance, one of their main goals was financial literacy. And we actually were able to bring on an employee benefit with a company called Goal Setter to help create financial wellness. And that's available for free to all of our employees. Same thing with our women at MGM. Their development was one of the goals that they had. And so we were able to create a partnership with Progressive Women's Leadership and provide a platform for them for extended learning on leadership. One of the other things that we have done is bringing visibility to DEI concepts and best practices. So we do that by working in strategic partnership in key organizational areas of the business. So talent acquisition, learning and development, HR, of course. Another thing that we are doing is utilizing partners, like the ones I mentioned. Goal Setter is a great example. But we also have some partners like Storybolt and the Defensive Line, which are more focused on building empathy and awareness across difference. And then lastly, we encourage all of our employees to voluntarily self-ID. And I'm proud to say, as somebody who identifies as queer, that we now include LGBTQ plus identification for people to be able to self-ID. And then how do we have accountability for these things? We have an annual inclusion survey that is resultant in organizational actions. And we actually have created our flexibility policy around our first inclusion survey. And that took a lot of work and a lot of different people, but we really listened to our employees. We also have created an entire training program that DEI is embedded into based on what our employees told us in the survey. And so we're really proud of the actions that have come out of that listening that we've done through those annual surveys. We also have required company-wide DEI trainings on DEI fundamentals and allyship. We also have required people leader DEI workshops on inclusive leadership and allyship. And this is from the senior level to executive level in leadership. And we do workforce reporting as well. Next slide, please. So our diversity suppliers is our next area. And this is actually a newer area for us. I'm very happy to say that we have partnered with Supplier.io, a really great platform to help to build and scale our supplier diversity program. We will be doing this in Q1, actually, is when we have the goal set to have our those percentage levels actually set in stone. So we're working with finance right now. But the cultivating of that will come through including diverse groups in vendor and supplier considerations, as well as cultivating connections with diverse bidders to leverage in partnership. The ERG relationships that we create as well will be a part of that, such as engagement with chambers of commerce and things of that nature. And then the accountability will come with working on the implementation, like I mentioned before, of the annual spend goals for that will be also across departments. So not just for the company, but in each area of the business, and then supplier reporting on those goals and how we are tracking toward them. Next slide, please. And then lastly, we have our workforce diversity. So how are we implementing this? We actually are already using artificial intelligence tools to generate gender neutral and inclusive job descriptions. And I am proud to say that Labor of Love is finally coming to fruition this coming year. We will be launching it's called Empower Mentorship Program, which is going to be available for all of our underrepresented members of the organization. So super excited about that launch coming in Q1. How are we cultivating this? So we're driving our underrepresented talent attraction through long-term institutional relationships with job postings, messaging campaigns, career fairs. And we have established relationships so far with ACES, which is American Indians in STEM, Lesbians Who Tech, the Athletes Unite Conference, and we are building relationships with the community through the ERGs to increase our brand visibility and company culture, and hope to identify and attract a more diverse talent pool to the company. And I think probably the best example of this is our partnership that we have right now with the Tom Joyner Foundation, which works with historically Black colleges and universities across the United States. We are doing an executive series with them, so going from different school to different school and having different executives talk about what they do and why BetMGM is an exciting place to work, letting the students have access to executives and ask questions, as well as our talent acquisition team so that they can help them review resumes. And we have exclusive, actually our first internship program will be exclusive for those students who are part of the Tom Joyner partnership. So that will be coming in 2023 as well. So we're very excited for that. So hopefully doing more things like that in the future as well. And then the accountability is, required inclusive performance management training, which is going to be rolling out this coming year. Or sorry, performance management is already there, but the inclusive hiring is going to be rolling out in Q1, which I'm very excited about as well. Annualized DEI goals to increase representation, and strategically structuring interviews and interview guides to help support equitable processes throughout the entire interview process. And so with that, I look forward to answering more questions from you all when it comes time to it, but I will hand over for now to Roman Rubas. Thank you.
All right. Thank you, Anna. Afternoon, Madam Chair, Commissioners. Thank you for the opportunity to present BetMGM's technology. Next slide, please. So BetMGM's proprietary mobile platform is live and tested in 19 jurisdictions. 18 of those jurisdictions are listed here that have been tested and certified by Gaming Laboratories International. It should also be noted that several of those jurisdictions, like yourselves, have either adopted or observed the GLI 33 technical standard. Jurisdictions such as Arizona, Iowa, Michigan, and most recently Ohio. Anytime that there's a requirement for annual security testing or penetration, or security assessments or penetration testing, we do contract that work out to independent third party in Bulletproof, which is GLI's provider. And actually, that's good for now. Next slide, please. So BetMGM's geofencing solution is fully integrated with GeoComply. It utilizes the location services on the player's device along with an SDK that's embedded within the app. So what I have on the right-hand side here is an example of an error message that a player would receive. Based on the type of error that the player receives, it'll potentially show them some troubleshooting information. This example here, they're showing them how to enable their Wi-Fi to hopefully improve the data points that are collected to be able to better locate that player. The BetMGM platform also allows players to place wager using desktop through a plugin that's provided by GeoComply. And as I transition over to the demo, I will be using our desktop product to demonstrate that. So if there's no objections, if I want to cover any more on the technical requirements or the geofencing requirements, I can transition over to the demo if there's no concerns.
We can go right into the demonstration. Thank you.
Excellent. Thank you. Okay, can everybody see the screen?
If you could make it a little bit bigger, are you able to do that?
This?
A bit?
Does that look better?
Commissioners, agree? Commissioners, are you able to see that okay? I can't see anybody's reaction, so you'll have to say yes or no.
I can see it just fine, Madam Commissioner.
I can see it.
Okay, we're good then. Thank you.
Excellent, thank you. So one thing I'd like to show you guys as I tab through the sports books in Colorado, Indiana, and New York, the consistency of the layout, the sports listed across the top, BetMGM's logo, and the jurisdiction underneath it. We always have the RG logo displayed in the header, and then the ability to search for players or specific events up in the header. We also have, again, comment to the layout, we have this showcase carousel where you can showcase different markets that we want to call out, and then the general layout of the sports books. For demoing purposes, I'm going to run through registration on Indiana, and then I'll come back and log in and place some wagers in our New York sportsbook. Should be also noted that we offer help and contact when we're logged out. So if I were to select this option, I'd be taken to some troubleshooting screens and then the ability to contact customer support. There's 3 different locations that we offer this link. What I'll do is once I'm logged in later, I'll run through that journey, the player's journey for that. So as I go through registration, BetMGM uses what we call conversation registration. So what we do is we work with the player on each step of the registration. The first step is to sign up with your email address. Second, create your password. So as I'm meeting all the criteria, you can see the details below are being checked off. Everything is green, everything's happy. I'm now able to move on to the next step in the process. Enter the player's name. It's important to note here that we also advise the player to enter the information exactly as it appears on their government documents. This is for better accuracy with our KYC providers when verifying those players. We now ask the player to enter in their last 4 digits of the Social Security number. As part of our KYC process, we're able to utilize the service by one of the providers that's able to try to match the first 5. If they're not able to match the first 5, that step will fail and the player will have to enter in their full 9 digits of their Social Security number. Next is the date of birth. So if I enter any date of birth that is below 21 years of age, I'm shown an error message. I'm not able to progress any further through the registration form, and the next button is grayed out for me. For the date of birth that's over 21, I'm now able to progress. for your mobile number. And this is not my mobile number, but it is a mobile number. The last step before going to the terms and conditions, it's going to ask you to enter in your address. We utilize a address finder feature. So if I start entering in an address, I can select from the drop down and it will populate those fields. And then lastly, I'll go through and acknowledge the terms and conditions that I'm over 21 years of age and I'm not a prohibited player. And the last thing to do is once I've checked those boxes is select the create account option. I'm not going to do that on this because this is a production environment. But essentially what happens when the player hits create my account, it takes the details that they've just collected or that we just collected. It sends them out to the KYC providers where they look to verify social security number, age and identity, and then finally address. The platform receives pass-fail responses from the KYC providers to determine whether that player is verified. Additionally, as part of that check, you have OFAC, PEP, and deceased checks that occur. So if somebody is on those lists, they'll not be able to create an account. Once the player is KYC verified, the platform then takes their information and runs it through the system against the self-exclusion list for the state to ensure that this player is allowed to have an account. And that is registration. All right, from here, I will log into my New York account. So as soon as I log in, I'm shown a toaster message up top that shows the last time I logged in. From here, again, going across the top, you can see the BetMGM logo, the jurisdiction that I'm logged into. We have the RG logo. So as Rich Taylor pointed out, brings you to our GameSense pages. One page I like to cover here is the state-specific pages. So any information that Massachusetts wants displayed can appear on this page here. Back. And again, coming back to the RG logo, the ability to search for markets. In the upper middle, we have the session timer that's always displayed to the player, so you know how long you've been logged into the sportsbook. And from there, I think I'll place my first wager. So looking at the first market that's available here, you have the Rams and the Packers. Let's say I feel good about the Rams. The bet slip populates on the right-hand side. You're seeing the team that you selected, the current pricing, and the stake the stake on the bet that you're going to place. I go through and place my bet. Everything's green and happy, and that bet is now placed. If I want to go back through my bets and take a look at any other details, so I can tab over to my bet section. From here, I can see the bet I just placed, the stake, and my potential odds. If I want to go beyond any open bets, I can click on the Settle tab. I have the ability to go back through specific time periods. I can look at any wagers that have, all winning wagers, any lost wagers, any canceled wagers, and have those details available on the right-hand side here. If I need to contact customer service, I can drop this little arrow down. I'm provided with the bet slip ID and the specific time that bet was placed. So again, I can contact CS, provide them that number, and they can look up the specific bet in the system. Additional feature I think we can touch on real quick is we offer the ability to cash out a wager. So we have here the ability to cash out at 50 cents. So I can basically go back and cash that wager out. So there's my confirmation. There's the details of the cash out. And then that'll now also appear in our settled wagers. One of the features that I'd like to go over that's unique to BetMGM is our ability to edit bet. So if I go through, place another bet, place it on the Rams. I have a link here to go through and edit bet. So by clicking this link here, so essentially most of our competition offers the ability to cash out a wager, which puts that money back into their wallet. They then go back to the sports book. They can go place another wager. If I edit my bet, you actually save an additional step. So if I decide to change from the Rams to the Packers, I can make that selection and confirm. And once it's placed, I get the green messaging that it's successful. All right. So going back up to the top, when I click on my account avatar, we're showing the MGM rewards information for the player. I know that there's a lot of discussions about the information being passed back and forth here. So when a player registers on BetMGM's platform, that player information is sent one way to MGM. MGM does a lookup against their player database, and all that BetMGM receives of response is their M-Life number, and then any tier credits that they should be receiving. I'm able to see my wallet breakdown. So if I have any bonus money or the amount of funds that I can withdraw from. If I choose to go into the cashier, you can see our cashier tiles. This is a dedicated cashier for New York. So conversations around whether credit cards are allowed or not allowed. Every jurisdiction has their own dedicated cashier. So these tiles can be changed based on what's allowed or not allowed in the jurisdiction. Going back up to my avatar. As I scroll down, I'm going to go to my responsible gaming limits. So Rich touched on these briefly, but just to see them from the user's perspective. So what I have here in my deposit limits, we offer a daily, weekly, and monthly limit. I currently have a $5,000 monthly limit set. If I choose to remove that, I can uncheck this box, hit submit, and I'm provided again a green message saying that it's been successfully opted out. So we provide information to the player at the bottom that calls out that if the value in the text box is different from the current limit, the requested limit is not applied. So this goes back to our waiting periods that Rich had spoke about. So if I click this link, we have the breakdowns of daily limits, weekly limits. I can see that my monthly limit, if the month has 31 days and it's done before the 28th of the end of the month, I can expect that limit to be updated on the 1st of the next month. If I make my change between the 29th and the 31st, I have to wait a full month, and the 1st of the next month, I will be able to see those limits updated. Additionally, there's information for 30 days and also for leap years. All right, going back to my responsible gaming section. If I want to time out from my from playing. What I like about New York's timeout pages, the state actually has their voluntary self-exclusion information right on this page. This is customizable based on what the regulator would like to see. What we have here is a link to the New York form to fill out. The player can go to this form, fill it out themselves, and it'll be sent back over to BetMGM. If I don't want to self-exclude, I'm able to select this timeout button. If I do choose the timeout, we have information to the player here that details what they're allowed to do with their account. So obviously you cannot place any wagers, you cannot make a deposit, but you will still be able to withdraw your funds. And you will not receive any promotional or bonus notifications or emails. So if I choose to continue, again, I can select the time period and a reason. And this is where I will stop, because when I hit continue, I will be timed out of my account. So an additional feature I think it'll be good to go over is this strong authentication. So essentially what this does is if a player chooses to opt into strong authentication as part of the login process, once they enter in their username and password, they'll be sent a PIN number to their mobile device. They'll have to enter that PIN number in, and they'll then be able to proceed over to their proceed into their account. And I think with that, that should be everything that we've been demoing today. Is there anything specific that you'd like to see that I did not cover?
Roman, could you go back to your page, please? It was just 2 pages ago. You had your dual factor authentication. It was just the one before on limits. Just pertinent to all regulation settings for, I think, opting out.
This page here.
That's responsible gaming limits. I'm looking for the opt-out times.
Oh, timeout, yes.
Timeouts, yes, please. And then the next page where you showed the different options. There we go. So you select the period you wish to exclude. It goes from, that's 3 days to a week, to 2 weeks, to 3 weeks, to 4 weeks. And then what's that?
So this I can set a specific date within the year.
Date. And then you have 1 year timeout.
So yeah, and then I can.
So you could actually
specify 1 year timeout.
So, and how much notice does your app provide for if you're running out of, if you're approaching your timeout limit?
So once the limit expires, the player is displayed a message that the limit has expired if they would like to extend it or remove it.
So it's upon expiration, you provide notice.
Yes.
But you don't provide necessarily it's approaching notice. It's just upon expiration.
Not from the platform. I don't know if we have internal controls.
No, I just wondered. That's helpful for us to think about, commissioners, right?
Madam Chair, if I may, it's Richard Taylor, Senior.
Hi, Richard. Yeah.
You know, I've thought about this question a lot over the past couple of years. And one of the things that keeps coming to mind is when somebody sets a cool off, 9 times out of 10, it's for a reason related to concerns about their gambling and problem gambling. And so if we were to reach out to them and let them know that this cool off is going to be expiring at a future date, my concern is that it starts a countdown timer for when I can get back to gambling, and raises excitement levels that frankly, I don't know if I'm comfortable with. Now, there's an argument to be made on the other side where obviously you can offer them the ability to extend that cool off for that timeout. But for me, I don't know if I'm there yet. Obviously, whatever the commission requires us to do, we will meet that requirement. But from my perspective, I just have some concerns about notifying somebody that their cool off is going to be expiring in 10 days, a week, or whatever the time frame may be.
Very helpful, Richard. Thank you. Thank you. And I interrupted just because I did want to look at that page. Commissioners, while we have Roman and the technology, do you have anything about the device itself that you want to follow up on? Roman, and you might be continuing on too. I might have, you still have more to.
You know what? I actually just realized I meant to touch base on customer service as well.
You did reference it at a high level, yes.
So if we're going to access customer, if you don't want to see, I can end the presentation right here.
This is good, please, thank you.
Okay. So if I want to contact customer service, I'll go to my account avatar. I'll select the option here. We offer the player troubleshooting steps before connecting with an agent. So let's say I have an issue with geolocation. We're able to provide the players videos to help get them through the issue they're having. If the player is still not able to resolve the issue on their own, you're then taken to the contact page. So we can select the live chat, which is available 24/7. We have limited hours for phone contact, and then obviously email.
Madam Chair,
Yes,
I know we usually hold our questions to the end, but I think this one should be a red flag for a couple of us looking at this screen, or at least for me for sure. And that is the hours of operation available to a live person on the phone. I see the hours are from 11 to 8. And I think I have voiced some concern, as have others, I don't want to speak for them, about the availability of a real person. And we were educated last week that there are times throughout the day that not a lot of people will be betting. So they've cut back their hours, but that was only, if I remember correctly, when we were being educated on that, maybe it was like a 4-hour window. This looks to be a very big window without the opportunity for someone to be able to call if they have an issue. And I know you have live chat 24/7, and I see the little hand going near that. But there are many like myself who would like to be able to contact a real person and not a live chat. So could you just speak to that issue, please? And thank you, Madam Chair.
That one I probably will hand off, but I believe the determination for the hours of availability are based on the regulatory requests. So if a regulator wants 24/7 phone support, it's something that would be available. But if anybody else wants to jump in on the operations piece.
Hi, Sarah here to talk about the regulatory requirements. So we do track and manage this across each jurisdiction within which we operate. Some jurisdictions don't require phone support at all, other than for a patron to be able to email in and say, please have someone call me. Other jurisdictions have limited phone hours that are required. And so we would obviously adhere to whatever guidance you all set forth for what your expectations would be with respect to staffing phone lines. So 11 to 8 is an example, and that's most commonly found because it's the highest volume of calls that we get across all of our jurisdiction is within those business hours. But we track it constantly internally within our CS operations department and manage according to volume.
Madam Chair.
yes,
So you've answered the question why it's 11 to 8. if we weren't to regulate how many hours something has to be open, I would assume then it would be 11 to 8 in Massachusetts,
Yes.
unless we were to do something regulatory wise. Is that what I think I just heard?
Yes, sir.
I have a
Okay.
follow-up, Madam Chair. Oh, sorry. Sorry, Brad.
I said, okay, I hear the answer and I'm not sure I like the answer, but I understand the answer.
Thank you. Commissioner Maynard.
So I have a follow-up. If in the live chat function, one was to type, my entire life savings was, transferred, would they get a call even if it was outside of these hours? Basically, would the live chat move quick enough to get someone on the phone for someone?
Yes, that's a great question. And Rich Taylor, as you heard speak earlier, has established a very well developed SOP for CS escalations of players who either threaten self-harm, harm against an establishment, or responsible gaming problematic behaviors, express any sort of issue with their play behavior or concerns that then are immediately flagged by a CS agent, escalated to their supervisor, and then according to the content of the conversation is escalated in whichever path is most appropriate, including a call from a supervisor, a wellness check from the local police authority, escalation to property security if that's the case, if it were, let's say, a threat of harm against MGM Springfield. Rich, did I miss any of the details?
No, you've summed it up pretty well. And one thing I just want to emphasize here is that we try to press authority to take action that needs to be taken to the lowest level possible. And so CS supervisor is one call away from the agents fielding the initial calls and issues from the customer. So they don't have to get to me for us to take care of a customer and send out a police department if that's what's required, for example. So we try to give our supervisors the ability to make decisions on the scene as quickly as possible.
Commissioner Maynard.
No, thank you. What about $10,000 being transferred?
Well, so amounts, that's a tricky question when it comes to RG and PG, because $10,000 means a lot different thing to me than it may mean to say, or to Michael Bloomberg or somebody else who has a significant amount of money. So we tend to focus more on behaviors and what the context of that conversation is. If it is, I need to get this deposited because I need to get on a hot streak to put food on the table, then of course we're going to escalate that as quickly as possible, because that means something a lot different than, hey, $10,000 is a drop in the bucket for my bankroll because I am of extraordinary means, not me personally, unfortunately, but for those who do have the income and the ability to deposit $10,000, it's usually a customer, friction issue rather than a problem gambling issue. So it's all about the context. And I think training our employees to understand how to interpret context and the why really helps us to decipher what's going on and if it needs escalation or not.
Got it.
Can I just back up a little bit when we say live chat? Does that include AI predominantly, or is it truly another human being? It's just not a phone.
Right. We don't utilize AI at this point.
So this is Commissioner O'Brien. Can I ask what languages are available when somebody calls on the phone?
English right now, Commissioner
Just
O'Brien, but we're actually in the process of establishing our Spanish support helpline and websites to provide that support for our patron and user experience. We do have Spanish speaking agents, but it's not formal.
Okay. Any other plans for any other languages aside from Spanish?
I don't know offhand, I'm sorry, but I can look into it and get back to you.
That would be great. Thank you.
That's really helpful. I'll set commissioners on this. And I thought, Commissioner Hill, I think it's appropriate to the extent that we're looking at the technology that Rowan, it was appropriate to ask her a question. So commissioners, if you want to go back to Rowan now, he's going to be around, I'm sure, if we need to. Wow. Okay. Great. Sarah. Or is it Ms. Loney? Are we on?
Yeah, actually, I think I'm going to hand it back over to our Chief Compliance Officer, Rhea Loney. Thank you.
Great, thank you.
Commissioners.
So Ms. Loney, is that the completion of your presentation?
That concludes our presentation, Commissioners. We open it up to you all for questions.
Okay, if you could take down the screen, that would be really helpful. Okay, Commissioners, it's 3:25. We will turn now to our internal experts. We hold our questions, Ms. Roney, until we start to proceed section by section of the application. I want to offer Commissioners the opportunity for a quick break. Or are you all set to proceed with our internal presentation? No one's asking for a break?
I'm all set to move forward, Madam Chair.
Okay. Then we're going to turn now to, thank you first off for the presentation. If I did properly, thank you, Ms. Loney. Excellent work by, and we love being able to hear from so many members of your team. So thank you. Everybody did an excellent job. Moving on to our own presentation, we're going to hear from, I think perhaps our Chief Information Officer is available today, maybe not, but otherwise we have GLI members, as well as our IEB, as well as them. And my friends at GLI, I want to just make an introduction. There we are. I see Joe. So GLI is the first to write and set gaming technical standards that are now considered to be the industry benchmark worldwide. GLI has continuously responded to the industry by innovating new standards and testing, allowing regulators to feel confident that they're providing a safe, responsible method of revenue generation for their stakeholders and preservation of integrity. So I think I see a few representatives. I'm going to let you folks introduce yourselves because they're switching up as we go along. Good afternoon, gentlemen.
Good afternoon. I have with me Gabriel Benedict, account executive here at GLI, who handles your jurisdiction, and Matthew Toller. He's got over 20 years at GLI in technical compliance. So I'll actually, and my name is Joseph Bonavith, Director of Client Solutions at GLI. Thanks for having us. Madam Chair and members of the Commission. I'll give an overview of the submittal, certification, and verification process regarding mobile applications and other digital platforms approved by the Commission. Before we can take submittals, the Mass Gaming Commission must approve 205 CMR 247 and 248. That list has gotten smaller now. Thank you very much for approving 138 and 238 last week, which we drafted in consultation with your staff and an outside law firm. After approval, the operators will prepare to submit their code bases for the entire sports wagering systems they intend to deploy. The submittal preparation includes the following. If it's a platform we're familiar with, a modification list from the last submission to one or more U.S. jurisdictions will be requested and reviewed to set the project plan for Massachusetts, considering any specific changes to the platform and all Massachusetts rules and regulations. If the product is new to the lab, we will review the technology architecture documentation, which is a complete, comprehensive, technically accurate description and explanation of all sports wagering systems. This will include a description of all hardware, devices, and virtual servers, all server and client software modules, including the software versions, the layout of all network communications between the various software and hardware modules, and an explanation of all third-party integrated systems. Post the technical documentation review, critical files regarding compliance will be identified and documented. A complete project plan will be put in place, taking into account the unique architecture and design of the platform and the specific Massachusetts Gaming Commission rules and regulations. The lab will run a supervised compilation of those source files, the signature of those files, and the compilation steps, and the signatures of all compiled code. Once complete, the source code can be submitted for testing in a lockdown environment. GLI review the player account management platform known as the PAM for registration, age, identification, verification, account controls, payments, reporting, responsible gaming controls, required disclosures, and geolocation. Geolocation testing commences in two parts: a field test to verify borders through sampling along the entire border while completing edge case technical tests. A field test will also cover any other restricted areas as defined by the MGC. A subversive workaround detection will commence in the lab, including but not limited to VPN and proxy usage, GPS spoofing, code manipulation, and man-in-the-middle attacks. GLI will verify the sportsbook in total, if not tested previously for the retail deployment, or review the integration of the sportsbook into the PAM for events, markets, point spreads, bet acceptance, and corresponding timestamps and logging. We will verify the enforcement of betting limits in all edge cases and the pre-event and live data feeds, post-event bet settling, corresponding timestamps, and all logging and reporting. We also review the change management process and procedures. After all the technical checkoffs are met, certifications can be issued when GLI verifies the changes made for Massachusetts-specific deployments, including source code differential and change testing to the latest reviewed version. And GLI has evaluated that all the product has met all the requirements specific to the Massachusetts Gaming Commission rules. After certifications are issued and MGC accepts them, field verification will be conducted in conjunction with the MGC. This procedure will be finalized in the upcoming weeks. During that time, the following will commence: verification at the production server, verify all critical file and signatures, and review of internal controls for procedures to operate the book, check technology for configurations such as proper setup or roles in user right management assignment, and potentially interview key personnel to ensure they know and will follow procedures from the internal controls. At that point, the operators and suppliers that have met the technical requirements for it, they will be able to operate a sportsbook according to acceptance by the Mass Gaming Commission.
Okay, thank you, Joe. You and your colleagues will be available for questions.
We are here, yes.
Thank you so much.
Yep.
Okay.
Thank you.
Thank you. So then next we'll turn to, bear with me as I take our lengthy agenda. I see it's Kathleen Kramer of our IB. Good afternoon, Attorney Kramer. We're going to hear from you as to report on the suitability of the applicant.
Thank you. Good afternoon, Chair and Commissioners. The IEB submitted a report regarding the preliminary suitability of BetMGM LLC. This applicant is seeking a Category 3 license to be tethered to the Category 1 licensee, which is MGM Springfield. The IEB performed this review for preliminary suitability in accordance with the standards and criteria set forth in 205 CMR 215.01 subsection 2. As a precursor to this review, the licensing division, in conjunction with the IEB, performed a scoping review of the applicant under section 5B of 23N, and we identified 4 entities and 7 individuals that we designated as qualifiers in connection with BetMGM's application. Those qualifiers are listed on pages 1 and 2 of our report. The licensing division has performed a review of the existing submission for deficiencies, and there are no substantial deficiencies. There have been ongoing communication over some pieces. The applicant has been responsive, and nothing significant is outstanding. And as mentioned, the IEB's review was performed in accordance with the reg, and that is set forth on page 3 of the IEB's report. I note again that this review was done for preliminary suitability, and we did not perform a full suitability investigation at this time. Our team was comprised of contract investigators, including former members of the State Police Gaming Enforcement Unit, Attorney Mike Banks and his team, as well as contract investigators from the firm of RSM. And their work was performed with the collaboration and the oversight of the IB, of course. The review for preliminary suitability is summarized in the report, and it includes the following: a summary of BetMGM's licensing status as disclosed in its application, a summary of its compliance history in other jurisdictions as disclosed in the application, a summary of pending litigation valued at over $100,000 as disclosed in the application, a summary of open source review of the applicant, individual qualifiers, but not entity qualifiers pursuant to the reg. And with respect to the RSM side, that team prepared a report that appears as Exhibit 1, and they reviewed disclosed financial information of the applicant. In this case, their review was supplemented by financial filings of the publicly traded ultimate parent company, MGM Resorts, as filed with the SEC. RSM presented financial ratios. They reviewed forecasting submissions submitted by the applicant in its general application, and they summarized self-reported history of judgments. At this point, I would otherwise rest on the report that we submitted to the commission, and of course, we will have members of both teams available for any question that the commissioners may have.
Thank you, Kathleen. Now we'll move on to RSM. Thank you. Good afternoon, Jeff.
Afternoon, Madam Chair.
I assume you may have colleagues joining you, or are you on your own today?
There'll be some that are with us, but I'll be on my own in terms of presenting.
Okay, so RSM US LLP is one of the leading providers of audit, tax, and consulting services in the United States. RSM has been working with the Massachusetts Gaming Commission to provide insights and analyses to help the commission. And Jeff is our lead today, and he leads RSM's strategic finance practice. And we have asked the team to look at precisely sections B2, section D, sports wagering experience, description of sports wagering operation. RSM has been asked to focus on applicants' estimated market share with each jurisdiction, as well as section C2, the projected revenue section. RSM has been asked to provide insights into all aspects of the applicant's projected revenue. We've asked them to also look at G3, financial stability and integrity. RSM has been asked to provide insights into all aspects of the applicant's financial stability and integrity. And this exercise is in addition to the work that they did in connection with the suitability report that we just heard from IEP on. Is that a go for you, Jeff, now? Please feel free to elaborate on your experience.
Perfect, yes. Thank you, Commissioner. Hi, everyone, Jeff Katz here, part of RSM. I lead our strategic finance and FP&A practice, and I'm based in Boston. I was instructed by the MGC. We conducted a preliminary review of each Category 3 applicant's market share, submission materials in tandem with other investigators involved in this process regarding the Category 3 temporary license process. Much of the information shared is likely confidential, including market share and projections. We're happy to discuss those items in detail in an executive session. We're happy to speak generally about the process by which the applicant shared such information in this public forum. In RSM's preliminary market study, the jurisdictional rules and what other nearby markets are doing may impact any of these applicants' market size and sportsbook composition in a given state. For instance, when Massachusetts goes live, it is probable that neighboring states will see a decrease in sports wagering activity as patrons stay home and place their bets rather than crossing state lines to do so. Given the evolving nature of the online sports wagering and the varying number of platforms in different jurisdictions, it is difficult to predict the ultimate composition of the marketplace, even after conducting extensive market research. But we can say it is being viewed as a lucrative long-term growth market by operators and industry analysts. Some analysts are predicting plus 10% CAGR, compound annual growth rate. If all applicants currently pending review are ultimately granted a license, Massachusetts would end up with an above average number of sports books operating in the market. In jurisdictions where sports betting is legal, there are between 1 and 25 sports books operating in individual states. For example, New Jersey has 25 sports books, Pennsylvania has 14, New York has 9, Connecticut has 3, and Rhode Island has 1. That is broadly associated with a larger ultimate market size and a lower hold percentage benefiting the consumer. Hold percentage is, for your reference, percentage of total wagers or the handle kept by the sports book. And this, of course, is still developing. It is anticipated that, and we're already seeing some consolidation will occur in the industry, both through merger activity and operators exiting the business unable to sustain losses. Speaking broadly, the online sports wagering experience of the Massachusetts applicant pool has varied levels of industry experience. They're represented by both domestically and international players, and some have decades of experience, and others are still in the process of building their platform. The Commission has received IEB's report addressing the suitability review led by the team, and that report is a review of the applicant's self-disclosed financial submission, looking at a select few sections of the application, those being section C2 and G3, broadly comprising historical financial performance of sports wagering in other jurisdictions, liquidity and ability to fund upstart costs and losses, financial projections in Massachusetts, and financial impact of compliance risks, bankruptcies, and other legal items. We understand that the purview of the IEB's report was intentionally limited in scope to provide the Commission with facts from which to draw their own conclusion. RSM intends to speak broadly about the applicant in front of you today. BetMGM is equally owned through a 50-50 partnership between US publicly traded MGM Resorts and UK publicly traded Entail PLC. The applicant provided financial disclosures for BetMGM and Entain. MGM Resorts has previously been issued a determination of suitability, and our review is limited to select public filings. The applicant provided high-level projections for operations in Massachusetts under 3 operating scenarios. The forecast methodology to estimate the total Massachusetts market size and gross gaming revenue, and then apply a market share percentage. This is a different methodology than some of the other applicants, but it is an entirely valid way to make a forecast. This methodology results in fewer data points to compare to industry standards. You know, for example, there's not a handle or hold, but this should not be seen as negative or strike. The projected market share capture rate percentage is constant through the 5-year forecast period. The applicant projects growth in the total Massachusetts addressable market each year of the forecast and multiplies these estimates by a static market share percentage. This estimated TAM is very conservative or low in year 1 of the projections that BetMGM provided and grows into a reasonable estimate by year 5. We note from experience, other jurisdictions scaled quickly upon the online sports betting rollout, then settled into a single-digit annual growth rate thereafter. If this were seen in Massachusetts and the applicant's projected market share capture were realized, they would significantly outperform their projected revenue figures. We view these projections as reasonable and in many ways conservative. Turning to liquidity, as stated earlier, BetMGM is an evenly split joint venture owned equally by MGM Resorts and Entain. Both parent entities have been providing financial support and technical resources on an as-needed basis. Both MGM Resorts and Entain are publicly traded organizations and have been reporting their financials to regulators. As presented in their publicly available London Stock Exchange traded filings as of the second quarter of 2022, Entain reported approximately $567 million in available liquidity to support its ongoing operations, comprised entirely of cash. RSM has identified that $236 million is payable in the next 12 months on Entain's total long-term debt balance. As presented in their publicly available SEC filings, as of the third quarter of 2022, MGM Resorts has reported $7.3 billion in total liquidity, comprised of $5.3 billion in cash and $2 billion in an undrawn revolving credit facility. RSM has identified that $1.5 billion is payable in the next 12 months on MGM Resorts' total long-term debt balance. Both parent companies have a capital cushion from which to fund operations. It is ultimately up to the applicant's parent on how to allocate its financial resources. If faced with future losses, there is no guarantee it will continue sports wagering operations in Massachusetts, but they seemingly have the resources to do so if they desire. RSM will remain on the line to answer any questions the commission may have about this presentation or our written submission. If there are further specific questions on the contents of our report, we are happy to discuss those in an executive session. Thank you.
Thank you, Jeff. Commissioners, now we can turn to our own evaluation of the application itself by going through the application on a section basis. As I've said in the past, at the conclusion of our review of each section, I'd ask for any comments you'd like to share, and we could get every question answered from both the applicant and our other resources, and then we would try to learn whether we have a consensus as to the quality of the response to each application. Before we begin this, do we need to take a break? It is 4:15.
I could use 5 minutes. Just
Okay,
5.
and perhaps my frequent request is that I too could use 5 minutes. So if the applicant will bear with us, it's 4:15. We'll come back at like 3:50, Commissioner Maynard, and get right to business. Thank you so much. Thank you, Dave.
Good to go.
Thanks so much. I think that Commissioner Hill might be.
I am here, just having
There you
issues
are.
with
Yep.
the video, so
Yep, there
thank
now.
you.
I just had to find your name. Thank you. He's just transitioning to that. All right, so this is a reconvening of the Massachusetts Gaming Commission public meeting number 414. And I will take a roll call because we're using a virtual platform. Commissioner O'Brien.
I am here.
Thank you. Commissioner Hill.
I'm here.
Commissioner Skinner.
I am here.
And Commissioner Maynard.
I'm here.
Okay, so we'll get started. Now we're going to proceed through the application. And I'm getting my notes organized. We're going to start with section B and individual questions on section B.
Madam Chair, I have a question.
Yes, go right ahead, Commissioner Skinner.
Thank you. BetMGM, are you licensed in Maryland or no? I thought I saw reference to the application being filed in October 2022. But then I know that there's some activity occurring in that jurisdiction. Could you clarify, please?
Yes, Commissioner, we do now hold licenses in Maryland. That's correct. When we submitted this application, we were likely in the process of applying, but we are now licensed.
Okay. Is there any other additional one, Ms. Loney, that you want to mention that's updated, or is Maryland the only one?
I believe that is the only one. Let me confirm. Correct, that's the only one.
That's fine. Other questions on section B? I'm just going to follow up with the presentation, and then maybe the commissioners will have a chance to look at their notes. You indicated that your compliance department has increased, and that's to be commended, from a very, a small handful to now 75 members with 40 on operations. When we're learning as we go in terms of this industry, and when there are compliance matters or issues that come up, can you describe to me the process and how it might flow to what I imagine would be with respect to the compliance committee? And if you could describe that process, and then also the membership of the compliance committee.
Yes, Madam Chair, we have a 3-person compliance committee, and we have a overarching compliance plan that's been approved by our board. The 3 members of our compliance committee are comprised of 1 member from each of our joint venture parents, MGM, and 1 member from Entain, and then an independent member. There are requirements to have additional expertise in the gaming industry. The compliance committee does hold quarterly calls and meetings, and at that meeting, we will go through any matters, any incidents. We'll follow our compliance plan. We'll go through any vendor due diligence, and then that will be reported through the compliance to the compliance committee at that quarterly meeting. In addition, we hold meetings in between each quarterly meeting, just due to our growth and scaling. And as you all know, the industry is changing very frequently. So we do coordinate with them more frequently than quarterly.
Thank you. Questions on first section B, Commissioner Skinner.
Thank you. I have a question about the share my bet feature of the online platform. Not sure who to direct this question to, but the individuals who get forwarded a patron's bet information via text, email, or social media, does that recipient's data, their information, is that retained at all in any capacity by BetMGM?
Commissioner Skinner, if you do not mind, I would like to ask Roman Rubis with our technical governance to join. I believe the answer is no, but I'd like him to confirm that for me. And he can share how that's shared.
No, that's correct. We don't store that player's information that's being sent, the bet details. Additionally, if I send somebody my bet that I placed on the platform, what they receive is essentially access to a logged out state of the sports book. So they would have to go back, and whoever I send that bet to would actually need to go through the KYC process, create an account in order to go ahead and place that bet that I just sent them.
So what information does a patron, a bettor, need to provide in order to share that bet information?
So if I select the share my bet option, I'm presented with a screen where I can input one of my buddy's email addresses and send them a link to that bet slip.
And it's just in that example, it's just the email address. It's not first name, last name, or anything
Correct.
beyond
Yeah,
that?
no personal information. Correct.
Thank you.
Commissioners, other questions? One of the, Commissioner Maynard, are you asking, one, we have been trying to learn more about the practice of pre-registration of customers, and we have not devised a regulation around that, and have been advised by GLI generally that there are no states with regulations on either pre-registration, in other words, registration of or customer cultivation and registration prior to licensure, and also no regulation in any other state that prohibits reloading or loading of the accounts. And in fact, GLI said that is a general practice across the across the industry. And when I think I asked that question, it wasn't, it was really around issues that I think Commissioner Maynard and I shared around equity. It's because we did decide to launch retail in advance of online gaming. Commissioner Maynard, you can chime in. I am only speaking as to Massachusetts right now, but to the extent that this is a general practice and it's not something that would put anyone at a commercial disadvantage, do you know, Ms. Loney, if that's happening with Massachusetts, and also whether there's loading of accounts? In other words, if this is something that needs to be discussed in executive session, I'm fine with that, but I am only talking about the anticipated practice for Massachusetts.
Madam Chair, I will only speak for our operation in that currently we are not doing pre-registration in Massachusetts. So I think we would ask the commission to have further discussion around, what you all would like to do for that. I can say that it is generally industry practice to allow some sort of pre-registration. Our ask would be, as you mentioned, there to be sort of an equitable time where everyone would be able to begin that practice at the same time.
Thank you, very helpful. Todd, if we could, that's on our reg list, so thank you. And maybe I know that we've had some affirmative requests for guidance, so another for you, Executive Director Wells, I would say that this is another request for guidance, so thank you. Okay, any other questions with respect to Section B? With respect to marketing strategies or marketing plans, do we have any questions on that?
So Madam Chair, I have some questions on that, but I didn't know if we were going to do that in responsible gaming or in B.
You want to hold until responsible gaming, Commissioner O'Brien? That's fine too. I think any marketing questions that I would have would be primarily concerning responsible gaming.
Mostly I have some credit card questions, some of the phone number questions. We already talked about the call line. And then I have a marketing kind of partnership question, but I think they all fall in responsible gaming.
Okay. And you know what? We're not so structured. If we have to go return back, that's fine too. Okay. I guess I'll ask this general question. Ms. Loney, I'm presuming that MGM will use third-party affiliates for marketing purposes and promotional purposes?
That's correct, Madam.
Can you tell me, will that MGM be able to retain full control over the content of any third-party affiliates marketing strategies?
Madam Chair, I would ask Sarah Brennan to join for that portion, as the general marketing compliance does fall under her department. The answer is to some degree, yes, but she can speak more specifically on this matter.
Thank you. Hi, Sarah.
Hi. So our group works closely with the partners and affiliates teams within the marketing department to ensure that the same guidance and guidelines we provide our internal teams with respect to good marketing practice, responsible gaming, AGA standards, the appropriate disclaimers and RG helpline information, and then general good ethics and marketing are also communicated to all of our affiliates. We do at times vet the materials that are sent, but we don't review every asset that a third-party affiliate would be marketing. We do, however, closely monitor what they are putting into the market, and there's an affiliate dashboard for them to access the disclaimer information in real time. If we ever discover there's an issue, there's an immediate action on behalf of our affiliate partnership team, reaching out to that third party and saying, you need to pull XYZ down if we see something that we don't approve or that is missing the appropriate disclaimers. So there's a lot of conversation back and forth, a lot of cooperative effort in marketing. Also, our players, when they register for an account, it's all part of the privacy policy in terms of service is an agreement to receive marketing from those partners with which we hold an agreement, like Yahoo, for example.
Any follow-up questions, commissioners, on that?
Yes. And so what if you do, if one of these third-party marketers does something in violation of the rules in one or multiple jurisdictions?
So it depends. It's jurisdictionally specific because some third-party affiliates are required to hold a license in a jurisdiction. So there would be regulatory implications on their licensing status. If they were to do something egregious, say, we would be reevaluating our partnership with them because obviously we wouldn't condone behavior that was in complete, disregard of the regulatory parameters, especially those by which we'd communicated to them.
Do you have a zero tolerance, or is it a 3 strikes you're out, or is it a case by case?
I would say it's a case by case. If there's an honest mistake where an affiliate leaves off 3 words of a disclaimer, obviously we're not going to sever a relationship with them. But let's say they are marketing to underage players, that would be cause for complete reevaluation of the partnership.
Can you give me an example of a jurisdiction where they have to be licensed?
Josh Wiseman, can you chime in for me on specifically where? In New Jersey, there's pretty significant licensing requirements, but I'll let Josh, he's our licensing expert.
Good afternoon, Madam Chair, Commissioners. Nice to see you all again. So we work with several marketing affiliates that are licensed across the U.S. Some of the jurisdictions where they're required to hold a license include New Jersey, Pennsylvania, Indiana, Michigan, Maryland, to name a few. And so all of the licensing requirements are somewhat different, but they all do hold licenses. We make sure that the licenses are in good standing before we work with them in each jurisdiction, and they're thoroughly vetted by various regulators across the US.
And you wouldn't happen to know whether there's reciprocity in the licensing in that regard across jurisdictions?
So the affiliates have to hold their own license, similar to our licensing process in Massachusetts. We have to the affiliates disclose the other jurisdictions where they hold a license. So it can have some influence, but they still have to be vetted and licensed by those regulators independently.
Okay. Thank you.
Other questions for section B? Hearing none, commissioners, I'll take your temperature. Do we feel that they've met expectations for our ability to evaluate this application in accordance with the standards that Attorney Grossman provided?
I feel that BetMGM has met expectations on section B, Madam Chair.
Thank you, Commissioner Skinner. Commissioner Maynard,
I concur.
Commissioner O'Brien, or Commissioner Hill?
I concur as well. This is Commissioner Hill.
No, I agree.
And thank you, and Commissioner Hill, you agreed as well, correct? Somebody, it was a confirmation.
Correct.
Okay, thank you so much. All right, then we'll move on to section C. Questions on section C, Commissioner? Looking at my sheet, sorry.
So I guess my question, so you anticipate, from my understanding, maybe one job actually to be located in the Commonwealth? Is that correct?
Commissioner, let me bring on my head of licensing as well, who is a little closer to that. I believe that is correct, but Josh Weissman.
Yeah, so BetMGM currently has 2 employees who are located within Massachusetts. They're remote employees who support the business across the US. At the time of our license application, we submitted a job description and the other relevant information about a sportsbook manager that would be a BetMGM hire. As we've worked through the process, that position is now in all likelihood going to be employed directly by MGM Resorts, by MGM Springfield, rather than by BetMGM. So as it currently stands, we'll have the 2 remote employees, but the staffing of the sportsbook in MGM Springfield will be handled by MGM Springfield itself for the retail operation.
Okay, so you're amending the application effectively to say 0 added jobs. Is that a fair statement?
Correct, 0 incremental positions, yes.
Okay. Thanks.
Other questions on section C? Commissioner Maynard.
Thank you, Madam Chair. In order to be consistent, I have been, as my fellow commissioners have been asking about the lottery question. I know that MGM in the Cat 1 situation did amend their answer on the record to discuss the MOU that they have in place and their willingness to continue to work with the lottery and the Treasury. I'm assuming, but I wanted to get confirmation that BetMGM is willing to work with them also.
Commissioner Joshua Weissman as well. Would you like to jump in on that one?
Certainly. So the answer would be yes. As it stands right now, BetMGM doesn't have a commercial relationship with the lottery, but we understand that our friends at MGM Springfield supplemented and provided a lot of additional information about the relationship that they have as it pertains to the retail operation. And as has been discussed, we'll be working with them very closely with the retail operation, and we would welcome any involvement in the process there.
I have a follow-up, but maybe are you following up, Commissioner? So I have a follow-up on that. We were fortunate enough to have the treasurer come and appear in front of us and make an appeal. So we've been keeping her appeal in mind. Am I right that in your patron engagement, you would probably be visiting and making arrangements with local establishments to promote your app? Is that something you're imagining? Do you do that? We've heard it presented in different ways from other applicants. And then I'll have a follow-up on the lottery.
Yes, Madam Chair, we would do that with local establishments when it makes sense from a marketing perspective, correct?
Right. So when you're at those local establishments, that's probably where the intersection of your online products most closely are connected with the lottery products, particularly Keno, or that they sell or sell the tickets themselves. So that's again an opportunity, if you'll keep in mind when you're going out to those local establishments, that the products are different and they can, in fact, really complement each other. So there's a true opportunity for some kind of an emerging partnership. And in Massachusetts, we're very proud of the success of the Massachusetts Lottery, and we're also under our gaming statute really required to make sure to protect it. So we're looking for your partnership in that effort. So thank you. Other questions for section C?
I had a follow-up question somewhat in terms of that section, that last one about community engagement. You may or may not have been on earlier in the day when we were segregating your role as vendor for MGM versus standing on your own in this application. And the one part of this that was disappointing to me was you kept referring to MGM's role in terms of their community engagement and their charity support and local support. And I didn't really hear very much on what BetMGM is going to bring to the table in terms of adding to that effort. So if somebody could speak to what BetMGM intends to do to complement what MGM itself is already doing, I would appreciate it.
Sure. And Sarah, is this one that you would want to take, or would you want marketing to speak to this, or Anna?
I think Anna is most likely the best person on our team to weigh in on this. And as she referenced in her presentation about our continued investment, not only within our organization, but in the communities within we operate, which is something that, would obviously have more impact once we were live in Massachusetts and could implement a strategy. But Anna is still on the line and can pick this up as well.
Yeah, can everybody hear me this time?
We can, Anna, yes.
Okay, great. Yeah, so the way that our giving works at BetMGM is it's a little bit different because we are a joint venture. So all of our giving actually rolls through our ERGs. So however the ERGs have positioned their mission and then the goals that are associated with those missions, we have giving mechanisms through that. So, we do have an allotted amount of money for the 7 ERGs to have community involvement, whether that's volunteer work, whether that's just giving, whether that's sponsoring events, but it does need to be run through the ERGs. And so, like I mentioned before, the Tom Joyner Foundation is one of those examples. We went to Out and Equal this year, which was another one. Afrotech was another one that we did this year. So we have different mechanisms for being involved in the community, but they do run through the ERGs.
And do you have any goals in terms of dollar amounts or percentages based on your market share, anything like that? Or is it just?
We don't at this point. We just have a budget that's given to the ERGs that's split up equally for them to utilize.
Okay, so everybody's getting equal. Okay.
Yeah.
Mm-hmm.
Thanks.
I think, Anna, my question, and I'm actually going to also defer to Commissioner Skinner. I wanted to be clear about goals for diversity spend and goals for workforce and hire, if to the extent that you have them, and otherwise your plans for setting them and meeting them, exceeding them. Thank you.
Exceeding, always pushing to exceed.
Yeah.
Yeah, so as I mentioned, we have our commitment to have those goals set by early Q1 of 2023. We don't have them currently. I have made my suggestion, and I have met with our my partner that is in procurement, Richard Kim, and he is now in the process of running by our agreed goals by our finance. And then once we get sign off, then we will start to implement that, like I said, department by department.
And that's for spend, correct, Anna?
Yes.
And 2023 is actually in.
I know.
So
right
are
around
you
the corner.
What are you thinking in terms of 2023?
Yeah, so I know that he actually has his meeting this week. My hope is that we have something that is agreed upon by, I'm gonna just say January, by the end of January. I'd like it to be starting to roll out in February.
And that's on spend. Commissioner Skinner, this is really one area that you pressed on. Do you have other questions?
I do. I was going to hold them until we got to section D, but I'm happy.
But here we are.
It's not a problem. It's relevant.
I'm sorry.
Yeah, no worries. So I believe, Anna, you gave the presentation on section D. You did highlight one positive step in the direction of identifying diversity goals, and that is your relationship with your supplier diversity vendor, Supplier IO. Can you talk a little bit about what it is that entity offers and how you capitalize on that to develop those goals?
Yes, so it is a diversity sourcing platform, and they have a very large, I'm talking about, we have two different vendors that we brought into play this year. So that one is for recruitment. Supplier IO is for our diversity supplier. It's a platform, and they also have a very large database that they have made available to us for different vendors that meet diversity requirements, whether that is minority-owned, women-owned, or veteran-owned, LGBTQ-owned, or small businesses. So they actually have taken. We've been keeping track. We just needed somebody to help us manage it. So they've taken all of our list of our vendors, and they are currently going through them right now to verify whether or not they qualify as a diverse vendor, depending on the qualifications and the state that they're in, and whether they have the whether they qualify. So once we have that number back, then we'll kind of have our baseline to where we start from. And then they will continually keep track, and they'll be able to, once we roll out our goals to the different departments, they will be able to supply us with a list of diverse vendors for us to put in the bidding process to suggest to our departments as part of reaching their goals.
So if I'm hearing you correctly, thank you, Anna. You don't currently have a mechanism to identify your current diverse vendors, and that's where Supplier IO comes in?
We did not until this year. And so I created a form. So this year, or maybe at the beginning of, I'm trying to remember when I rolled that out. It actually might have been the beginning of 2021. I updated our new vendor form. So anything before me, we did not have. So we had to retroactively, like, that's kind of the bigger list that they're going through is we did not keep track until I came on. I updated the vendor supplier form, and so now all new vendors have to fill out a section on diversity supplier requirements. So we have been keeping track since 2021, but they are going through and compiling everything.
And so since you have, I guess, instituted this process whereby you've revised the form and that is now required for vendors to complete, do you have any information on what your current diversity spend is to share?
I do not. I can probably get you something.
That'd be great. Thank you.
Sure.
And sorry, go ahead.
Oh, I just said, yep.
Okay. And then lastly, you mentioned that you have an idea of what your goals should be around diversity spend.
Yeah.
Could you share what those ideas are, and just tell us a little bit about what those numbers are based on?
Yep. Go ahead.
I was going to say, we won't hold you to it if you still need to vet it with your other.
Yes. So my recommendation, and like I said, Richard Kim, who has done diversity supplier work at his previous job before coming to BetMGM this year. We've agreed that 2% should be an attainable goal across the company. I would love to shoot for 5, but I want to make sure that we are able to meet that. So my recommendation is 2%, and I will, and that is department by department. It's not just company wide.
2% across all categories. So 2% total.
2% across the categories.
Okay, so 2% in each category.
Yes.
Okay, and what is that 2% based on? What's that recommendation based on?
When we were having these conversations, it was he has come from companies that have done up to 10%, and he said that that normally is not a attainable goal, and then he said 5% is kind of where people stick around. So by going in at 2% to kind of get us in the groove of how this works, and help us meet those goals, that was kind of the recommendation that he had.
Well, looking forward to hearing more information once the process is cleared by your colleague.
Yes, me too.
The percentages don't really mean a whole lot if we don't understand the universe of the number of vendors that BetMGM currently works with. So some additional information is going to be really helpful there in understanding what the process and goals are.
Definitely.
Thank you.
Commissioner Skinner, my apologies. My notes, I actually wrote, don't forget it's in section D. So I did jump ahead. My apologies. With that really fulsome discussion on section D, I do want to make sure I don't forget to close out section C. And so if you have additional questions on section D, hold them, and we'll go back. Anything else on section C? My apologies.
Yeah, that answered my question. I was going to know whether I should dive into D or keep my piece for the moment. I'll do that.
Yeah, I type out my questions and I just put it out of place. My apologies. So I have no further questions on section C. I'm not hearing any further from Commissioner Maynard, Commissioner Hill, Commissioner Skinner. You're all set as well? Okay, so we have, do we feel as though the applicant has met our expectations with respect to the quality of that response? Commissioner Maynard, you're nodding your head?
Yes.
Okay, Commissioner Skinner?
Yes, for me.
Thank you. Commissioner O'Brien?
Yeah, I would have liked some more detail, but I think it satisfies the threshold.
Okay, and Commissioner Hill?
I believe they met expectations.
Excellent. Thank you. Okay, now appropriately move to section D with a good introduction and response. Commissioner Skinner I don't know if you had another question to ask on that or other commissioners' questions. Commissioner Skinner.
No, I'm sorry, Madam Chair. I've exhausted my questions.
Okay.
For now.
Excellent. Yes,
So my questions about diversity, equity, and inclusion have to do with the workforce diversity stats, which I had difficulty really identifying what they were. And some of the ones that I saw were not great in terms of when I was looking at some of the gender and ethnic diversity, but maybe I'm not reading these correctly. So if somebody can speak to what your stats are in your general workforce, and then also with clarity on your upper level management. Looking through the stats, when you got to C-suite and director and manager, I was trying to sort out what your stats were.
Yeah, I know the dashboard can be a little bit difficult. So I apologize if the screenshots were not easy to read. So yeah, currently our breakdown of female, male, and non-binary is 31%, 67%, and 2% respectively. As far as our ethnic and racial breakdowns, we have 8% of our population identifies as Asian, 16% identify as Black, 18% identify as Hispanic or Latino, 3% identify as Pacific Islander, 52% identify as white, and 5% identify as 2 or more races. Within our executive leadership team, with the addition of Rhea, yay, we have gender diversity is 25%, and our racial diversity, we actually just have 1 member of our 9-member team who does not identify as white.
So can you clarify for me what you're talking about? You're talking about your C-suite at this point, or where are we in that order?
Yes, yes.
That's your C-suite.
Okay. Yes.
So 1 of how many?
Of 9.
1 of 9 and 25% female in the C-suite.
Yes. Correct.
Identify as female. I understand.
Right. Sorry, that is actually probably closer to 22%.
22%.
Yeah, two people out of 9.
Anna, did you say one of 9 does not identify as white?
As white, correct, in our C-suite.
1 of 9.
Our executive leadership team.
In the C-suite. And the C-suite is 9. And then I know you may not have this breakdown, Anna, but the Massachusetts Gaming Commission is always interested in it. You went through your numbers overall. But besides the C-suite, do you have any statistics on leadership development with respect to minorities or gender-based?
Your director manager, you had 2 other levels in there.
Yeah.
Director, senior director level, and then manager.
Yeah.
I can get that for you. Director, senior director, and manager level.
Yeah, at 538 in your app, you have a director / senior director level, and then 539, you have a manager level.
Manager.
But I couldn't really decipher the stats.
Okay. And you want the breakdown for gender and then race and ethnicity on those levels? Sure. I'm happy to get that for you.
And then just wondering if we've talked about the gender issue in particular in some of our other licensees that have pretty robust programs in terms of particularly promoting from within. Mm-hmm. And I'm curious if you have anything specific. I know you talked about the one program, and forgive me, I'm forgetting the name of it now.
Yeah, Progressive Women's Leadership Platform.
Yeah, is there, do you have any other programs? Is that the main program that you have?
We actually just launched this year, Take the Lead, which is, it's not gender specific, but it is for anybody in our organization that's a people leader. And that was a 9-month program that dealt with everything from inclusive leadership to well-being to critical conversations. So those kind of core leadership skills. So we did that. This next year, like I said, we'll be having the Empower Mentorship Program. So because, and that is only open to our employee resource group members. So because the women's ERG is part of that, they will have access to that mentorship program as well. So those would probably be the main things that I would point to for now.
Anna, I do want, so O'Brien did mention in the bar packet, which is lengthy, on page 538, because I thought I read it.
That's the one PDF with everything. Yeah, the full
Now,
on.
you can provide guidance on, and then on 539 at the director level and the manager level, and it is across breakout, which it was exceptional that you broke out the ethnic components the way you did. We don't always hear that breakout, so I think that's very, very helpful. Commissioners, I don't know if you have the scrolled version, but Commissioner O'Brien, if you wanted to complete your thoughts, I'm seeing in the under C-suite, we heard those clearly. Under the director position, the dark color we should look at, correct? Female is
I'm going to see if I can also look at my platform while you're
right
while you're looking there.
So it's a little bit broken down in that I don't really know how to interpret it actually.
Well, I had difficulty interpreting the graphs.
Because it's all
that was
male.
my question.
Maybe it's if there's anyone. I feel like I need a remedial graph reading exercise. So count of employed is on the side. Women, for white women, they make up about 30% of the director positions, maybe? Is that how to look at it? And then white male make up, no, that doesn't make sense either, because then you're leaving out that's 100%.
Is that one just a gender breakdown?
Yeah, this is gender breakdown by ethnicity, in the director, senior director positions.
Okay, yeah, so that's because I want to look at the information intersectionally, right? So I don't want to, just think about our people as gender and as ethnicity, but if Black women are having a different experience in getting into leadership roles than white women, then I want to be able to see what that looks like. So I think that's probably why that looks that way. But I'm not sure exactly what you're looking at. So I'm trying to look on my dashboard to see if I can find my own numbers to help explain.
In your but I can't tell what page it is for you. I can only tell you what it is for me, which is a big page.
It's so if you go to D3A, you guys put some charts in response to your answer to D3A.
Okay, D3.
And I appreciate that intersectionality a lot, Anna, and understand that it's evolving. So I understand that. So I just wanted to make sure that you were giving credit for being responsive in the fact that we're just having a little trouble navigating it.
Yeah.
I can offer some support
Thanks, Sarah.
to Anna as well. I'm one of the chairs of the Women at BetMGM ERG, and I'm also the chairwoman of the development committee within the ERG itself. And I think one of the points that we want to stress to you all in our communication about our investment and commitment to DEI is that, Anna joined the team, and prior to Anna, she's revolutionized this for us at BetMGM. We take it extremely seriously. We've had significant investment on behalf of all business functions within BetMGM, representation cross-functionally across the entire company. And as a chair of the development committee and a senior director, a woman in leadership at BetMGM, I have been able to hear authentically the experience of those who identify as women at BetMGM, and then help to mentor and lead them, which I think is a testament to BetMGM's commitment in this space. And as you alluded to, we're evolving and we're growing. We don't want to, necessarily say like, well, our parent company does this and we do that too. We would rather come to you authentically and say, listen, we're in the foundational stages of this, but we are all in on it. This investment that we are committing to making in 2023 is one that is supported by executive leadership at the company. Ria has been with us just a short time, but has been a really solid, influential woman leader for us at BetMGM already in her short time. And I think, again, it's a testament to the business's investment in this space. Anna is amazing. I don't need to tell you that. You can probably tell from her testimony here. And so looking forward to where these programs continue to grow, and proud to be a leader both of the women at BetMGM ERG, but also to the development committee, which is focused on internal growth, Commissioner O'Brien, as you had asked. I myself have been promoted twice at BetMGM just through hard work and commitment. And, the company chose to invest internally. I consistently look across my team and look for opportunity for upward mobility, both from in the compliance team and external departments. We've absorbed individuals from the CS departments who joined the team as entry-level folks, hourly based, who are now salary compliance employees. And so I think it's truly a sense of community and investment at BetMGM. And I can't stress enough, what a great job Anna's done, but that we do ask for you to also realize that this is an evolving and growing commitment for us, to which we take very seriously, but we maybe don't have, picture perfect responses on it today, but we will a year from now for sure.
And I do have the graph up here. So if we're looking at director and senior director.
Okay. So that's on for our purposes. If you have the scroll version, that's 538 commissioners.
So out of 29 white director, senior director identified employees, 9 of those are female, which is 31.03%. Is that kind of what you're looking for? And then I can go.
Very helpful.
Okay.
It's extremely thoughtful. So just thank you.
Sure. All credit is due to our BI team, who actually built me this dashboard so that I can keep track of these things. So next we have our Asian identified employees at this job level, and we have 6 total. So 5 of those are male and 1 is a female at 16.67% of the total population.
And what level are we on?
We're on director and senior director level.
Okay, thank you.
Sure. And then we have those who identify as Hispanic or Latino, and all of those, you can see 100% are male, and that's 3 employees that identify that race and ethnicity. The last category that we have for self-ID is 2 or more races. And we have 50-50 breakdown, 1 male and 1 female at that level. So then
they're not also captured in the other categories, right? If it's 2 or more, is that a separate category? Or are they also potentially captured in
no
Asian category?
Yeah, you only identify, at least in our self-ID, as 2 or more.
Okay.
How many director or senior director role positions do you have? Employees, excuse me.
I'd have to do this math really quickly. So 29, 35, 38, 40, it looks like, at that director, senior director level.
And so what, just in terms of raw numbers, what is the number of people of color you have or minorities in that category?
Let me pull out my calculator really quick. So we have 6, 9, so 11. So 11, which would be 28%.
Thank you.
Identify as non-white.
Thank you.
Mhm. If you're all ready, I can move to the manager level.
Yes, please.
Okay. All right. So our manager level, those who identify as white, we have 54 males and 25 females. So that is 31.65% females. And those who identify as Asian at this level, we have 9 males and 6 identified females, which is 40%. Those who identify as Black or African American, we have 9 males and 3 females, which is 25%. Those who identify as Hispanic or Latino, 5 males, 3 females, which is 37.5%. And those who identify as 2 or more, we have 2 males, 3 females, which is 60%. So if you give me a second, I will do the math again really fast. So 2 is 5, 10, 13.
My pointing out these graphs wasn't necessarily to have to drill down on every number, because we want to be fair and also careful here. But I did want to make sure that Anna and team got credit for providing what was, even though we may have, it didn't have numbers in it, perhaps purposefully, but it did have representation here. So I just think to interrupt Anna, but I just want to make sure you got full credit for providing.
I appreciate that. It's important for sure.
And I think you were
Appreciate the clarification, because like Commissioner O'Brien and the chair, I had difficulty deciphering the charts.
Yeah, of course. So I apologize that it was, it's something that's interactive when I'm in the actual dashboard. I can hover over things, so I apologize if it wasn't clear in the screenshots that I sent.
No apologies needed. And it represents a certain degree of nuance that we don't see with all, always. So thank you very much. Other questions for Anna? I just want to end with from my point of view, I saw, and I reviewed this a bit ago on this piece anyway, but it looked as though you had done some kind of a self-assessment among your colleagues, all your fellow employees, about inclusion. And it looked like a third party did that surveying for you. And it's notable, one, that you did that, and 2, that it came out. And that's actually sounds like that might be your baseline. And
it was, yeah, that was the first thing that I did when I started. Was I engaged Culture Amp, which is an industry leader, as a third-party vendor for surveying, to get a pulse of where we were at to start. They also have a really, really robust self-identification breakdown. So that goes into caregiver, socioeconomic status. So you can really dive in and see what your people are experiencing at different identity levels. And we actually we have adjusted the way that we do that. So now it's not just an annual survey. It's part of a quarterly survey now that we do. So it's not as long. That's just inclusion focused. There is an inclusion survey that we do now in Q3 that is a longer one, but there are now I want to say 9 or 10 of the same questions that we're asking in every survey. So whether that's on benefits or whether that is, work flexibility, the different things that we're surveying on throughout the year, there is an inclusion piece of that. So we can keep a bit better gauge on that throughout the year, not just annually. But then, like I said, it's really important that we act on it as well.
Well, I just wanted to commend you for that. And then I think I want to take a pulse of my fellow commissioners with respect to Section D and Anna and team support. Commissioner Maynard.
I have a clarifying question before I do that. Anna, first of all, thank you so much for walking us through this, and thank you for, as the chair and has pointed out, a robust set of information, though I also needed the clarification.
Sure.
Commissioner Skinner asked in the last section if you would be willing to provide us with the information that you do have, understanding that you don't have it all up to this point. I just wanted to make sure that that was something that you were willing to do.
Yeah.
On supplier diversity specifically.
Yes. Yep. I took a note, and I will, as soon as I am off camera, I will reach out and look to see what our spend has been. This is the problem with it. With the information that we have, like I said, prior to when I started, we weren't tracking. And so I don't know how accurate it's going to be. So I can give you the amount of our vendors who identify as diverse suppliers right now from when I came on in 2021 and we changed up that form. But from 2018 to 2021, we weren't tracking it. And so to me, it's not very accurate for me to report on that because we're not getting the full breadth of, we might be missing a swath of people who actually do identify as diverse suppliers that wouldn't be captured in that information. I'm happy to give you what I have from 2021 on, but it doesn't seem very representative, which is why I didn't supply it.
There's no information included in the application on that today, so anything that you can provide would be really helpful.
Yeah, of course. I'm happy to give you what I've got from 2021. Yep.
That's perfectly understandable. You've stated it on the record why you can't, and I appreciate that. With that said, Madam Chair, I would say that they do meet my expectations, given the caveat that we're going to get this information.
Yeah.
I agree with that same caveat, Madam Chair.
Okay. Commissioner O'Brien.
Same here.
Commissioner Hill.
I agree.
Okay, so we're all set then to, with that additional information to move on to section E.
Thank you, everyone. I'll get that to you as soon as I can.
Thank you. And you don't have to get back to us this moment. It's just fine. Thank you so much. Okay. Section E. Question. This is on responsible gaming, and thank you, Richard.
Thank you,
So
Madam.
Yes, Commissioner
Sorry.
Wright.
I can circle back to sort of the C references that you were making earlier. It goes into the responsible gaming plan. You've gotten a couple spots in your application. You reference the fact that you don't take credit cards as part of your protocols. And I'm just wondering, do you also have mechanisms that would enforce a reg if we had one that said you can't do credit cards or one step removed from that?
I'll take the first part of the question and just clarify that that would only apply in Massachusetts or any other jurisdiction where credit cards are prohibited.
Right.
perfect. Just
So
want to make sure.
statutorily, we can't have credit cards.
Yep.
And, the intent of not getting into credit card debt, there are some jurisdictions that go beyond that, and we may go beyond that saying, and, you also can't do one step removed. So I'm just wondering if you guys have that in other jurisdictions and do you implement it?
Yeah.
So, could you just clarify? I couldn't quite hear or the second part, please.
Or one step removed, the whole
One
concept
step
we've been
removed.
talking about is the one step removed from a
One
direct use.
step removed. I didn't quite hear that term. Yeah. Or yes, secondary. Yeah. Thank you.
And for that part of the question, I'm going to defer to my manager of finance, Kieran Conlon, who can talk a little bit more about the mechanics of how we receive payments. If he's here. Yep.
Yep. Hi, everyone. I've just joined on for this topic, especially. Would you mind repeating the question for me about what exactly about the payments process you'd like to know?
Sure. So statutorily, under 23N, patrons are not going to be able to place a bet using a credit card. And there are some jurisdictions that either statutorily or through interpretation go further, which we are considering doing. That would mean not only can you not use a credit card directly, but you can't use it indirectly. So you can't say load PayPal or link a credit card to PayPal and then pay. Now, PayPal has a corporate policy where they don't allow it, but there have been instances where people have sort of short-circuited that. I'm curious to know what you guys have in terms of safeguards if our reg says no credit cards either directly or indirectly, meaning one step removed is not allowed.
Sure. Yeah. Functionally, we're fully prepared to just not allow anybody to use credit cards on our platform down to the jurisdiction level. Now, I think probably the deeper part of that question you just posed was what's stopping someone from finding a loophole here. And we've actually spent a lot of time over the past year or so with that, struggling with that same question, because we always worry about people committing identity theft, or doing exactly what you said, where they're able to do transactions under the guise of something different. But what I can tell you is, to the extent that we're able to see that person's identity and what they're doing behind, the veil between us and our payment vendors, we utilize it wherever we can. But there are a lot of privacy clauses that these people take advantage of at third-party payment providers, where they're allowed to hide their identity behind them. And that's something that I think is probably an industry-wide issue of people trying to do that.
If I may, commissioners, I may be able to answer your question a bit more pointedly. We work with our payment providers in each jurisdiction to ensure that if there is a regulation that requires one-step removal of credit, as you said, that either those providers can properly implement those controls, and we would check that and make sure of that. And if they could not properly implement those controls, we would not activate them in that jurisdiction. So that's the same process we would use in Massachusetts.
Okay. Great. And I know that we were given the name of at least one jurisdiction that has that, Tennessee being one of them. Do you know of any others that you operate in that function that same way?
I know that Tennessee and Iowa, neither of them allow credit funding, and we strictly comply with both states.
And those would be the only two.
Yeah.
Okay. Thanks. And then we already did the call centers. My other question, and I'm assuming this will be updated, but the numbers that you put in your, it said Massachusetts Responsible Gaming Plan, but it doesn't have the Massachusetts numbers. It's got the national numbers, and we do statutorily have to have Massachusetts DPH approved numbers. So I know MGM's fully aware of this, but I just wanted to flag that in terms of something going forward that I noticed when I was looking through it.
Yeah, no, we will definitely have 327-5050 as the number displayed in Massachusetts. That's typically when we go into a jurisdiction, we'll work with the regulators, understand which number they'd like us to display, and then we'll ensure that our marketing team has that guidance within the marketing plans.
How does it work on your website in terms of the accessibility in Mass? Obviously, is into your website. Do you list all of them? How does that work?
Yeah, so originally what we wanted to do was have a single GameSense website that all of our platforms could tie into. And we quickly realized that given the nuance from jurisdiction to jurisdiction, that wasn't going to be feasible. And the last thing I wanted to do was to have a page with 30 numbers listed that nobody would be able to, get to their number within a timely manner. So what we've done is we create clone websites in each of our jurisdictions. And so all of the responsible gambling logos and links on the Massachusetts website will go to the Massachusetts GameSense page. And within the state resources section, as well as throughout all the other content where referenced, we will use Massachusetts numbers, Massachusetts links, and Massachusetts information.
That IP address base that is going to send you to that.
It'll be based
interface?
on the product that you're logged into. And so in order for you to go into Massachusetts betting, you would have the GameSense links tied in that way.
Got it. Okay, great. Thank you.
Welcome. Also, Commissioner, I just wanted to add, if you go into the state resources section, there is a drop down. So say you are in New Jersey, for example, but you're a Pennsylvania resident. You could always go into that drop down and it will show you Pennsylvania. You click on that and it takes you to the Pennsylvania GameSense website for that information.
That was all I had.
Thank you. Other questions on section E?
Just a comment, Madam Chair. I wanted to thank Mr. Taylor for the robust discussion around GameSense and the work that Massachusetts has done, and appreciated that in your presentation.
You are a leader in responsible gaming for a reason, and I think a lot of it is around the adoption of GameSense within the Commonwealth. So thank you.
Thank you. I know the time is.
I hope Mark is listening. That's all I can say.
Well, okay, we can direct him to the recording if he's not. Oh, there he is. There he is. And I know that you are all close colleagues. So the collaboration with MGM on GameSense has always been noted, and we appreciate it, and now see it extending out to this particular vendor and partner. So I know the time is late, but I really want to go back to something you raised in presentation, Richard, because it caught my eye or ear. The ethic risk management, I feel like it's linking to the medical community in a way that we imagine, but I might have misunderstood. Could you just briefly explain it, please?
Yeah, so Epic Risk Management was founded by a gentleman named Paul Buck, who has publicly talked about his own struggles with gambling addiction. In fact, it led to him going to prison for a number of years. And when he left prison, he wanted to do some good and help people who may be in a similar situation that he went through while he was in the depths of his addiction. And so that team is comprised of those who've experienced gambling addiction, including those who are professional athletes throughout Europe, so professional rugby players and footballers, so our soccer, their football. And what they do is they provide educational seminars and workshops for not only operators, but also sports leagues. They have deals with NCAA groups and organizations. So they'll go in and they'll talk to student athletes about gambling addiction and how athletes are at an elevated risk for developing gambling problems and what they need to be on the lookout for and how they can address some of those issues and those problems. And so we went to them and expressed a desire to work together to develop training that would help empower our employees to more quickly identify and take action when concerning communication and behavior is observed. Similar to the conversation Commissioner Maynard and I had earlier, it's all about the context and understanding the why behind a statement. And so this training will help prepare our employees to have those conversations. There's really not a whole lot of additional healthcare or medical work that we'll be doing with this group as part of this evolution. Not to say that they don't do that with others, but I can't really speak to that.
Very helpful. Thank you.
Thank you.
Okay. Any other questions on the responsible gaming? My notations were that, and I anticipated it, Richard, when I saw your involvement, that it would be outstanding, and I think probably somewhat because of our bias to the GameSense involvement. So thank you. Any other questions? Okay, I'll seek a consensus. Commissioners, do we find that they met expectations with respect to this particular section? Commissioner Maynard?
I do.
Thank you. Commissioner O'Brien?
Same here. Yep.
Okay, Commissioner Skinner?
Yes.
And Commissioner Hill?
Fine. Met expectations.
Okay, great. And so we're all set to move on to section F, and then we'll close out with G. Questions on section F? Starting with geofencing. Any questions? One was answered for me with respect to your dual factor authentication. I think Roman answered that it's an opt-in as opposed to a requirement to have that second. I forget how you referred to it, Roman, but customers can opt in for that second layer of protection, correct?
Yeah, that's correct. It's a player option.
Thank you. With respect to, from my perspective, reading the answers, all of them, I said that they were very fulsome responses and really educational for me with respect to geofencing and KYC. Any particular questions, commissioners? One thing I would note for potential regulation, I'm not sure if this is done in other jurisdictions, but it appears that you keep for 5 years records on either what you refer to as the obvious errors where there's accuracy and in timeline issues with respect to data feeds, as well as there was another area, I guess, on suspicious behavior, 5-year records, and then you do your own auditing. I'm not sure if that's something that we want to kind of piggyback on if regulators do that. I'm turning to my general counsel, if you could just make a note. But what I do see is that you keep those 5-year records and you do your own self-auditing. And to hold, I suspect if there was a big compliance issue, you'd be funneling it right up to your compliance committee if you saw any trending problems. Is that fair?
That's correct.
That's correct.
Any other questions or clarifications you're seeking on section F?
Madam Chair, I have a question relative to section F3.
Okay.
Knowledge, expertise, and reliability has to do with the security of patron data as it relates to the confidential investigation that MGM disclosed.
So that would be something.
I'm not sure if we should hold it until section G or not, but I'm just throwing it out there as an option to discuss now.
And that would be an area where we want to go into a executive session appropriately, Commissioner and Council Grossman?
Yes, I believe that's right.
We would request executive session on that matter.
Certainly. Okay. Anything else on section F? Okay, so if we'll hold on seeking a consensus on that pending executive session, and then turn to section G. Questions?
I do. I have a number of questions about the corporate structure, and in particular, the 50% ownership entity in terms of Entain and Entain's compliance history. I think an article was attached in the report. I think there's been some discussion of a recent pretty substantial fine that I think I'd like to hear addressed.
And am I right that that would also be something that the applicant would want in an executive session, or is it public?
Executive session, please.
Councilor Gross, are you comfortable with that?
I think, Commissioner O'Brien, do you have the page of the application this is on?
Well, the corporate structure is in the beginning of the suitability report. And I think there is a description early on when they talk about themselves in the beginning of B. They talk about sort of the history and the derivation of the company. But there are references within G, for example, page 1135, G3, believe it's H. They talk about like bankruptcies, for example, and they say not applicable to BetMGM. However, MGM and Entain would provide any applicable responses directly with their applications. Entain is really before us as a qualifier with your application, BetMGM. MGM has already gone through its process historically and then most recently this morning. So I have a number of questions about that, about the internal controls that pertain to Entain in particular. So I know the fact of that fine was public. There have been some articles that in general talk about sort of the historical violations that were cited in some of the ML anti-money laundering incidences that were captured in that, but I would like you to drill down on that more for me. And I'm assuming based on the request, Todd, that there's a fair amount of the detail they may share that would be maybe, you know, if not trade secrets, then would put them in a competitive disadvantage if they shared it publicly.
Well, it certainly sounds like at least parts of it would be competitively sensitive. The only part I'm unfamiliar with is how much is public information. And to the extent there are parts that have been publicly reported on, that is not really the proper topic for executive session discussion.
So if I'm happy to give a summary, there was a reference to an article that I think was out there published on August 22nd that talks that on bonus.com that talks about BetMGM's reputation being linked with Entain in Leo Vegas, and Entain obviously being one of the entity qualifiers in this matter. And it talked about a fine that the UK Gambling Commission was levying. I think it's a 17 million pound settlement that had recently been reached. Is that correct?
That sounds accurate, yeah.
Yeah. And it talks about, I believe there were aspects to it. I think it was a 14 and a 3. There were two separate fines really for the total of the 17. And maybe it's better coming from what the company feels stating publicly in terms of summarizing that article in terms of the historical violations in terms of the sanctions. In terms of
so we do have
anti-money laundering.
we do have Entain counsel on the line to help, you know, discuss anything that's Entain specific. What I would say related to that fine specifically is BetMGM does have its own AML compliance, and Sarah Brennan or Rialoni can speak more about that. So that is all in-house. So that is not one of the services that Entain provides, but certainly Entain counsel is on the line to speak specifically about anything Entain related.
Okay. Do they want to give a summary of that now? Oh, sorry, Commissioner.
No, go ahead. I was just going to note, Commissioner O'Brien, that the response that MGM gave to G3G has that same language, not applicable to BetMGM, and that the parent companies will provide information separately. And that's information that I would be looking for relative to administrative or judicial proceedings in which the applicant was found to have violated a statute or regulation governing its operation. So just throwing that out there for Council Grossman to consider as to whether or not that is an appropriate topic to discuss in executive session, if that is the applicant's desire or request.
Commissioner Skinner, can you just, I know the language, but can you remind me of the exact?
G3G.
It's page 1134 if you're in the consolidated application.
And while there is reference to certain actions in the IEB report, none of that was disclosed directly in this application. As far as I can see, I don't know if I'm missing it.
I'm
No, there were
certainly not-
a number of them that were answered that way that sort of referred to Entain like it was filing its own application, which is not exactly the posture that they're in front of for us.
I guess
And Entain doesn't have to provide an application. So
No, they're an entity qualifier, so they do need to be suitable, but they don't need
Yeah.
to fill out a separate application.
that's right. That's exactly right. And of course, the suitability will process is underway.
Right.
So to the extent
And
that
then I had one other area in terms of marketing associations where there was just an entity that it's not mentioned anywhere else, either in the IB report as an entity qualifier, but and to be blunt, I don't know whether I should say this to Attorney Grossman offline or not, because I don't even know if the fact that the association is public or not, but there is a reference. I think it's at page 954. There are certain marketing agreements that are referred, and there's another entity that's in there that is just not referenced anywhere else that I'd like to just understand the association with.
let's let everybody get caught up.
you're looking right in the middle of the page.
Just 1 second, because I switched over to the section by section analysis. So now I've got to get into the bigger document. It's got to load. So
Just while that's being pulled up, I might be able to help with one of the previous statement with the Entain application from a high level, just to understand the process. So with this application.
Mr. Weissman, I'm sorry, I'm having trouble hearing you.
Oh, I'm sorry.
yeah, you know what? You sound a little bit like you're in the aquarium. So before it was not bad, but now it's getting a little bit more bubbly. So.
Is it better now?
It is.
Okay.
That's better, yeah.
I'm not in the aquarium, I can assure you. So just structurally and procedurally, what we did with this application is consistent what we do in other jurisdictions where, because of the ownership of BetMGM, we file our information that we have directly, and then with some of the questions like the one that was referenced, we get Entain or MGM to file their responses as they pertain to those entities directly, just to preserve confidentiality between all of the entities. I just wanted to say that in case it helps clarify it all.
1 minute. Oh, getting closer. 9:54, Commissioner O'Brien?
I believe so, yes. That's what I wrote in my notes.
Yes, that's right.
And if the applicant wants to look at, and then maybe they can alert me as to whether or not I'm say that publicly before we narrow our list of executive session issues.
Getting closer. This is why this is not optimal. 9:59. I'm trying not to overscroll.
You can jump to the page.
Right. Yeah.
There
I
is a
know.
way to type the.
I should, because I'm not manipulating this that well, so that's really good to know. Commissioner O'Brien, you can show me that function.
Yeah.
Okay, so I've got it, 9:54. What paragraph?
I think it's toward the middle of the page. Is that right, Todd? I think you've got it up.
Yeah, it's the,
Do you see it after subsection B, the first word?
it's the bolded information,
bolded.
and right in the middle, I believe.
Oh,
Yeah,
okay. So not
that's
going-
the corporate reference. Yeah, right. That I just don't know if that's something that's for public consumption.
It's a mutual access agreement dated a certain date between two entities.
Right. It's just not a name I'm familiar with, and I don't know if it's for public consumption. I just wanted to ask for the details.
Bolded one, not the
The bolden one.
So
This is on, this is within section 2.1.1 of Article 2?
Correct.
I think we'd like to take that into executive session if we could.
I'm sorry. I'm sorry.
He said they would like to discuss in an executive session.
Okay, great.
Thank
So
you.
we have that matter, and then we have, Todd, what else do we have?
I'm just scrolling back to the other issues. So there were judicial, I'm sorry, hold on a second. I lost the page here when I scrolled up. It's page, okay. So it's, I'm sorry, it's page 1134. I think this is the one Commissioner Skinner was asking about, where the question calls for a description of any administrative or judicial proceedings. That was one of the issues. As a general matter, those tend to be matters of public record. So we need some kind of showing that those are not public record before we move into executive session to talk about those. I'm trying to get back to the other question.
That was Commissioner O'Brien. I think you started out with the first one. That was.
So the first reference was in particular Entain and the UK fine that was recently levied. The details beyond sort of the general discussion we just had. There was also one litigation which, to the extent they can discuss it, it was I want to be careful with the reference that I make. I think in the suitability report, there's a pending litigation matter. I'm assuming it's the fact of it is public, would be the patent infringement case. Whether that bears at all on any technological capacity, I would assume any discussion in that regard would be trade secret and or competitive disadvantage, and so more appropriate for executive session.
That's right. Yeah, and it is an active litigation. So
litigation, right?
So the complaint itself is likely public, right?
Yeah, correct. Public filings are certainly
so
public.
Commissioner,
can share the pleadings with you. But any specifics as to the technology, certainly we would consider to be commercially sensitive.
Right. And my question really is whether or not any adverse ruling in that matter would impact sort of the technological capacity of the applicant.
Right, so I think he's saying any specific questions around it would
right.
be.
No, I'm just trying to be more narrow with the question, not the litigation itself that's publicly out there. That was my sort of the impact question.
I think that would fall under the protections of the executive session, right?
Yeah.
Absolutely, that would be a fair subject to talk about.
So we got that one's clear.
The reference that I just made to 954, and then basically Entain in general, to the extent that they referenced it, if they're saying they would answer separately, if Entain counsel is available, if there's anything in terms of bankruptcies, withdrawals, that sort of thing, I would be interested to get an answer in that regard, to the extent that it is in any way relevant to the suitability that we're looking at, the preliminary suitability we're trying to vet here.
Bankruptcy relating to.
So at 1135, the answer to G3H regarding bankruptcies was very specifically limited to BetMGM, and they refer you to the other respective applications. There is nothing in front of us in that regard for Entain, but I would be interested in this. Maybe something we can discuss publicly with Entain's lawyer on the call. because I would assume those would be public, whether there's in fact been any bankruptcy filings relating to Entain.
Was that your question, Commissioner Skinner? Yours was relating to bankruptcies, is it relating to?
Yes, I'm interested in that, but my question was specific to G3G.
Which is the administrative filings or?
Disciplinary action.
Disciplinary action. Yeah.
Right. And G3J has internal control changes, I think, and does the same sort of language.
So one of, I think, as far as Entain is concerned, Entain is a public company, if I have that right, which would suggest that any bankruptcy filings would be matters of public record. So we'd need to be precise as to what part of that would be sensitive or competitively sensitive.
I don't actually think that one would be. I think given that Entain Council's on the line, that might be something that could just be answered right now, possibly in the negative, I don't know. But I think that would be public information.
What's your precise question, Commissioner O'Brien?
Whether or not Entain, in response to the question of, asked in general of, I think it's G3H, the bankruptcies question, where they specifically tell us to refer directly to MGM and Entain. I'm just looking for an answer, Entain, if any.
Commissioners, if we could have a 5-minute recess to get the relevant folks from Entain on to be able to answer those questions or provide the references for an executive session, that would probably assist us in moving this forward.
Great. We're happy to do that. It's 5:23. Why don't we return at 5:30? Ms. Loney? Is that enough time? At 5:30 return?
I believe that is, Madam Chairman.
Okay, thank you. Okay, I'm not sure if everyone is set, but we can take down the slide. We'll give the applicant time. Miss Loney. There we go. Okay, commissioners. I'm just looking for Commissioner Hill. Box.
I see his box, Madam Chair.
Yeah, Commissioner Hill, if you could just check in. Let's see. Well, we'll proceed.
Commissioners, are you prepared for us to proceed?
No, you don't. Just 1 second. My documents dropped, but I just need to do our sign in. Commissioners, as you know, this is Gaming Commission's public meeting number 414. We're reconvening, and I need to just take a roll call because we're holding this virtually. Commissioner O'Brien.
I am here.
Commissioner Hill. Commissioner Skinner.
I'm here.
Commissioner Maynard.
I'm here.
Okay, we're all set to proceed. I think Commissioner Hill will join us shortly. Okay. So now we'll turn to you, Ms. Loney. We left you with a question that you need to get further information.
Yes, thank you, commissioners. And Madam Chair, I would like to introduce to you Martin Litka. He's the SVP of American Regulatory Affairs and Responsible Gaming for Entain. He will be able to give you an update and brief you on the fine that you had raised earlier.
That would be Commissioner O'Brien raised earlier. Is that right?
I believe that is correct.
Yes. Yep.
Okay. I only make that clarification to make sure that your questions are all satisfied in the end, Commissioner.
Yep. Okay.
Thank you. It looks dark there.
Madam Chair, Commissioners, very good afternoon. I can hear myself.
It's okay, we can hear you just fine. Thank you.
Okay. Well, it's really nice to meet you. Thanks for taking the time. And my colleagues from BetMGM have summoned me, if you will, to address the issue related to the UK matter that you have raised with them. So the first point I would like to make in that regard is that it's not a fine. It might have been reported as such, in the press, but that is not correct. It's a regulatory settlement that Entain has reached with the UK Gambling Commission. The other key point to make in that regard is that the regulatory settlement relates to issues that occurred between June 2019 and June 2020. So of course, we admit that at that period, we did not handle those matters to the full liking of the UK Gambling Commission, but we have further improved, enhanced, and bettered all Entain's governance processes with particular focus on responsible gambling and anti-money laundering since. Secondly, I believe that it's also a matter of public record that originally the counts of indictment, if you will, that the UKGC raised in relation to the time period we're talking about, that there have been over 70 of them, so many, many more. And at the end of the day, we were found guilty, if you will, only of 6 of those. In other words, Entain managed to successfully walk the UK regulator through all those issues and convince them that in a shattering majority of them, there was no case to answer. To be fair, if you are asking yourself the question whether we should have contested the remaining ones further, the answer to that question is yes, we could have. In theory, we could have taken the UK regulator to court, but we decided not to do it, I suppose, largely for obvious reasons. The key one being that we've improved all of our processes since, and secondly, we've always taken a positive and cooperative approach to all our regulators. So we felt that a regulatory settlement was the most efficient and the most friendly way of settling that matter. So hopefully that is an answer to the question that you have raised before I had a chance to join the session.
So thank you for that. This is Commissioner O'Brien, Mr. Liggett. My question is to the extent that you can publicly describe what exactly the infractions were that resulted in the settlement, and then what it is exactly that you guys did in terms of increasing internal control, particularly with the AML, and to the extent that you can give some of that publicly, and if there's part you feel you need to do privately in executive session, I'd ask you to give as much as you can publicly and then flag for us when you hit the point where you feel you would need to go in another setting if you need to.
Sure. So let me start by talking about the improvements and enhancements we have made to our both AML and responsible gambling systems. We've materially increased the size of the team that look after all these issues. So that's the first point. Secondly, and these days we have about 600 people across the governance team. So that's the legal team, anti-money laundering team, the compliance team, the responsible gambling teams, and my own function, i.e. regulatory affairs. So we've brought many, many more people that allows us to monitor all the applicable regulatory and legal developments in this space to an even more granular extent. We've stepped up our internal trainings. We brought a third party to review all our governance processes, and we presented the results of that review at our Nevada licensing renewal hearing, and they were found satisfactory. On the responsible gambling side of things, Entain launched a brand new responsible gambling program, which is called Advanced Responsibility and Care, that revolves around two key pillars. The first key pillar being leveraging of technology, and effectively it's technology that in the past has been used for bonusing. So we've started using that technology to detect patterns of negative gaming behavior so that we can provide our customers with as personalized care as possible. And in parallel to that, because there's of course a strong human element to all this, besides materially increasing the number of staff that looks after all these matters, we've also trained a team that is dedicated to responsible gambling matters. Originally, that team used to be part of the wider customer service function, but we've separated them out, and these folks only deal with problem and responsible gambling matters these days. So in other words, it's not as though you, as a customer, you'd have the same person offering you the latest bonus on the one hand, and on the other hand, they would be talking to you about the gambling issue that you may have. This all has been separated. So that long story short, we've made changes to personnel. We have enhanced our training. We've introduced new forms of technology to address the shortcomings that the UKGC, the UK regulator, identified for the past period that I've been alluding to.
And can you give any factual description of the 7 areas that form the basis of the settlement?
Then we'd have to move to the
Go into executive session.
I'm afraid.
Okay. And then again, and if you can't answer this out in the setting, let me know too also. But I noted that Adam Greenblatt, who is the CEO of BetMGM, at one time was with Entain. And was his employment in any way connected to the events at issue in the settlement that we're talking about?
It is correct that Adam Greenblatt was employed by Ladbrokes, and Entain at that point, GVC, acquired the Ladbrokes Gala business back in late 2017, early 2018. To my knowledge, Adam Greenblatt would not have been involved in any of those issues that resulted in the regulatory settlement that we have just discussed.
Okay. And then can you state whether or not Entain has had any bankruptcies?
Now, to my knowledge, Entain has never had any bankruptcies. Entain is, as I'm sure my colleagues would have pointed out, is a London listed public company these days, amongst 40 or 50 biggest companies. We've just successfully, that's been announced to the markets in the last few weeks, negotiate refinancing of our existing loans. So needless to say, had we ever gone bankrupt, we wouldn't have been able to do any of these things. So that's a long-winded way of saying no.
Saying no.
Commissioner, if I might go back one question just to add on that, as Rich Taylor presented fairly extensively earlier in his presentation, we have a very separate responsible gaming operation. So none of the responsible gaming operations are conducted by Entain personnel. They're all in-house. You've seen the growth, the numbers, the analysts that we keep adding to the responsible gaming team. So that's very separate and apart from Entain and what occurred in the past. In addition to AML, we have our own AML policy that governs BetMGM's AML processes. We have an AML director of AML. We have a very large AML and risk team. So all of those processes are also handled in-house by BetMGM, not Entain function.
Great, thank you.
You're welcome.
So other than wanting a little more detail on the 7 episodes that are the basis of the settlement agreement, I think that answers the questions that I had relative to Entain. I don't know if any of my fellow commissioners had any questions.
Commissioners, so we would not need to go to executive session on that point, Commissioner O'Brien.
Only on so much of it, it gives a description of the 7 incidents that form the basis of the settlement.
Right, for that case we will, okay?
Correct.
Commissioner Skinner, any further questions for you? This gentleman, can you tell me what time it is for you right now?
I'm on the East Coast, so I'm good.
Okay. It's just, it looks even darker than it looks here right now, so I wondered if we had pulled you out of bed. Okay, good. I'm feeling less guilty.
Chair, I don't have any questions for Ms. Silica.
Okay, anyone else have any other questions for? Okay, where are we in terms of outstanding questions, Commissioner and Councilor Grossman?
So let's see. I take it, Commissioner O'Brien, have we answered the bankruptcy question satisfactorily? Okay.
Yes.
Well, there'll be, but the follow-up you want.
Well, no, that was a separate
Well, no,
issue.
the follow-up, that's a separate issue. That's the compliance in terms of a past reported fine.
Okay.
And I have the patent infringement case impact question.
Yeah.
And then the just of in any more detail, the most recent Maryland incident, and then the reference to page 945 with the entity that I had not been familiar with.
Right.
My point.
945, and I think we decided that's all good. And then Commissioner Skinner?
My questions pertain to the disciplinary action directed toward BetMGM. I was also interested in getting an understanding of.
Is that just the Maryland one, Commissioner Skinner, or?
No, in addition to the Maryland one, anything that is responsive to the request in G3G. And I don't know if that warrants an executive session, but hoping to get a little bit more detail on those incidents. And again, they're detailed, or they're not detailed. They're mentioned in the IEB report, but I would be interested in getting some a little bit more of a summary of the facts surrounding each of those incidents. But then also I wanted to understand, wanted to gain some additional information relative to the confidential investigation that BetMGM disclosed on Friday.
Yeah, so that one we know is clearly in the realm of a commercially sensitive. I mentioned the last one. Councilor Grossman, do we need to go through the individual items that she alluded to know whether they are appropriate for executive session? Unfortunately, we're really precise here. So bear with us, Ms. Loney and team.
Yeah, so I think the answer to that question, Madam Chair, so we're talking about, I think we're on page 1134, G3G, in reference to any administrative or judicial proceedings. I think we would need to identify which ones we're talking about and determine that they're not matters of public record to begin with.
That's right. So we have to do that in a way that is comfortable for all parties, right? Perhaps Councilor Grossman, you can assist here rather than having even Commissioner Skinner struggle through. Or?
Yeah, so let me open up the suitability report.
Councilor Grossman, there's been multiple references to page numbers, and I'm not on the same page as any of you. I don't have the single file. Yeah. So where can I find that, please?
You know what? It isn't fair for us to use a single file because each of us are looking at different sets of documents. They're all the same documents, but they're put in different order. So to be fair to Commissioner Skinner, she's looking at section by section, and some are looking at the page. So Commissioner Skinner, the section that you should be looking at, Councilor Grossman, is.
So that one, Commissioner Skinner, was G3G, as you identified. It just happens to be on
Yeah.
specific page of the consolidated document. I don't have in front of me the broken down page number, but you're on the right.
G, I think it's 01, the administrative or judicial proceedings. And it says,
Right.
please refer to the application of MGM LLC for responses related to MGM Resorts International. So, and this of course is all public, it's part of the application. So it does says, interestingly enough, says MGM. Let's go. Commissioner Skinner, are you seeing the same thing I'm seeing? Let's go to response to question. On the administrative or judicial proceeding during the last 10 years in which the applicant or any entity that owns 5% or greater share was found to have violated a statute or regulation governing its operation. Is that the one that you're asking about, Commissioner Skinner?
It is. I was just trying to get back to it. I have too many windows open.
Yeah, so that's G3G. G3
Yeah.
not applicable to, the response is not applicable to BetMGM. BetMGM's parent companies, MGM and Untamed, will provide any applicable responses directly with their applications, but of course, Untamed doesn't have to have an application, but they are qualified. So,
Chair, just to clarify, Entain has, as an entity qualifier, they have submitted a BED form, but part of our review, the IEB's review, included the applicant level entities only, but they have submitted. And, I think that's part of the materials that licensing has reviewed.
yeah, so for Entain, of course, it doesn't have the application, but they have cooperated with respect to all the expectations of the qualifier that's underway. That's like, so,
So the, and just looking at the self-disclosed compliance history, I mean, we can go through that list, but this might take a while just to kind of cue this up for everyone. If
what
that's
section
what we want.
is that?
Yeah,
So this is on page 8 of the IEB report.
Okay.
It goes from page 8 to page 11. We can go through each of them, but again, this will take a while. So if we want to do that, we can jump in.
I don't think we necessarily have to go through all of them. So you're saying they start on page 8 and go through. Is that what you said, Todd?
Yes. So
Yeah.
that goes through the compliance issues and then the litigation.
Yep, and then the litigation as well. Let's stop the phones. Commissioner Skinner, did you intend to ask questions on each of those items?
I would just like more of the sort of a summary of exactly what is referenced there. And essentially, I'm looking for a response to the question in the application. So, I mean, we don't have to review those at this point during the public meeting, but if we could, have a written response to those so that we can add it to the record, I'm happy to do that.
We'd be happy to provide an additional response or as much as possible, take these in executive session and answer any additional questions that the commission might have beyond what is publicly disclosed on each of these fines.
So let's just be clear. So what you're saying, Commissioner Skinner, is that it says that
I'm looking for a response from BetMGM to G3G.
Right, so they did put in a response and they said not applicable to BetMGM, so they might have misunderstood what the question was. If you think the response is what's set forth in the, that they self-disclosed to IEB. Because it says in which the applicant or any entity that owns 5% or greater share. See.
So then I'll ask BetMGM, is the answer that you provided in your application in response to G3G accurate?
So I would say, Commissioner, that we provided the fines that BetMGM has received, and Entain provided theirs separately as part of their documents and filings to the commission.
That MGM provided that information where? Is that in the applications that IEB has?
Correct. Josh, would you like to provide the exact attachment, or if we know a page number? What I'm looking at is.
That won't help me because I don't have access to those applications.
So just to be clear, I'm looking at the response section G3G, and your response is essentially not applicable to BetMGM, and Commissioner Skinner is wondering, is that accurate? And if not, how can we solve it?
So I think I can help with this. So we provided information about all regulatory fines and proceedings in section E3F. And then it's also worth noting that we received a deficiency notice relatively recently from MGC.
I'm sorry, I'm having a really hard time hearing.
Sorry.
Yeah, we're not hearing you. We're not understanding you.
Sorry, can you hear me now?
Can you try again?
Can you hear me now?
We can hear you. It's understanding you that's the challenge. So try a little bit again, please.
So in the application, our fines and our regulatory fines and warnings were provided in I believe it was section E3F. And then I also just wanted to note that we received, after submitting our application, we received a deficiency notice from MGC, which we provided response to. That breaks down all of the proceedings and fines by jurisdiction.
And I don't know, that maybe Director Lilios can add in here, whether that is what's included on page 8 of the report.
Yeah, I think they ended up responding to the deficiency notice, and we summarized the disclosures. You know, those are the ones, Todd, that you're pointing out.
Right.
But they are BetMGM specific, which is what we were charged with reviewing.
Right. The only question is, you know, what components of these are not public information? And I don't know the answer. There are a number of jurisdictions that are included here. It is possible that some are confidential and some are just public. I can't answer that question, which is why I'm loath to even mention where they're from or how many there are or anything like that. So I think that's what we're looking for, a little bit more information about.
So are you looking, would you like us to address the IEB report in chronological order, and we can go through each of these, and the commission can indicate in order if they'd like additional information, and we can provide a summary as possible publicly. And then if it's the commission's pleasure to have additional information on that, we can request the reasoning and go into executive session. Would that be the most efficient way to cover some of these?
Thank you.
That would be ideal. The more we can discuss publicly, the better by far. And we can see if that satisfies.
Okay, so why don't we do it this way? Does everybody have the suitability report in front of them? Okay, so page 8. I'm not going to mention the state unnecessarily, right? Or should I? Can I, or should I not? Todd?
Well, let me ask Ms. Loney and Ms. Brennan, maybe. Do you have the IEB report in front of you?
Yes, we do.
Okay, so we're on page 8. You see what we're looking at. Can you just maybe if
I don't
you
want
could.
them to feel compelled to read every single violation. I want to
Absolutely.
hear if our commissioners are really interested. Not because of the nature of these, it's because really, is it necessary to read each one? Go right ahead, Sarah.
I'm happy to provide some sort of, I don't want to say anonymous, but blanket statements about these in generalities that I think will provide the clarity that Commissioner Skinner is looking for, while also preserving our privacy with respect to these. And if we would like, there are a couple that we should likely discuss in closed session because the conditions of such are not public, but most I can speak to, and again, reference our earlier statements about the expansion of compliance at the business, which will help add some clarity to how the fines occurred or how the violations occurred to begin with. Is that helpful, or would you?
Go right ahead. Whatever you're comfortable with doing. I just want to make sure that no one feels compelled to read every word into the record. And we'll ask if a commissioner has a question about it. I'm looking at the first one and the first bullet. Is there any questions? No? Yes?
Is that directed to commissioners? I just, what I'm asking for is a summary of each of those incidents. There are numerous incidents and the company is a very young one. So I'm concerned about the multiple violations in different jurisdictions. So I'm asking that the applicants speak to those on a very broad level, but I would like some additional detail, more detail than is provided for in the IEB report. And I don't think that's unreasonable.
No, it's not unreasonable, but I'm just looking at what it says and just wondering. Okay, go right ahead, Sarah, if you can help. We're starting with, might as well, should we say the state, Todd? To all public record, the state?
I mean, yeah, why don't we just turn it over to Ms. Loney, Ms. Brennan. If you want to just, if you can say the state, and you can start going through them. And if, you know, very high level, and we can stop you if you're going into too much detail or not enough.
Okay. I'm going to do my best. And everything just closed. Hold on, bear with me 1 second. Okay. Bear with me 1 second because my IEB report just closed. My 7-year-old distracted me on her way to dance class. I apologize. Okay. So point 1, bullet point 1, bullet point 2. This was, well, I guess I'll give some background. Many of the errors that were trading in nature were due to manual errors in the beginning of our operations. Again, at the time, we didn't have a dedicated trading compliance team, and so we're operating under best practice of 3 years ago, which now has dramatically improved, which includes comprehensive, thinking about, this is fine to say publicly, but comprehensive sports activation grids, which indicate to the business what's permitted and what's not across every jurisdiction. And so our trading team uses these compliance references to ensure that they're not offering any markets or events that are prohibited in jurisdictions. And obviously there's quite a bit of jurisdictional specificity with permissible markets and prohibited events. And so you'll find that the root cause of many of these issues on this list, and Commissioner Skinner, I completely understand the concern when you look at a list that is long, but take some comfort in knowing that the processes internally and the internal controls and the compliance documentation have served to mitigate risk and decrease these types of errors from occurring. It's also something that we track internally very closely in terms of trends of errors and violations in order to evaluate whether or not previous remedial actions that were put in place effectively prohibited further instances of these types of violations. So with that sort of stage set, I'll go through these to the best of my ability. There's a couple that I may not be able to address, but can take away and then provide further explanation. The first was a manual error. These were mistakenly offered in the jurisdiction referenced because, to my earlier point, they were allowed in other jurisdictions, but prohibited in that specific state. The trader had failed to effectively reference the appropriate compliance documentations and mistakenly thought that they were permitted. Similarly to bullet point E, it was the same root cause of prohibited events being allowed manually by a trader who did not understand the restriction.
That's an in-house trader, right? Because I think earlier you said
Yes.
that MGM has its own internal trading service. Okay.
Bullet point 2, unfortunately, upon research, I was not able to find further details on, but I can take back and see if I can get more background on for you. But same jurisdiction, and my understanding on a cursory level is that it was the same root cause and manual error in permitting a market that was prohibited to be posted. Bullet point 3, this was a combination of errors in one letter, and I have a couple of reference guides open. Give me 1 second. So this had to do with a license application that was submitted late in that jurisdiction, as well as a self-reported trading issue of a past posting on basketball that we accepted wagers minutes after the market should have been closed. This was also with respect to a responsible gaming issue and a license and an employee who was working in the jurisdiction who did not hold the appropriate occupational license. All of the issues that were addressed in this warning letter or identified in the warning letter were subsequently addressed by BetMGM and remediated internally. That particular fine encompassed 4 separate issues.
And
Madam Chair, may I just make a suggestion? I think it would be a better use of all of our time to have the applicant supplement the response to G3G. I don't know how my fellow commissioners feel about that, but I don't think this is a good use of our time at this hour.
I guess I'm wondering if I could ask them, I'm going to ask IEB and GLI. When you see these entries, because we don't have, to Commissioner Skinner's point, we don't have, she's seeing different, there's quite a list. And in some ways, I feel like that may be the reality of this industry, but I don't have any point of comparison. And I also don't know how much we should expect from an applicant to give on details of this, if this is standard or not standard. So I guess I'm asking Director Lilias and maybe a GLI, if they had a chance to look at this application, is this a reasonable response? Because I'm at Commissioner Skinner's point, she may want more information, but I also want to be fair to the applicant. If they're compiling responses that are standard across the country, then I want to be fair to them too. So I don't know if GLI is still on.
Madam
Yes.
Chair, if I may, I believe we do have an attachment that was submitted as part of our license application that will be helpful for the commission. Now, I'm not looking at the same page numbers, so I may need assistance to determine what I would be looking at that we submitted versus what you
I
have.
feel like I might have seen a long list somewhere, but I'm not sure.
Attachment 30B.
Was that to the
submitted?
That's the BED. That is a grid to the BED. I mean, that is available to you if you would like to see that. But it's part of the BED.
We don't typically make that part of our review.
And in some of that, we've gone into some detail about these fines that is in addition to what is disclosed in the report. So that may be of assistance if that's something that you would like to view, or we could supplement if there's anything else that's not on there that you would like us to supplement. But I believe that that will answer some of the questions being raised right now on these particular fines.
I think that would be helpful because like Commissioner Skinner and I have questions about it, and this is not the typical way the suitability is done. So we are going into new territory. So I think in terms of trying to get a sense of what's out there, what this company has gone through in this area, I think looking at attachment 30B would be helpful for me.
Okay, Commissioner O'Brien, thank you. Commissioner Skinner, I would like to hear from Director Lilios. I'd like to hear from Executive Director Wells, so that when this application was complete and the standard of review, and Councilor Grossman, I want to make sure that, we're not asking the applicants, and I don't know the answer to this question. Are we asking the applicant to do more than what we asked in the application? And so I want to just be fair. Commissioner Skinner, it may be that we both may have expected a different response, but I just don't know if this is meeting, what is typical expectations on this, on these entries. We can get more information. I want to just hear from the experts here. Director Lilios and Director Wells.
I mean, listen, this is like casino gaming. It's a highly regulated field, and you have an operator here who operates in many jurisdictions. So of course you would expect to see violations. It means that regulators are doing their jobs, and this is a relatively new industry. So it's not a surprise to see violations from any operator in this arena. Now, what we look at when we evaluate self-disclosed information is we look at things like whether there are multiple incidents in the same with the same problem that went unaddressed for a lengthy period of time, whether the operator self-identified and self-disclosed the information, whether the fines were timely paid, whether they have implemented remedial actions, including things like audit functions to identify on a forward-looking basis, so the conduct doesn't repeat itself, whether infractions were intentional or inadvertent. So all of that type of assessment is a very fact-specific assessment. We haven't done that for purposes of this review and this preliminary report that's before you. But I can certainly say, and I think it's common sense, that it's not a surprise that an operator that operates in many jurisdictions has violations as part of its history. And Karen, I don't know if you have anything to, any more light to shed on that or anything else helpful?
Look, we can't hear you, Karen.
Hear you.
No.
Nope.
Now you're mute.
I'm not on mute.
Now
you're okay.
All right, okay. So, yeah, I absolutely agree with what Loretta is saying. I think we also have to remember that we have not been sports wagering regulators. We're a new jurisdiction. So that, it will take some time for us to evaluate. If we just, the IEB gets a list, we're not in a position right now to say, that's a massive list. That's out, that's way beyond the norm, because we have not had the opportunity, as Loretta said, to dive into that. That will be part of the suitability investigation that's ongoing, but it's not as if IEB could comment at this point on the breadth and scope of those violations. But she is correct that it is not unexpected for a company that is in operating multiple jurisdictions to have violations by a regulator.
So can I just add on, and then I'll turn back to Commissioner Skinner because this is her primary question. When the IEB saw these, this list of self-disclosed, both the pending litigation and then self-disclosed compliance history, did you, I understand you haven't done any kind of a deep dive on it. One, will that be part of the ultimate suitability review and as, you know, in accordance with our regulation? And then two, if something jumped out at you, like a trend that you saw, would you have reported that in here?
You know, really, we were trying to adhere very close to the regulation, which is to present you with a summary of the self-disclosed history. So, you know, I'm not really in a position to opine, oh, something jumped out at me is, you know, really bad. And like Karen said, we are all learning now. So, you know, I think it's, you know, in terms of repetitiveness, you know, that really is meant to show itself in the history that's presented for you.
And then, so these are the entries are really a summation that IEB did.
That's correct. And yes, part of the full review for durable suitability, we will be looking more closely at these and speaking both to regulators as well as to the operator.
That's helpful to me, Commissioner Skinner. I didn't mean to. I am struggling with this in the way of not having anything for state of comparison. So that was helpful to me, Commissioner Skinner. You were asking for, what were you asking for precisely?
So the idea is not to assess whether the nature or number of these disciplinary actions is standard or normal or to be expected. I am looking for a response to G, 3G, because if I am hearing correctly, I understand that MGM provided that information or provided information in connection with the BEB application, a different answer to a similar question in that application that is different from the answer they gave in the general application here. So I am expecting that question to be answered as other applicants have done. And again, at the very least, there's an inconsistent response between the general application and the BED that MGM has provided. So I'm looking to understand, I'm looking to have that rectified.
So, and again, so we're going back to that language where it said it's not applicable.
That's right.
Right. So,
and I asked this question earlier, and I don't know if I got a response, but is the answer to B 3G in the general application accurate?
I agree, we did not get a precise response to that question, and I had wondered if there was a misinterpretation of that question. Or is it that you put in, it doesn't apply, but now you actually realize you meant to include what is now summarized in this IEB report?
Yes, so
I may be able to assist, or Josh, you can assist, but Josh, correct me if I'm wrong. The question specifically asks about judicial proceedings, and it is not applicable for judicial proceedings. Now, that doesn't mean we haven't had fines assessed as a result of regulatory settlements, but the way we interpreted that question, it's not applicable to BetMGM because there's been no regulatory violations or fines that have come out of judicial proceedings or administrative proceedings. That, I believe, Commissioner Skinner, is what you're asking.
I think maybe administrative proceedings would include your regulator.
Yeah, that's my interpretation would have been that it does. Administrative would be the type of thing that would be, you know,
so
30B to the BD.
And that answer, if you believe that would include settlements, that's not how we read it, but certainly the attachment to 30B would be the answer if we're including regulatory settlements.
Right, and I think there's just a disconnect because of how this was requested out. We, the commissioners, don't get the BED. And so we, the commissioners, are looking for all of the information. And so because of that interpretation, we didn't get attachment 30B, and we probably should have.
And now I'm hearing that there was some confusion as to what administrative is versus judicial
Versus regulatory.
settlement. So that's helpful. So now, if we just assume that that was inadvertent, could you point to us where that question is answered, if it is answered in the materials that are submitted to first the commission and then if necessary second to IEB?
Yeah, so can you hear me okay?
Yep.
Yeah. No?
Yep, you're good.
I can hear you, I just can't understand you well.
I feel so
Sorry,
bad because
You'd have to get a T-shirt that says that at the end of this.
Sorry, I'll do my best. So just to add additional color to this, what Jeremy just outlined is correct. On December 7th, we received a deficiency notice from MGC asking for additional information. And then item 30B, which was just referenced, outlines all of the information. What we've done is we've provided, even if there was no fine assessed, if there was just a regulatory warning, we've included that information. Basically, in response, we've taken as conservative approach as possible, and we've provided response to if it was a warning, a fine, any sort of violation whatsoever. That's has all now been provided to supplement our application.
Ms. Loney, I think we might need a little bit of a translation on that. Where do we go?
So I think what Mr. Weissman is indicating is that we did receive a deficiency notice and that we did provide the responses back, and it's in the exhibit or the attachment 30B. And he's indicating that even if that does include all settlements, all fines, all warning letters, so they all are referenced in 30B. And so we are happy to update the application and reference them in any additional sections, but I don't think there's any, unless you'd like additional information outside of what was provided in 30B, which we're happy to provide for you. But, you know, a review of that would probably be the most beneficial to go through that. We're happy to provide it again.
Can we, how long of a document is that, Loretta?
It's 3 pages.
Could we share that now with the commissioners and take a little bit of a break? Does that make sense? Commissioner Skinner, would you be more comfortable? All right. Does that work? Is that the solve, Commissioner Skinner? I think we got to at least the bottom of why they answered perhaps the way they answered. Does that make sense? I know it's 6:30. Take a 10-minute break, commissioners. I need some feedback, sorry. And then we're gonna still have.
I'm trying to get a sense of how much longer, because
And
I do have commitments in a little bit, so I'm
And
just
we have
trying to
an
see how much longer we're gonna do this, or whether it makes sense to break and finish this first thing in the morning.
We have an executive session to have. as
Right.
well.
Thing I'm wondering, defer to Todd, is can you continue it tomorrow if it's not noticed? Because we have another agenda for tomorrow.
Everything was day to day, isn't it though? Isn't it listed to?
We didn't do it day to day. We'll have to look at the meeting notice for tomorrow to see if this was referenced on there.
It's covered, I believe.
I thought it was the way it was written.
I think so too, and continuing this tomorrow, I think makes sense to me, particularly given that we have to go into detail about the Maryland issue that I understand the applicant has requested to go into executive session for, as well as the confidential investigation.
Moment.
It is not noticed for tomorrow.
Pardon me?
Yeah,
It is
tomorrow
not
is
noticed.
just Caesars and Plainville and PPC. So this is not on for tomorrow, which means we can't do it tomorrow.
What if we decide, what if we don't close out today and we just roll it over first thing in the morning?
That's not good practice. It does expose us, but
Well, that's not what I want to hear as an answer. So there we go. So that's not going to happen. Commissioners, it's 6:30. Can we try to wrap this up in 1/2 hour?
We can try, but I'm not hopeful that that will happen.
I'm not so
mean,
sure
you
that's
know,
a realistic. We can certainly try,
yeah.
but I don't think it's realistic.
Yeah, I agree.
Okay.
Can we take a dinner break and come back?
I have childcare issues when we get past 7. So me not leaving here around 7 creates issues for me, which may require me to leave the meeting.
Not to mention, it is now it's now been more than 8 hours.
I know, Commissioner, I'm quite aware. I'm just trying to make sure that we close things out where we can.
Can we
Or we
not
get
revise the
to more
agenda?
definition. Pardon me?
We cannot revise the agenda? We posted, we could just revise, can we not?
We could amend it, Todd. These are circumstances, is it?
If you think this is an emergency, I think that's what the law talks about, then we could probably amend the agenda. I mean,
Counselor?
I mean, the key is that people be put on notice as to what you'll be talking about tomorrow.
And
there's no clear
Ms. Loney, is
jurisprudence
your
on this.
team available tomorrow morning?
yes, Madam Chair, we are, and we would waive any notice requirements or anything and appear before you in the morning without any problem.
It's not necessarily their
Yeah.
notification, it's the public notification.
We're worried about our regulators. So we want to make sure to do it right. Todd, Crystal brought up a good point. If we were to amend right now, it does have to be under an emergency circumstance because of the 48-hour rule. And given that we are coming upon the holiday season, we won't be meeting until January. It would be helpful to me and our organization to be able to keep this one in continuity and not break from this and then resume, a couple of weeks from now, just so that we're fresh. There's been several questions and that have been addressed. And so, commissioners, I turn to our council if that's valid. I do think that that's probably the fairest, most efficient way for us to accomplish this law, which does have a sense of urgency and emergency to it. And Commissioner Skinner, I don't know how you feel, but I'm afraid I'd have to be completely refreshed in another 2 weeks. I don't know if you feel the same way, but that's why I'm looking for them to continue it in the morning, and then we would continue to Caesars. What do you think, commissioners?
I'm fine with that proposal. I just defer to legal counsel as to whether it's something that fits within the parameters.
I mean, we took a look at this issue a little bit once before, and I believe there is not a great deal of jurisprudence on this specific issue. I think if you do it, there is some risk of exposure that a claim could be made that it was done improperly. But if everyone's willing to assume that risk, then by all means.
Oh, Counselor. I'm going to ask for a 5-minute break, please. Okay, and then we'll come back and we'll make sure that we do this right. Thanks. Thanks, Dave. Okay, we're waiting for just a couple folks. Karen, are you coming on?
Here, sorry, I just don't have my camera on. Hold on one second.
Okay, and then Commissioner Skinner. Commissioner Hill, are you available?
Yep, I'm here.
Great. My preference would be for us to try to continue. Director Lilios wanted to make a point of clarification around the reporting first, and if we could try to finish up, Commissioner O'Brien is amenable to that. I think Director Wells has a big calendar out and is just looking at timing. So, and I do think otherwise, if we run into a real problem, I do believe, Councilor Grossman, if you could just look into how we've amended in the past to see if we, if this would work. But let's see how we do. Director Lilios, why don't you go up there?
Hi, thanks, Chair. So we've been speaking about the 30B supplement, the chart that was provided by the applicant that outlines its regulatory and disciplinary actions. It is a one-page document, and I have reviewed the document. I've also spoken with the lead investigator on this particular case, Joe Duggan, who is on the line now. And it appears that pretty much everything of consequence on that document is in the IEB's report. I think, Rhea, maybe it was you who suggested that there might be more detail in the attachment. I don't know that there is anything that consequential difference in the attachment that's in the report. I think the report is a pretty fair, a pretty robust summary of what was submitted. So with that background, I wanted the commission to have that background. And Joe, I see you're on the line. You've got your
Yes.
finger on the pulse. Maybe you could either confirm or shed any more light on that.
Right, so I received their compliance history, Bet MGM's. It wasn't where it was supposed to be, but it came in this supplement from the business entity disclosure, 30B.
Yep.
And what they sent, I summarized in my report, just about but just as much detail really as was in what they sent.
Okay, great.
But it looks like it's all in there.
And is that detail consistent with practice, or does it seem leaner than what you're used to on these?
Well,
kinds of-
I actually haven't been doing this for that long, this particular piece, but I would expect even doing NGVs, there's always litigation and fines, regulatory fines. There's a lot of, I don't know, I mean, it's probably a couple from each jurisdiction or one from a jurisdiction there.
But in terms of the actual entry, Director Lilios, is it Mr. Duggan, or is it?
Duggan, yes.
Duggan?
Yes, Madam
Yes.
Chair, yeah, Duggan.
I wondered if I should be using your former title, so forgive me.
No. Yeah, no.
Okay.
Joe Duggan is very good. That suffices.
Okay, Mr. Duggan, thank you. So Director Lilios, is that the nature of that summary typical, or?
Chair, I'd rely on what we relied on in our reg, which was that along with this application, the applicant had to attest to the veracity of its submission. So the IEB is going to go back and do a full suitability And the applicant knows that if they are found to have been intentionally or recklessly, misleading in this document that they've submitted, that their license is at stake. And the commission found that to be a compelling paradigm, to move forward with. So I can't really say, is this typical? Is that, we don't have enough of a universe. We haven't been doing this for a long time, but you've got a whole system.
Right.
They've signed under oath that this is true. They didn't submit it at first, and that's not unusual. We have had some, misunderstandings, and we've had to go back. The licensing division went back, and this is the one-page document they submitted.
Okay, can I ask this question then? Because I want to make sure Commissioner Skinner and all of us are comfortable. Are those entries redacted? Or are they part of the public record? Counselor?
I don't think, Todd, I'd have to defer to you. I'm not looking at a redacted document because I'm looking at was filed with licensing. That I know that the licensee the applicant was invited to propose redactions, so I don't know if that occurred.
I know with respect to at least one, sounds like they want. So Commissioner Skinner, we could circulate that one pager. I think Director Lilios wanted to point out it's probably not going to really illuminate things much more. So it would probably only be through conversation that we would really be able to elicit more details. And we would navigate that in the public forum and to the extent appropriate in a private session. So I do think we probably need to be somewhat precise on what you would like to hear more detail on, so that we can assess whether it's appropriate for an executive session.
Madam Chair, I don't know how else to say it. I mean, I've said it a couple times over the last hour. I'm looking for a supplement to the answer, G3G, and I don't fault that MGM for the misunderstanding or the misinterpretation in answering that question. But I am looking for that question to be supplemented. And I believe it was Ms. Loney who referenced a 3 or 4 page document when there was a proposal earlier in the evening to circulate that to be reviewed on a break. So I don't know if there's still a disconnect between what BetMGM thinks they have relative to these disciplinary actions, or what they think they submitted versus what IEB actually has. But I'm not going to back off of my request.
No, I'm not asking you to back up. I'm asking you to clarify. Okay, so Ms. Loney, it sounds as though you said a 3 to 4 page document. Seems as though Ms. Director Lilios thinks it's a 1 page document. Are we talking about the same thing? And perhaps just different pages?
So commissioners, the document that I'm looking at is a Excel sheet that looks like, or a tabled sheet that's been turned into an PDF attachment, and it is labeled attachment 30B, licenses confidential, and it has our state, the license we hold, and any disciplinary action. And this is just a hair over 3 pages, and it does go by each state, so it could be easy to follow along. There is one additional document that does separately, that was provided with our original primary application, which is E3F attachment, and that does have our warning letter history as well. So that is the other one that was referenced. And I apologize earlier, I thought those were contained in this 30B, but that is separate. 30B was supplemented. Commissioners, however you would like us to do this, if it's your preference for us to provide this information prior to the morning, for you to review it in a single document. If you would like to take a look at these documents, if you'd like us to walk through them, it's really whatever your preference is for how we address these.
I think I in fact, I know I stopped, I think it was Sarah or Anna, I'm not really sure. I stopped someone from discussing each of these incidents action by action. And I'm just, in the time that we've taken to sort of flush out this request, and we could have gone through each of the incidents, right, in that amount of time. So I was just trying to make it easier and to have a better use of our time. So I'm fine with accepting that supplement, the supplemented documentation. But I'm also fine with having the discussion in public if that's what is deemed necessary.
And Chair, excuse me, I can confirm that there is a supplemental document that did not come in before the excuse me, before the IEB submitted our report. So we haven't put eyes on that, so it may be something that you'd like to see.
Yeah, that changes things for me.
So, Ms. Loney, you have a document and you have not submitted to us. Is that what I'm hearing? That you would like to submit now as a supplement to your application?
No,
Or-
Madam Chair, we have these documents that I'm referencing are before you, but if it's your pleasure, we would be happy to provide a supplement, provide a little more information if that's your request. We're happy to do that as well.
So I'm very sorry. I am now completely confused because I'm hearing, and I know Director Lilios, you have a little bit of a sore throat. So are you saying that the document that Ms. Loney referenced, you don't have, or you do have?
I do now have it. It did not make it in full into the preliminary report.
I see. So would it have been part of our report?
I haven't reviewed the whole document, but I expect, yes, if it itemizes additional disciplinary actions, yes.
Okay. So you're going to need time to review that. All right. So we have that issue. That would be for Commissioner Skinner. We're going to have.
But I think it's for all of us. I think that information is very different than what we
Right,
believed before the break.
Because now I understand that Director Lilios didn't have something or hadn't. So that's fine. So now we're going to have to definitely roll this over because we need to give IEB some time.
Actually, Chair, we can, but we haven't been considering, supplementals like that. This is just a chart. We could provide you with the chart.
Okay.
So we're already doing a truncated suitability process though. And so the idea that that's not going to be at least getting first eyes on from you guys was really not my understanding of how this is going to go.
I don't know what the document is. Would that be?
I don't either. I mean,
that document typically would be something that you would have considered and Heather would have considered. She just
Can I quickly chime in? I apologize. I don't mean to interrupt, Chair. And I haven't reviewed it, with a fine tooth comb. But the 3-page supplemental document that is in the deficiency folder that shows the deficiency responses that came into licensing. And Attorney Loney might be able to clarify this. It appears to actually reference the same fines that are referenced in the IEB's report. It's a longer list. It has all of the licensing information and with respect to different jurisdictions, some of which there were regulatory actions taken, others there weren't. So that's why it appears to be longer. Now, again, I haven't gone through it with a fine tooth comb, but it does appear that the fines and the regulatory action that are referenced in the IEB's report seem to be consistent with this document. And Attorney Loney may be able to supplement that response.
Thank you. And I can add on that it does give it gives slightly more information on each one of these fines. If you look at the report, it references, it's the same fines that are listed in there with with a little bit more information on the subject matter of the fine.
And if it's the information along the lines of what Ms. Brennan started to walk us through this evening, then I would be interested in seeing that. To the extent that it does not contain that information, I request that you supplement your general application.
So Commissioners, we have a decision point to make here. Commissioner Skinner is asking for a supplement. I think what I'm hearing is that right now in our organization, we have a document that we could review right now, this moment, and Ms. Loney could maybe even read the entries, except for those that are commercially sensitive. And then we could decide to incorporate it by reference into and supplement the application. Or Commissioners, are you satisfied with what we have in front of us, given what we've been told? Commissioner Skinner, I hear you saying you would like it supplemented.
I think it needs to be supplemented.
Commissioner O'Brien, okay. Commissioner Maynard?
I would be happy looking at the document before I make any decisions on how I would move forward past looking at the document. This is definitely a symptom of listing out these questions separate from the jurisdictional forum. And I wish that I could say that I did. Wish I couldn't say I told you so, but I did tell the commission that this was a real possibility when we decided to put similar questions in 2 different places.
Okay, and Commissioner Hill?
Well, I think at this time, Madam Chair, we should get the information that's being requested, take a look at it, and then move forward after we get the information.
Okay, so, and when will we do that, Commissioner Hill? What's your recommendation?
Well, as soon as possible. I would have liked to obviously have had it tonight, but that's not going to be possible, I don't think. So I for one, am trying to understand why we can't recess till tomorrow. I did hear from our general counsel that that's not the preferred way of doing business, but I have no issue doing that unless I can hear something different on why we shouldn't be doing that. What's the downside of it?
Well, the downside is that any action you take at an improperly noticed meeting could be invalidated. That is the downside.
Is it improperly noticed if we amend it tonight, Counselor?
You know, we were looking at some cases. I mean, again, I'll repeat myself. There's not a ton of jurisprudence on this point. Boards have done it before. We're looking at one case now where the AG's office, which oversees the open meeting law, found it to be a violation, where a board continued a meeting.
Right. Before we go down that road, can I ask whether a resolution would be, we go into executive session on the 4 points that are still there. We have them supplement, give it to us. If we were to do this, wrap up, could we take a vote on this and make the vote conditional upon further review by this commission that we're satisfied with the supplement? Could we move forward tonight as properly noticed today and put that as a condition on the vote?
Commissioner Skinner?
I'm sorry, he can't tell that I'm looking at him, but I'm I'm deferring to Council Grossman. Sounds like a reasonable resolution. I just want to make sure that that's an appropriate condition to attach.
Because we could then further review that at a properly noticed meeting and take any sort of action if we needed to, if there was something that was raised in that. But then we could take what is in front of us, get through the executive session, and ideally not have to deal with renoticing for tomorrow.
We are able to get that document to you immediately.
That would be great. And so, but what I think Commissioner O'Brien is saying, we could go into executive session, address the other issues. And if we actually have and maybe once we all get a chance to look at that document, if we accept the fact that that is going to be a supplement, because Commissioner Skinner is quite right. That question wasn't answered.
Correct.
So we need to correct that on the record. So that would be the response. take a look at this evening. Or if we don't have time, make it a condition.
Right.
Counselor?
It seems like a solution to this, so we can plow through the rest of this evening.
Yeah, I mean, that
Before
sounds,
you answer that, can I just raise the issue of precedent, right? I mean, is this, what we're proposing is if we undertake that, then it's game for other applicants to also request to go down that road. So I just want, to note for the record that, if we do proceed in that fashion, it's, where does it end? Where does it end? And what are we giving up in terms of the integrity of the process if we are prepared to issue licenses conditioned upon the provision of some additional, crucial in my mind, information that's very relevant to the issuance of the application itself?
Let's see if we can solve it tonight, Commissioner Skinner. I need to just be really practical. I understand the issue around precedent and where it might end, but honestly, I bet that all of us attach a different amount of weight to the question that you're asking. And so I think let's try to get through. We know we've isolated that issue. We now have a potential fix that Director Lilios is going to pass it around. What I'd like to do is perhaps go back to the issues for the executive session and have Todd read those in and see if we want to even go into executive session. And if we decide to vote to go into executive session, we'll do that. And then we'll talk about, by then that document may have come to us. Is that just one step at a time? And then if we decide, it should be a condition or shouldn't be a condition and can't be a condition, we'll get to that. Does that work?
Certainly, definitely, interested in compromise and moving things along.
Yeah, just I feel like we can get to that to do. And maybe as we're doing that to do, something will come to us or our counselor, our legal staff to give us some further clarity, as well as IAB. Okay, so Todd, want to walk us through the outstanding issues, and thank you everybody for bearing with us on this hour, but we're trying to work. But the one thing I want to message is this is not to compromise. So I am completely aware of Commissioner Skinner's point. So let's just talk about right now what's in front of us for an executive session.
thank you. So we have matters related to confidential investigations. That's one. Number two, there is a collaboration referenced, well, I was going to use a page number, but I believe it's relative to a marketing agreement that we were looking for more information on the particulars. There is the pending litigation relative to a patent infringement matter. That's number three. There are the 7 episodes relative to the regulatory settlement that were described in the Entain matter from, I believe it was June 2019 to June 2020.
Yeah.
Although I just want to confirm those dates, but I think that was right. Then there are the matters you were just discussing with the chart and the judicial and administrative proceedings.
But those can't all be discussed in.
It's actually just the one. It's just
the merit.
Some of what was redacted originally has since been made public, but not all of it. And so it's so much of the Maryland episode that can't be further discussed without violating, I think, competitive disadvantage.
Right.
Okay.
Okay, so I think, let me just double check the list. So those five matters. Yeah, 5 matters. And I believe they all fall under the umbrella of being, and this is where we'll kind of just turn to Ms. Loney and Ms. Brennan perhaps to confirm that the theory is that they're all competitively sensitive to the point that if discussed publicly would place that MGM at a competitive disadvantage.
That's correct.
And they
Great.
do all seem to fall within those parameters.
So with that said, commissioners, if I look for my packet, here with me. This is it. So the commission anticipates that it may meet in executive session in conjunction with its review of the BET MGM LLC application in accordance with GL Chapter 30A, Section 21A, subsection 7, and GL Chapter 23N, Section 6, subsection I, to consider information submitted by the applicant in the course of its application for an operator license that is a trade secret, competitively sensitive or proprietary, and when it disclosed publicly would place the applicant at a competitive disadvantage. Do we have a motion with respect to the matters that were outlined by Councilor Grossman to go into executive session at this hour?
Madam Chair, I move that we go into executive session for the specific reasons delineated by Council Grossman just prior to your summary.
Second.
Thank you. Any discussion? Okay. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. Thank you. Now, you need to have an invitation to the virtual room. And Crystal, who I believe is still here, will make sure, do you have a proper contact who can forward it to the proper appropriate parties? Sarah or Ms. Loney?
Either one of us, and we'll make sure that the correct people receive it.
Okay. Crystal, are you all set with that contact information?
I actually don't think I have Miss Loney's contact information. Who else was
You can
included?
send it to, do you have Sarah's? You can send it to her.
I can send it to Ms. Loney. I have her email.
Okay.
If you can make sure to include Crystal. Okay.
Well, I'll just forward.
So you'll get that, and we're going to the public. If anybody is still with us, we do anticipate returning to this public forum, but we are going to go in executive session at this point. Thanks so much. All set, Dave? Okay. Dave, thank you. I know it's a long day for you. Thank you so much. We are now returning to Massachusetts Gaming Commission public meeting that began at 10 this morning. It is public meeting number 414. We're returning from an executive session, and I need to take a roll call because we're holding this meeting on a virtual platform. Commissioner O'Brien, good evening.
I'm here.
Commissioner Hill.
I'm here.
Commissioner Skinner.
I'm here.
Commissioner Maynard.
I'm here.
All right, so we'll get started. We are returning after the executive session to our agenda. And if I am correct, I believe that we did manage to take our temperature on E, but not F and G, am I right?
Could you repeat that?
I need to take, I'm not sure if I think Commissioner Skinner, that I need some help here from somebody who is taking notes for us, I assume.
You are
That
correct in your assessment, Madam Chair.
it was just G and F and G that we need to assess the response, the quality of the response, that we got through E. Did we get through F?
We did not.
I thought. All right. So now, before, I think it's G that we'll turn to separately. In light of the responses and the information that we received in the executive session and overall the information we received in the application and the presentation, do we feel now do we feel that the application and the applicant meets expectations?
Madam Chair, or F?
F. Section F. If I recall correctly, I noted that I thought it was a very fulsome response in the application. But I think there was something that one commissioner or somebody objected to an F. We did not move on.
Yeah, that perhaps was me relative to the confidential investigation, and I'm satisfied that what we've heard in executive session now, I believe that this section meets expectations.
And perhaps in connection with the litigation too that Commissioner O'Brien raised. So Commissioner O'Brien, thank you, Commissioner Skinner. Thank you, Commissioner O'Brien.
No, after executive session, I'm satisfied.
You find it okay? Does it meet?
I find that F meets expectation, Madam Chair.
Thank you, Commissioner Hill and Commissioner Maynard.
It meets expectations, Madam Chair.
Thank you, and I'm all set. And with respect to section G, we did receive a document that has been submitted to supplement the response that Commissioner Skinner pointed out as perhaps inadvertently, as it turns out, inadequate. But in any case, inadequate. And that document has been submitted to supplement what was also included in the IEB report. Commissioner Skinner, I'll turn to you first on that. Have you had a chance to review it?
I have, and I'm satisfied on each of the items, with the exception of the unlicensed supplier matter, as well as the unauthorized credit card transactions. So wondering if the applicant can just briefly summarize the circumstances, the root cause of the issue, and what you did to mitigate any future violations.
Commissioner, we'd be happy to. We're going to take them in reverse order, if you don't mind, and discuss the credit card one. I would ask Sarah Brennan to join us, and she will give you an overview on that one.
Hi, thank you. And Commissioner Skinner, happy to provide more detail. As referenced earlier in the hearing, we do prohibit credit card use in the jurisdictions which by regulation prohibit the use of credit on our platform. BetMGM's controls were in place. Unfortunately, this was a failure on the part of our vendor, Sightline, who was providing the credit services to us, or rather deposit method services to us, where on their end, with their third-party WorldPay, there was a coding issue which allowed credit transactions to go through because the BIN number was not properly prohibited from making transactions. Now this impacted all operators and it impacted BetMGM. There was 911 credit card transactions amounting to $266,878. As soon as we were notified of this issue, we did an immediate audit of all transactions to ensure that no further credit transactions had taken place. At the point of notification, the issue had already been identified by Sightline and a stop in place. We did subsequent audits to ensure that no other credit transactions had taken place in the coming 6 months and year after the notification of violation. We also revised our internal controls, revised our patron-facing terms of service, and added additional language to our cashier that's patron-facing, which explicitly says credit card use is prohibited in Iowa. Now, you couldn't actually take a credit card anyway and transact on the Iowa website. Your transaction would not go through, but we added that language just so it was out of an abundance of caution and clarity to patrons. I did appear in Iowa to testify on BetMGM's behalf this past September, where Sightline did also testify and accept responsibility for having allowed these transactions.
So the credit cards were used to deposit funds into the wagering accounts.
Yes, ma'am.
I thought you said, okay, sorry. And so were those funds able to be put towards bets?
At that time, yes, they were used for wagering activity.
Okay. And there was a fine associated with the violation, but not anything further required by BetMGM?
No, ma'am, just proof that we had taken it back, implemented remediation measures, worked with Sightline both contractually, but also an evaluation of their internal compliance functions to ensure that they had deployed controls to prevent further recurrence of this issue.
Okay, thank you. When was it? When did you realize? The period of time was from January 5th, 2021 until July 22nd, 2021.
Yes.
Is that something that is report? How did that come to your attention, I guess?
Sightline actually self-reported to the regulator and had notified operators as well. And then we did a self-audit in parallel with the audit they did of all operators' platforms to identify the violation and number of occurrences per platform.
Mm-hmm. So 6 months of activity was allowed during that period of time. It's pretty significant.
Yes, and I'd have to check. I think the wagering activity was actually less than what was for BetMGM's platform. I think it was March to July. I can fact check that for you in my incident report, but the time frame was slightly shorter than what the actual impact across all operators was.
Thank you. And then on the supplier data issue, the unlicensed vendor.
Yes, Commissioner Josh Weissman, our head of licensing, will be discussing that as it is relating to a fine relating to a licensing issue.
Hi. So hopefully my sound is a little bit better. I ditched the headphones. So As many of you would know,
Weissman, I'm gonna say it again. We're still having that issue. Hard time understanding you. But I probably should have given my fellow commissioners the opportunity to ask any questions around the credit card violation issue.
That's okay. The commissioners, I think they would have spoken up, I think. It's
Well, I
okay.
did actually have a follow-up,
Okay,
which was
Commissioner
basically, and maybe
O'Brien.
you said it already, and it's been a long day, so if you did, I apologize. But do you have protocols in place to spot check these things now?
Yes, yes. We do UAT testing prior to deployment of application in a new jurisdiction, but then we do continued compliance testing, both within my team and the cashier team. And because whenever there's a significant issue, you know, we do learn our lesson, right, from violations and regulatory issues. And so this becomes part of our compliance checklist in an ongoing way to ensure that regular audits are done of the cashier, of patron-facing language on the website, and anything you see in this list that's been addressed as an issue becomes part of our regular compliance audit routine.
Okay, thanks.
Terrific.
Are there any other follow-up questions on the credit card? Okay, Commissioner Skinner, and thank you for that. And I'm presuming that there hasn't been there's nothing else is pending on that issue. Or on a similar issue in a different jurisdiction.
No, ma'am.
Thank you. Okay, Commissioner Skinner.
I would turn it back over to Mr. Weissman, assuming we can adjust the sound a little bit so we can understand it.
sorry about that. I'm giving this another try. Can you hear me okay now?
That is much better for me. Yes.
Good. Okay. So BetMGM works with several third-party vendors who provide data. For this issue in particular, when we were going live in one of the jurisdictions, there was an internal communication about the licensing status of one of the vendors. And we inadvertently relied on their services at the time of our launch, even though they had applied to the regulator in question for a license, but they hadn't yet been approved. Subsequently, they were licensed, and they have been licensed in several other jurisdictions. But that was the root of the issue here, was an internal communication. Since that time, our licensing team has grown significantly, and we also have a much more structured process in place that has safeguards baked into it to prevent this from happening again. So there's a set line of communication with relevant parties that need to effectively sign off on the status of the vendors before the flip is switched and they're turned on, so to speak.
Thank you.
Commissioner Skinner's our former chief licensing officer, so that one resonates. There we go. Okay. Commissioner Skinner, are you all set on those two?
I am all set on those two. Thank you.
Okay. Anything else?
Not
with respect to section G.
Not for me, and so I do think with that additional information, that section meets expectations.
I agree, Madam Chair.
Okay, and Commissioner O'Brien, you're videoed off, but perhaps you're hearing. Commissioner Maynard?
Meets expectations.
And Commissioner O'Brien?
Yeah, it meets expectations.
Okay, so we have a consensus there. And thank you for all the everybody's attention on all the matters and the good questions raised, and also the applicants' nimbleness in being responsive and quick to use all of your resources to really help us understand the responses. And very, very helpful. So, commissioners, we have made it to then the next item on the agenda, if we are comfortable, and that is number 9, where BetMGM we could consider making a determination with respect to the licensing question with the guidance of, would you like to proceed based on that, an overall assessment of the application? Okay,
We're here at 8:30, Madam Chair, so we might as well keep plugging along.
I think that makes good sense. Okay, so Todd, now this is where, as we've done our other licensing applications, Todd will go through the factors and the evidentiary standard that we must find in order to make an ultimate determination, which is, does this applicant, would it benefit? I'll let you do all that good work. Thanks, Todd.
Thank you. So we'll focus our attention on section 218.06, subsection 5 of the regulations. You'll recall that the umbrella standard in determining whether to award a license of this sort is whether it would benefit the Commonwealth. And in reaching that conclusion, the regulation sets out a series of factors that we discussed earlier. You'll recall further, though, that within each factor, there are a series of sub-factors. So I'll go through those now, bearing in mind, of course, that the standard by which you have to view these is whether there is substantial evidence in the record, whether from the application itself or testimony presented during this meeting. So the first factor is to look at the applicant's experience and expertise related to sports wagering, including the applicant's background in sports wagering, the applicant's experience and licensure in other jurisdictions with sports wagering, and a description of the applicant's proposed sports wagering operation or description, technical features, and operation of the sports wagering platform. The second one is the economic impact and other benefits to the Commonwealth if the applicant is awarded a license, including employment opportunities within the Commonwealth, the projected revenue from wagering operations and tax revenue to the Commonwealth, and community engagement. There is one other one that does not apply here. The next factor is the applicant's proposed measures related to responsible gaming, including the applicant's responsible gaming policies, the applicant's advertising and promotional plans, and the applicant's history of demonstrated commitment to responsible gaming. The next factor is a description of the applicant's willingness to foster racial, ethnic, and gender diversity, equity, and inclusion, including within the applicant's workforce, through the applicant's supplier spend, and in the applicant's corporate structure. The next factor is the technology that the applicant intends to use in its operation, including geofencing, know your customer measures, and technological expertise and reliability. The next factor is the suitability of the applicant and its qualifiers. And we can, of course, come back to discuss this in a little bit more detail, but the sub-factors are whether the applicant can be or has been determined suitable in accordance with 205 CMR 215. The applicant and all parties in interest to the licensee's integrity, honesty, good character, and reputation. The applicant's financial stability, integrity, and background. The applicant's business practices and business ability to establish and maintain a successful sports wagering operation. The applicant's history of compliance with gaming or sports wagering licensing requirements in other jurisdictions, and whether the applicant is a defendant in litigation involving its business practices. And finally, any other appropriate factor in the Commission's discretion. So that's the standard and the factors that the Commission has to apply here. The other issue that might be helpful to circle back on is the suitability standard. You'll recall that there are two possible options here. One is a durable finding of suitability, which can only be awarded if the applicant has been subjected to an adjudicatory proceeding under section 101 of the regulations, which has not happened in this instance. And the second option is that a preliminary finding of suitability may be awarded. And that is detailed further based primarily upon the certifications made by the applicant and the IEB's report. which you have taken a look at as part of this review. So those are the elements and the factors to be considered. Of course, there are a series of automatic conditions that would attach to any award. But before we get into those, we have customarily taken a look at any additional conditions that the commission would consider attaching to the award of any license. I don't have any specific conditions that were identified, though there were a series of issues that were raised. So, Madam Chair, I'll pause there for purposes of maybe talking about conditions or any other issues relative to the factors I've just discussed.
Commissioners, are there any conditions that we would want to attach should we proceed if we were to go ahead and with the findings, or do you want, I guess I'd like you to be thinking about that and we can then go through the vote. I know that we've done the vote in the past, but there's the standard conditions. Is there anything that's been discussed today in both public and executive sessions, public meeting and executive session to think about for a condition? So with that said, you want to walk through the what we need in order for us to move ahead, what we must find.
I'm sorry, you mean relative to the conditions?
No, not relative to the conditions. I think we would make, we have voted first and then impose conditions second. So.
Well, no, we need to, because some people's votes may depend on conditions, so.
Okay.
The only, I guess, let me backtrack a little on what I said. The only thing I did make a note of was the supplier diversity spend information, which the applicant has agreed to provide. So that is one issue that I did actually note.
That would be consistent. Was it two parts, Commissioner Maynard and Commissioner Skinner, just like we did last time? Or is it just one part?
I was just going to speak to, they actually answered the second part verbally to us at that 2% rate across the categories. So I took that answer to not be conditional. I don't know how Commissioner Skinner feels about it.
Yeah, I would still want to see the total number of vendors in order to put that 2% in context.
That's what I was going to say. The first part, which was that 2021 information forward, to be consistent, I would like to see that information.
That's the vendor list.
Yes.
Okay, and you're satisfied with 2%. And let's see how that evolves.
I'm satisfied that they gave us an answer on the question.
Right.
Yeah.
Right.
Yeah. I understand. Okay. Is there any other condition that we might want to explore? I would like a minute to just check in on something. Bear with me. 1 minute, please. Thank you. We're 2 minutes. Sorry, that was more than a minute. Thank you, Dave. Okay, so if you want, we'll just reconvene and quickly for the roll call. Commissioner O'Brien?
I am still here.
And Commissioner Hill?
I am here.
Thank you, Commissioner Skinner.
I'm here.
And Commissioner Maynard.
I'm here.
Thank you. And we've taken that roll call because we're holding this reconvening of the Massachusetts Gaming Commission public meeting number 414 at this hour, now 9 o'clock. I appreciate everyone's attention and patience. So we now have had Council Grossman go through the factors, and if you could remind, it's A through G with the exception of F. There would need to be a finding that is supported by substantial evidence of each of those factors and sub-factors being met. Is that fair? Do I have a motion with respect to that? Oh, or we want to talk about conditions first?
I think we should talk about conditions first to make sure if anybody has anything else to add. I know we talked about the supplier diversity, the vendor diversity list, and Todd was indulging us. I wanted to know how, okay, so just so you know, my phone just told me to go to sleep. So just so we're all aware. That's how long we've been on. In terms
Mine keeps on
of,
saying drink water and stand. So here we go. Sorry.
11 o'clock, 11 hours at the 9 o'clock hour.
yeah,
Just saying.
this is it. This is it. So, and I don't think I'm the only one feeling this way, but I do want to put this out for discussion, which is putting a condition if this license were to be voted in the affirmative, in addition to the diversity list, that we place a requirement on BetMGM to provide timely and ongoing notice to IEB about any developments in either of the matters, the confidential investigations that were first disclosed on the 16th and that were further discussed in executive session. I feel like for me, anyway, that's given the posture that we're in, that to me would be a condition that I would suggest. And I thank Attorney Grossman for working the language with precision, but that was the language that I feel comfortable with. I throw that out for discussion.
No objection from me. I think that is makes eminent sense.
Agreed.
It's so reasonable, Commissioner O'Brien, that I assumed that it was going to happen anyways.
As you know, I'm a pessimist and I like to bootstrap, so.
Again, so we would have those two conditions that would attach, and then of course the standard conditions that Todd has read into record earlier today, but we should hear them again.
Sure. So that's in, again, section 220.01 of the commission's regulations, and it talks about the automatic conditions that attach to any award of a sports wagering operator license. And the conditions are as follows: that the operator obtain an operation certificate before conducting any sports wagering in the Commonwealth, that the operator comply with all terms and conditions of its license and operation certificate, that the operator comply with General Law Chapter 23N and all rules and regulations of the Commission, that the operator make all required payments to the Commission in a timely manner, which in this instance would be the $1 million fee for a temporary license, which we can talk about momentarily. The next one is that the operator maintain its suitability to hold a sports wagering license. And the final one is that the operator conducts sports wagering in accordance with its approved system of internal controls, consistent with 205 CMR, and in accordance with its approved house rules, in accordance with General Law Chapter 23N, Section 10A, and consistent with 205 CMR. So those are the conditions at play. It's important to recognize, and I apologize, I don't know if we've actually even discussed this, that they would presumptively be awarded the preliminary finding of suitability and not the durable finding. That is a finding that the commission will have to make. If that's the case, that makes them eligible to apply for a temporary license, which is discussed in section 219 of the regulations. And as we've talked about before, Executive Director Wells and I will work with the presumptive licensee as to how to go about doing that, which will come back before the commission at a later date. So that was a lot of words, but that's, I just wanted to put all that out there for you.
So with that said, and the conditions of the two that were advanced by Commissioner O'Brien, as well as the standard ones, and with the reviewing sections A through G with the exception of F, do I have a motion regarding a finding that we have met those with the meeting that the evidentiary burden of substantial evidence? And I did not frame that well. Do I have a motion? Councilor Grossman, you may need to help a little bit.
Absolutely. So,
Commissioner Hill,
Madam
you
Chair,
have it? Yeah.
I'm going to take
Yeah.
a swing at this.
Thank you.
Our former secretary, Commissioner O'Brien, has been helping me be a good secretary here, teaching me how to do a few of these things. So let me take a little try at this.
Okay, great.
And then we can amend if necessary. So just bear with me because I have been working on this. So, Madam Chair, I would move that the commission find that the applicant, Bet MGM LLC, through its application submitted and as discussed here today, and subject to the conditions discussed here today, has established by substantial evidence and met the criteria set forth in 205 CMR 218.065 A through E and G, and further that any award of the Category 3 license to the applicant would be to the benefit of the Commonwealth.
Do I have a second?
Second.
Do we need to amend that to include the conditions? Or those
I can certainly, I can read them if we need clarity. The first condition would be that the licensee provide the vendor diversity list as requested here today. And second, that BetMGM provide timely and ongoing updates concerning any developments connected to the two confidential investigations that were first disclosed to the IEB on 12/16/22 and further discussed in executive session today.
I certainly am all right with that change, Commissioner O'Brien.
Okay, with that amendment,
I second it with that amendment.
thank you very much. Any further discussion, clarification? We have that recorded, okay? Councilor Grossman?
Yes, right on.
Okay. Commissioner O'Brien?
Aye.
Commissioner Hill?
Aye.
Commissioner Skinner?
Aye.
Commissioner Maynard?
Aye.
And I vote yes. Now, Commissioner Hill, with respect to the outstanding subsection F.
Let me take another shot at it, Madam Chair.
Thank you
I
very much.
move that the commission find that the applicant Bet MGM LLC be found to have established by its application filing reviewed by the IEB and the discussion here today by clear and convincing evidence its suitability consistent with 205 CMR 218.065 F, and that any conditions subject to a finding of suitability also reference the obligations outlined in 205 CMR 220.01.
If I could just offer I call it a friendly amendment, though I don't have standing to do that.
I forgot about the adjudicatory piece.
Yeah, it's
correct?
actually not clear and convincing in this case. It's just substantial evidence that they have established their preliminary suitability because there was no adjudicatory proceeding. But otherwise, Commissioner Hill, I think you got it right.
Hey, it's 9:07.
Is the 218, is the subsection reference correct as well? Or was that the full suitability reference?
No, that's actually the reference to just suitability. I'll double check that. I think that's
Yeah,
right.
I just want to double check that.
218.065 F
A
is.
swing
yeah.
and a miss. I tried.
No, not at all. No, that's a double, not a home run. But that's no, that's the factor that talks about suitability. That's not the suitability.
But the
section.
218.07, is that the suitability? Is that the preliminary suitability?
Preliminary suitability is discussed in 215. 0.01B.
So is that
I'm sorry, 2.
0.012 A
Two.
and B?
Just B.
Yes.
So we just need, I think we just amend to make sure we're referencing that as well.
Commissioner Hill, do you want to withdraw your motion and we can start over? Is that the easiest way?
I would withdraw it with no problem.
Okay,
But with the new sections and the new language, unless somebody else has it in front of them,
yeah. We'll need some help.
I'll need some help.
Yeah, exactly.
So I think what we'd like to do is move to find that the applicant Bet MGM LLC has demonstrated by substantial evidence it's that a preliminary finding of suitability may be issued in accordance with 215.012. And accordingly, they are eligible to apply for a temporary license.
I'm sorry, Commissioner Hill, but this is
No, it's not that tough.
all right, but
By substantial evidence, its suitability consistent with 205 CMR 215.01. Is that what I heard?
subsection 2.
Accurate?
215.01 subsection 2, yes.
And we would continue on in the condition subject to a finding of suitability, also referencing the obligations outlined in 205 CMR 220.01. That remains.
Yeah, yes, those conditions attach automatically.
Okay. So I'm just going to read it, not in record. I move that the commission find the applicant that MGML be found to have established by its application filing reviewed by the IEB and the discussion here today by substantial evidence its suitability consistent with 205 CMR 215.012, and that any condition subject to a finding of suitability also reference the obligations outlined in 205 CMR 220.01. Did I forget anything there? Sound good?
That does make them eligible for a temporary license. That doesn't need to be part of the motion necessarily.
Okay, so I'm going to read it all, just like that, if that's all right. Madam Chair, I move that the commission find that the applicant Bet MGM LLC be found to have established by its application filing reviewed by the IEB and the discussion here today by substantial evidence, its suitability consistent with 205 CMR 215.012, and that any condition subject to a finding of suitability also reference the obligations outlined in 205 CMR 220.01.
Second.
Do we need to insert the word preliminary or no? Is that covered?
The site references preliminary suitability, so I think it's covered. And I think everyone is of the same understanding.
But I'm certainly, I can move to insert preliminarily as a friendly amendment
Preliminary, yep. Insert in front of
prior to
suitability.
suitability.
Do you accept that? If I second that friendly amendment, if Commissioner Hill accepts.
I accept that friendly amendment.
Thank you. Thank you, Commissioner O'Brien. All right, any further discussion? All right. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
and Commissioner Maynard.
Aye.
And I vote yes, 5-0. And that concludes this portion of the agenda. Congratulations to Bet MGM.
Madam Chair, Commissioners, staff, thank you very much. It's been a very long day for all of you. We're very appreciative of that. Thank you for the thoughtful discussion. It's very appreciated by Bet MGM. If you need anything from us, you know where to reach us.
Thank you. Commissioners, would you like to say anything other than good night?
I was just you beat me to it, Madam Chair.
Good luck and good night.
Good luck and good night.
Congratulations.
Congratulations. You know, it is a late night, but the business is concluded. So thank you so much. I see Executive Director Wells is leaning in.
Just one quick matter. So tomorrow we have on the agenda finishing up Caesars, the sports book at PPC, and Penn Interactive. We also have Fanatics sort of on the tail end, and they have everybody on call just in case. But they were inquiring whether they should remain on call because they have a bunch of their executives. But I didn't want to. I can't imagine we get to it, but I didn't.
I have to be blunt that I think after the day that we've had, to use Commissioner Skinner's phrase, I don't think we're doing the applicant any favors by putting them on at the end of the day tomorrow, given today's list and tomorrow's list.
And I don't want to do this again tomorrow.
Right. I think we need to be realistic about them. I don't think we'd reach them.
Yeah. So I would say, let's say that we excuse Fanatics, and then we're going to see them now. In terms of tomorrow, we will be starting with Caesars. Commissioners, we will then be moving into a Cat 1 for EPC. And is it then it's realistic then that we can at least begin with PSI?
Have we been given the supplemental that they were going to be providing? Because we had asked them to supplement.
PPC?
No, Caesars, similar to the list that was
Caesars,
supplemented.
I don't know. I don't know if we've received from IEB the piece that's missing.
Because that's what we're waiting for.
Yeah, Kara did forward you this much earlier in the day, their supplement on the discipline, but she has not forwarded the BED. They hadn't submitted the BED, and she's been on all day. Kara has. She may be on now, so let's see. You have one piece that you're waiting for, but you don't have the other piece. Oh, she said they've submitted. Okay, so the question is, I don't think you were preparing to review it, but if you want to, you can. What we were prepared to do was to have the licensing division report on whether it is substantially complete. Remember, this was an entity qualifier. The IEB in this process does not do a review of the entity qualifier applications.
But it was also them, it was akin to today where they did not give a fulsome list.
We have that.
We have that.
We have that.
That was said
Okay.
earlier today, but the piece that Loretta is now addressing is the piece where there was just, we inadvertently left something out and they needed to respond. They did respond. And I guess my question is,
Yeah, but have you been able to do what you need to, Ivy?
does IB done so that tomorrow morning when we start, we would be able to have a checklist?
Yes, the licensing, Kara has told me that she will be prepared to do the preliminary review of the application for administrative completeness. And she'll be able to report on that. So yeah, you'll be ready for Caesars.
Okay, thank you. This is a process for tomorrow. We'll start with Caesars and then move to PPC's Cat 1 application. It's a resumption. Is that the right word? We're resuming, the review of their application. We were last in an executive session with them, and we will resume that review with an update from them. Everybody received that update from, okay. And then we would go into the Cat 3. Commissioners, one of us is not, does not have a 9 a.m. matter because of a recusal. I am asking Councilor Grossman if we could, Commissioner update, if we could roll that matter over to another date given the late hour. I will be needing every second I can to get organized tomorrow to resume at 10.
I think that's eminently reasonable. If there's any way to squeeze it in this week, that would be ideal. I know that that's a challenge, but that would be.
We have Thursday, the 22nd. Could you do whatever you need to mark it up for that at the conclusion of that public meeting or before? Crystal, is that even, I know that there's a change in some commissioners' plans, so is that even a fair thing to? I really,
I'm actually wondering if we can finish this, maybe you guys finish this offline.
Yeah.
Well, honestly,
I
just
have to
looking because if I have to be
meeting
here at
and
9, Commissioner O'Brien, I just am changing, I'm going to be in the office to chair the meetings on these matters, so.
I'm gonna leave the meeting early before you guys conclude. I'm recused from the other matter, so I will see everyone at 10 o'clock tomorrow morning.
Okay, see you at 10.
Thanks, everybody.
We should adjourn this meeting first, actually.
Well, you can adjourn without me.
I'm going to adjourn without her. She's just, she's fine.
Okay.
Thursday already starts at 9:30 and looks pretty lengthy, so I don't think that putting something after that has proven a few times that we run over too late, so I wouldn't think we could do it Thursday.
And what about the 9 o'clock hour on that one?
I mean, the meeting starts at 9:30.
At what time?
9:30. It was already set early because of commissioner schedules, yeah.
Pulling up my Wednesday schedule.
I was gonna say we can potentially do it Wednesday, but I think that's one commissioner unavailable.
No, I don't think we have.
Oh, no, two commissioners unavailable at least.
No.
But see, this is where I struggle now that Ruby's managing the schedules. I can't do anything. I can't
That's
see.
okay. That's okay, Crystal. Commissioners, I'm waving the white flag for tomorrow morning because I am going to be commuting in here. And I need the time to prepare. So Todd, we'll have to figure out if we need to know seriously what the timing on this has to be. If it could be, I know the week after Christmas, I don't think you're available that week, but.
We could schedule for that day. We have one of our other lawyers handling it, and you can probably try.
I don't know if the commissioners are available then. Is there a time? What is the timing on this matter?
It's There's no set time. It's just a matter of getting it done.
Madam Chair, if it helps, I'm available the week after Christmas.
Then that might, maybe we could squeeze it in then and have another attorney cover it. Commissioner Maynard, you get back that Thursday or Friday, and Commissioner Hill, I'm not sure what your week looks like. I'm
Kind of up in the air, waiting to see what we need to do and not do
yeah,
before.
I guess well, you know what? Let's just, it's not going to be tomorrow. We'll work on it a different date going forward, but it will not be on for tomorrow. That was a commissioner update. It was a matter unrelated to the agenda, a matter for an adjudicatory hearing that we must deal with, unrelated to today's agenda. So thank you, commissioners. With that, take that off for 9. Thank you for all your good work. Thank you to the entire team who's hung in here. Thank you to the applicant. Appreciate everyone. Do I have a motion to adjourn?
Move to adjourn.
Second.
Don't all jump. All right. Thank you, commissioners. Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. That's 4-0. Commissioner O'Brien left a little early. Thanks.